I am on behalf of the respondent number 1, Union of India,
Yes.
along with Mr. Arvind Sen, senior advocate. He instructed me that to take adjournment. So, my lord,
Correction.
lordship, last occasion we could not appear because I was sick, my lord.
Where are you? Who is this?
Hey, Monica.
Same
My
order
lord,
as
my
yesterday.
lord, my lord. Different to now. একটা কি এক নম্বরটা কি নাম এক নম্বরটা এক নম্বরটা একটু আমাকে
Petitioner has sought
একই লিখবো নাকি আমি একে
correction/modification of the order passed on 22nd December 2023 on the ground that the application filed by the petitioner under section 3G within bracket 5 of the Act of 1956 ought to be considered by the learned arbitrator and not the sixth respondent as recorded in the order. Paragraph, by consent of the parties, comma, the order passed on 22nd December 2023 is corrected/modified to the extent that the sixth respondent shall
আমি item number 2 লিখেছি
refer the matter to the refer the application filed by the petitioner under section 3G5 of the Act of 1956 to the learned arbitrator who shall deal with it upon service of notice upon all concerned upon granting a reasonable opportunity of hearing to all concerned including the petitioner, comma, in accordance with law. Paragraph, the remaining portion of the order shall remain unaltered. Urgent certified website copy. Yes, next.
Deeply aware, my lord.
1 2 3
Next is also same.
My lord, 1, 2, 3 are same.
1, 2, 3 are same. Very
In
good.
the matter, item number 2, I am appearing on behalf of the
Give
respondent
your name.
number.
Deeply aware, my lord.
1, 2, and 3 same order.
Yes,
It's 6. Respondent number 6 in all the matters?
yes, my lord.
Very
All the matter.
1, 2, 3 same order. Yes. Where is Mr. Dev? Did not come.
My lord's order was to my lord.
Complete compliance.
Yes.
Part compliance has been done.
Part compliance means, my lord, only valuation and etc. has been, and they have also issued a notice asking us to appear before hearing on them on my lord, perhaps
My
on
lord, in
22nd.
In this matter, my lord, 25th is the date to pay the amount, my lord. So give me some time.
Kindly record that.
Yes, my lord.
Learned counsel for the alleged contemner seeks further accommodation to comply with the order under contempt in its entirety upon submitting that 25th that
date-
the amount shall be paid to the
Petitioner.
applicant petitioners on 25th January 2024.
Yes, ma'am.
Paragraph, let the matter appear under the same heading on 29th
Monday, next.
29th January 2020.
My lord, your lordship will not Monday. That is
Not
Wednesday, Wednesday, my lord.
Wednesday,
As because
31st.
my lord, compliance report.
31st January.
31st.
My lord, I am for the petitioner. This is the first time for the new contempt.
Will you serve and come back?
I have to serve.
Yes. The applicants petitioners are directed to serve copy of the contempt application along with annexure thereto upon the alleged contender and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 12th February.
Yes, my lord.
12th February. Next.
My lord, same, my lord.
Same.
I will give.
Same order. 6.
My lord, in item 7, my lord, I am for the KMDA, my lord. My lord, I report.
When we are for the beg to appear for the petitioner, my lord.
Yes.
On the earlier location, you also directed the KMDA. It has been merged to the Howrah Development Corporation, my lord.
My lord,
My lord, to file a report. Most probably, they have not filed a report.
my lord, the report is ready, my lord, but it is yet to be affirmed, my lord. My lord, may kindly take.
Sometime.
My lord, may kindly take it on the next week, my lord, not this week. I am.
Next, my lord, kindly fix a date, my lord.
I will.
My lord.
Learned counsel for the KMDA seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 16th February.
16th February.
February,
February.
16, yes.
16th February. Much obliged.
Next.
I am appearing for the petitioners, my lord.
Yes. Respondents?
Madam, Daily is the main respondent here.
Lordship,
Yes,
Lordship Shukanto Bhattacharya is appearing for the respondent
yes.
and I'm just praying for some passover.
Passover is not possible in
My
this
lord,
court.
every time, my lord, they are taking time.
Every time this is happening, yes, please make your submission. For the respondent. Respondent number?
They are present at the time of my lord demarcation. And they signed in the case map. After that, they are now, my lord,
Lordship, both the
delaying the
council.
matter for a.
You are for the
every day
railways.
they are
No,
taking time.
I'm the junior of Shukanto Ghosh, the second.
And on
council
last
that-
occasion, they prayed for time to
Yes.
file an exception to their own report.
No, Lordship, I'm just praying for some passover, nothing. Not-
Passover in this court is not possible. You must
Then,
be
my lord,
aware
not
by
today,
now.
my lord. Then, my lord, not today. Otherwise, my lord, every day they are taking time on the ground of to file exception on signing the case map and are present at the time of
Not
demarcation.
today. Very well. Now, because several dates have been granted. Not today.
Not today, madam.
Please be ready
Yes,
tomorrow.
yes, Lordship. Much obliged.
Yes, 19.
In this matter, my lord, I am for the state.
It was dismissed, again restored, again they are not there, petitioner. Mr. I.A. Lodhi. Who is he?
Imtiaz Ali, Aslam Loji. My lord rejected the application.
Yes. Anyone for the petitioner?
Every day, my lord.
Anyone for the petitioner in this matter? The writ petition was dismissed for default by an order passed on 29 July 2021 and was restored to its original file and number by an order dated 3rd October 2023. Today, the writ petitioners have again failed to appear, today the writ petitioners are again not represented. Stop, no accommodation is sought. Paragraph, it appears from the record that they are no longer interested. Dismiss for default. Full order. Corbin.
Madam, brother.
20 for the state, my lord. The presence of my lord, Jila Parishad is necessary, my lord.
Madam, a road was
It appeared, I cannot
constructed,
help.
Yes, but they appeared, my lord, the last time.
appeared. Madam, a road was constructed without acquisition of land, damaging all the crops. Madam, we file objection, they have given undertaking before the court. They will not complete the road. In spite of that, they have completed the road.
Mr. Shondipon Banerjee.
Yes, ma'am.
Where is he?
On the last occasion, he had said he will take instruction whether they will give the money
Or demolish.
or demolish the road.
Yes, yes.
Yes. For that reason, your lordship has given some time for this.
Very unfortunate today they are not there at all.
But I shown on that day the photographs.
Yes, yes, I remember. I can recall.
Now let it be demolished, the road. Pradhan Mantri Sadak Yojana.
Will you come back on 25th? I'll give you a short date. Next week. And please inform Mr. Banerjee in the meantime. None appears for the Jela Parishad. None appears for the Jela Parishad. Paragraph, let the matter appear under the same heading on 25th January.
April.
Well, I beg to appear on behalf of Bakuda municipality.
Petitioner,
Petitioner, my lord. Earlier, 2 occasions this matter was taken up. The petitioner seeks for time.
yes.
Lord, they have encroached the government land.
Mr. Dhar is for the state. Today no one
Mr.
is there.
Dhar.
What is wrong?
My lord, already report has been submitted by Mr. Dhar stating that, my lord, the hearing was given to the petitioner. He was present at the time of measurement, and my lord, it was found that some portion of the land has been acquired by him. That is why he asked to demolish.
Asked to demolish.
Last annexure, if your lordship kindly consider.
It's difficult. No one is appearing.
So this is the problem.
এটা কেন হচ্ছে?
Let there be a date because on other occasions they were appearing.
My lord, a short date may be given, my lord.
Petitioner is not interested.
Petitioner is not interested, but my lord, we are in difficulties because
I
this is
know,
the
yes.
vast road.
None appears for the petitioner and the state respondents. Stop, no accommodation is sought. Paragraph, let the matter appear under the same heading on 31st January. Next.
Number, sir.
22, madam, is I am for the petitioner, madam.
Well, I'm appearing.
The person to your lordship directions, the reports have been filed on behalf of the BLLR and also on behalf of the, my lord, the executive engineer. Both of them admitted in their report that portions of the land for the petitioner has been, my lord, utilized for laying the pipelines in the process of widening this road. Will kindly see the report and pass the necessary orders so that I can get the compensation for damages. It was not acquired by any authority. But kindly see the report of Mr. My lord, one report submitted by the respondent number 7. Devashish Chattopadhyay on earlier occasion.
Demarcation was made.
Yes, my lord. My lord, kindly see the paragraph 8. Paragraph 8.
Here again, the state is not there.
Is not there.
Difficulties,
But-
my lord, they not even serve the copy to me, my lord. I don't even know what is the status of the report, my lord.
কত আইটি 24
22.
So Bandyopadhyay doesn't choose to appear in most of the cases. What is wrong about? I'll give you a short date.
My lord, on 25th I am available here and 29th. And your lordship fix any date.
30th?
38th.
Yes, 30th.
Yes, yes.
Please inform Mr. Bandyopadhyay or
Yes,
Mr.
yes.
Nag.
I said just now I shall inform.
None appears for the state respondents. Paragraph, let the matter appear under the same heading on 30th January 2024. Please,
But I appear for the PMDA. My lord, there are 4 matters, 23, 24, 25, 26.
Yes.
My lord, may kindly recall this matter relates to that suppression of material fact to the point I have
Who is
taken.
appearing
Mr.
for the
Mr.
petition?
Mondal, Pulok Mondal was appearing. On the other day, I took that point, relied on some orders to which he was the learned
Party to
counsel.
it, yes.
Yes. And he was to reply on that, on the preliminary point. Otherwise, the pleadings are complete. The matter is ready.
It's a hearing matter.
It's a hearing.
Affidavit.
It's a hearing matter. Though not affidavit was directed, report was filed, exception was used. That is why it is coming under the motion.
I do not find the petitioner today. This is very difficult.
That's true. I am just trying to avoid my lord. This is-
Let there be a very short date. I'll dismiss the matter if the petitioner doesn't appear on the next date also.
As you wish.
24th.
24th.
I am the state in item number 25.
None appears for the petitioner. Stop. No accommodation is sought. Paragraph. Let the matter appear under the same heading on 24th January 2024.
Very well.
One last chance. Let it be. I'll consider.
Otherwise, I am ready for
29th.
24th.
কত থেকে কত 25
26 অব্দি। Same, up to 26.
Oh, up to 26, same order.
Up to 26.
Up to
23, 4,
26.
5, 6.
Same order. Up to 26.
Yes, sir. 27 minute I appear for the Yes, state is the. To file the exception to the report.
You served?
Yes, no, it has been served. Well, in the exception, I have categorically stated it is a specific mistake on the part of the government, Malad. Malad, they have acquired land, which they have acquired, about which, Malad, I am the owner. Whereas the compensation has been paid to the erstwhile owner, as would be evident from their records. Malad, if your losses kindly have a look to their report. I have purchased land in the year of 2000. No, only 2000. And Malad, the acquisition proceeding.
The state has come up with a report, isn't it?
Yes. State has come up. The state to answer me, Lord. Where
You are the requiring body.
requiring. They don't have anything to say. I have some submission. Let them. Nothing. So far, the acquisition and compensation is concerned. No. Not on facts.
Ultimately, the land has been given to
Yes.
Mr. Taluka's client.
But acquisition.
At our cost. And that too at our cost.
That's true. But by acquisition has been made by the government.
Yes,
Malad.
yes.
That is why I'm. Well, if your losses kindly come to their report. Annexure 6 of their report at page 21. Hey, no.
You say there was no acquisition.
Malad?
There was acquisition, but compensation was not paid.
Yes, not given. Compensation not given. Compensation which has been given, Malad, that is when I am the owner of 3 katas of land, whereas Malad compensation has been given, Malad, 1 kata, around 2 katas. A rest portion, I have not been given the compensation. That is also reflected from page 21 to 27, 28, 29, and up to 30. Malad, this the compensation which has been given to the parties. Malad, my portion is, Malad, where, if you losses kindly come to page 29, there is a where it will be evident that I have been given compensation for how much land, how much.
Shikha Roy.
Malad, Shikha Roy. So that, Malad, the total plot of land, Malad, 1110, acquired 0.205 acre, Shali, and Malad, I have been given compensation. That is, Malad,
18,000 something.
18,000 something and 20,008, total 39,109.
Yes.
That is, Malad, for the land. If your losses kindly come to
What is
serial
the
number 16, Malad, serial number 16, right hand side middle portion,
Yes.
That is 271.0.55555 acres.
Yes.
And next one is 0.0063480 acres. No, ওদের report থেকে. Whereas, my lord, if you will kindly come to our exception.
Total acquisition?
Total acquisition, my lord, entire land. That is, my lord,
0.345 acres.
my lord, my lord, my lord. Total acquisition, in their report, they have also stated.
You are the sole owners.
I am the sole owners. Actually, I have purchased in year 2000. Well, the compensation which has been given, that is erstwhile owner. At that point of time, 2006, they were not the owner. And it is an admitted fact. They have given some port for.
Given Shikhara. Shikhara is.
Yes,
you.
my lord. Shikhara.
You are the petitioner.
No, my lord. If not for my entire land, part of the land. Though I have purchased the entire land of Shikharas in the year of 2000, but compensation which has been given 2006, that is for part of the land, not for the entire land. That is the only dispute. Well, in their report, if you will kindly come to page 4, their report.
Yes.
That subsequently thereafter another land acquisition proceeding being LA case number LA such and such 2004 5 was initiated for the purpose of construction of Barakpur Damdam Expressway under provisions of Land Acquisition Act 1894 involving lawsuits kindly
Yes.
0.2050 acres in plot number 1110 and 0.06 acres in plot number 1111.
Yes.
And my lord, the declaration which has been given, paragraph 10, under section 6, my lord, in respect of the said land.
Yes.
And my lord, so far the position is concerned, that is not required. But paragraph 12, lordships kindly, this is in respect of us. The award in LA case number was duly declared and compensation in respect of the plot number 1110 and 1111 were awarded in favor of Ajanta Datto, Otul Sarkar, Vishnu Sarkar, Dilip Kumar Rai, Gauri Das, Jharna Sarkar, Kamal Sarkar, Mintu Sarkar, Pintu Sarkar, Prafullo Sarkar, Pran Krishna Sarkar, Pushpo Das, Ranjan Sarkar, Ritu Sarkar, Shanti Sarkar, and Shikha Roy. My lord, all Sarkar I have purchased from them. And my lord, Nayan Shikha Roy, present writ petitioner, Shapon Chandra Datta is not awarded, Tarak Sarkar is awarded such and such, and all of the declared awarded received their payments. Photocopy of the award, serial under reference is being annexed herewith and marked as annexure R6. So R6 is compensation which has been given to the parties. But my contention is, my lord, if you will kindly come to our exceptions, I have clearly stated in paragraph page 3, paragraph 3, subparagraph E. Though I have stated everything, but in here I have some of the entire dispute. That is, if you will kindly come to exception at page 3, paragraph 3E.
Yes.
In the year of 2006, government, in fact, under plot number 1111, acquired land measuring about 0.06666348 into 2 is equal to 0.01296 acres. Out of the petitioner's purchased land measuring about 0.038156 acres and raised land measuring about 0.0242546 acres, that is 1 katas, 8 chatak and 31 square feet remain under the petitioners. So total I have purchased 3 katas. Well, the next one is government also acquired land measuring about 0.0055555 into 2 acres is equal to 0.011111 acres under plot number 1110. Out of the petitioner purchased land measuring about 0.011344 acres and 0.000233 acres remain under the petitioner, which will be evident from the annexure 6 to the report of the respondent on page 23 to 30, petitioner also duly got compensation in respect of the aforesaid acquired land. So petitioners are entitled to enjoy the remaining purchased land, 0.000233 acres, that is 10 square feet, under plot number 1110 and 0.02456, that is 1 kata, 3 chitaks and 31 8 chitaks and 31 square feet acres land under plot number 1111, thus totaling 1 katas, 8 chitaks, 41 square feet as per purchase deed dated 8/12/2000. After acquisition in the year 2006, are entitled to get compensation of the same. So this is the my lord, entire thing I have sum up here. The total land I have purchased 3 katas, whereas my lord, I have not received compensation in respect of 1 kata, 8 chitak, 41 square feet. That portion has been, that compensation has been given to the erstwhile owner by the government. From the records, it will be evident.
Let us hear the state.
I have filed my report on the earlier question, my lord.
Yes.
My total land, my lord, there are 2 plots, my lord. Number, my lord, 1111 and my lord, 1110. Two plots, my lord. The total quantum of lands were 0.39 acres. So that will appear from the, my lord, my record of right. This has not been annexed, my lord. Excuse me, my lord. Handing over.
Yes.
Plot number 1111, total area is 0.18 acre. Jomir Poriman, right hand side, my top. And my lord, plot number 1110, next page, my lord, Jomir Poriman 0.21. But if I sum up, my lord, the total area will be, my lord, 0.39 acres. But out of these 39 acres, my lord, in first LA case, there are 2 LA cases. First LA case, my lord, page 8 of my report, can you see, my lord? Page 8 of my report for the last.
Yes.
Last person, 1110, plot number, left hand side. Land acquired, area 0.005. This is the first LA case, one. And my lord, next one, 1111, plot number, acquired land 0.12. If I summed up, then it becomes like 0.125 acre. 0.125 acre has been acquired in the first LA case. That will appear from page 8. And thereafter, kindly see, my lord, page 16 of my report. This is the second LA case. In second LA case, plot number 5, can you see page 16?
Yes, yes.
Plot number 1110. Area, my lord, acquired area 0.205 acre. And my lord, next plot number 1111, total area by 0.06. But if I sum that, then it will become 0.265 acre. And thereafter, if I sum both the land acquired with both the cases, it will become 0.39 acres. So entire plot has been acquired. The entire plot has been acquired. It is it is true. And there first LA case, the compensation is paid in the favor of the erstwhile owner. And they are the purchase after acquisition.
When was the award? When was the compensation paid in the first LA case?
Yes, sir. First LA case, compensation paid.
Page 9. Page 9 of
Page 9. Page 9 of my report. This is, my lord, 6869 LA case. $92, my lord. 82, my lord. Page
82.
Yes, sir. Page 8. Page 11, 82. Then they have not, my lord, come in the picture, my lord. They have not purchased at that point of time. They have purchased in 2006.
2000.
2000.
Second LA case is 2006.
2006.
And we are not bothered about the erstwhile LA case.
And
We have purchased the land.
Yes, only the second case you are entitled.
Yes.
yes, they have received the compensation interest over second case, my lord.
Second case, what is the quantum of land acquired?
Sir, I am saying. my lord,
0.26
Page
altogether.
29, my lord. Page 29 of my report. This is the award. But kindly see, Shikha Roy, serial number 16. Total area of land. My lord, ratio.
29.
0.205, my lord. First, 1, 2, 3, 4, fifth line, my lord. My lord, serial 16,
Yes.
the area of land 0.205. That is my lord. Acquired land, my lord.
No, no.
But
Not at all.
second case, that portion of the land has been acquired. In
I
second
think
case,
acquired land is 0.0055 triple.
no, my lord, 0.0205.
No, that is total land. But in respect of our case, our land has been acquired only 0.05555 acres.
Thus, you will kindly consider page 24, serial number 4, and page 29, serial number 16. These two plots are involved in the second case.
আচ্ছা ওরা রিপোর্টেই তো বলেছে আলাদা করে এখানে রিপোর্টে আলাদা করে বলেছে
These are identical documents.
No. In respect of two different plots.
না না 1110
1110.
আর ওটা
area
111
205.
110. Next, my lord.
1110
4.
Identical.
Next, just subpara, you will find plot number 1111.
Yes, same in 27 also.
Same is repeated.
It's identical. These two
Identical.
documents are identical.
Identical. Documents are identical.
But strangely, this is in the name of Dilip Kumar Rai. The other one is in the name of Shikha Rai.
The total area of land wala acquired 0.205.
And compensation paid for the entire.
The rest portion, my lord, which they have purchased, my lord. But they have received the compensation. They have received second case. But how they can say, my lord, the.
They come into picture in the second case only,
Yes,
not in
my
the
lord,
first case.
No.
So what was the quantum of land acquired in the second case?
So that is, my lord, second case acquired in respect of first plot, my lord, 0.205. And in case my second plot, my 0.06 acre. But that will appear from page 16. Page 16 of my report, my lord.
Please come to paragraph 12 of your report. You say that in the second case also compensation was given to the Sarkars.
May have some share is there, the first owner, erstwhile owner. We have some share, my lord. And also includes the
This
petition.
includes the present petitioners
This
also.
includes.
Yes.
Includes the
we are not
Present petitioners claim over 3 katas.
three katas. So are in
You are
respect
owner
of
of
other.
3 kata. Out of that,
we have got only one kata something, but I intend to get now.
entire 3
What?
katas have been acquired.
Yes, my lord, that portion has been acquired.
The entire 3 katas have been
Entire
acquired.
3 katas have been acquired.
It is quite natural. My entire plot has been acquired. That includes the land of the petitioner.
If your losses kindly come to page 4 of our exceptions. Here we have also clearly discussed. In fact, in the year of 2000, Pran Krishna Sarkar and the heirs of his deceased 2 brothers sold out the land measuring about 2 katas 5 chitak out of the land 0.06 acre, that is 3 katas 10 chitaks under plot number 1111. So, said Parikrama Sarkar, Pran Krishna Sarkar and others should have the remaining land measuring about 3 katas 10 chitaks minus 2 katas, 5 chitaks. That is 1 kata, 5 chitaks under plot number 1111. Whereas government acquired land measuring about total 0.047304 acres is equal to 2 katas, 14 chitaks land under plot number 1111 in 2006 from the said Pran Krishna Sarkar, losses kindly noted, and others, and paid compensation to them despite the fact that the Pran Krishna Sarkar and others are only owners of 1 kata 5 chitaks land under plot number 1111 in the year of 2006, as would be evident from the document annexed in the report. The details of the acquired land under plot number 1111 from Pran Krishna Sarkar and others by government in 2006 are given below as government records. Well, here I have stated everything, how much compensation and how has been given to the erstwhile owner and how much was the land.
Exception.
And how much was the land?
They are submitting that is not from record, my lord.
No, from the record.
Shown your lordship for the record.
No, no.
Second LA case, page 16, where the land has been acquired in respect of plot number 1110, 0.205. It is appearing on record.
16 is prior. It's the first acquisition.
No, my lord, second acquisition. Page 16 is second acquisition. Page 16 is the second acquisition proceedings. 2005.
Page 16.
Yes. Page 16 of my report.
No, that is the notification.
Notification.
15 and 16.
This was the quantum of land.
No, this is 15 and 16.
This is the quantum.
Yes, ma'am.
Total quantum. Yes,
No,
that is not
total.
disputed.
In second LA case, this land has been acquired.
Yes, yes.
And
I am
rest
not
was
disputing
acquired
it.
in the first land acquisition case.
Yes, say, and second LA case 1110, and it is recorded 0.205. That is, I have also said so.
0.205.
Yes,
and
I am not disputing it.
0.06. These are
And,
equal to
yes, and 111,
Rest has been acquired in
3.06.
the first LA case.
No, no.
I have shown to your lordship.
No, no, they are just misleading the code. No, he is misleading.
16 is the second LA case.
Second LA case. And page
Acquisition is 0.205.
And 0.06.
06.
Yes, my lord.
So the
I'm-
petitioner is claiming compensation for this.
Please,
Because second LA case, they are entitled. Please show me that you have paid for 0.205 and
entire
0.06.
20, they will not entitled to get one. Let them show they have they are the owner in respect of entire 0.205 acre of land.
Not entire. Why I should
That
produce
is why they are
entire?
not the entire owner of the land.
No.
They have
I am
not
the
got
owner
some
of the.
share
No. I am the owner of the plot number 1110 and 1111.
Yes.
That is not disputed, and so far the
Not in respect of
those two
entire
plots
area
are
of land.
concerned. Whatever.
You are the owner of the entire plot. These two
No,
plots.
my lord. 3 katas of land in respect of the plot number 1110 and 1111. So to that effect, not
In total.
total 3 katas in total in respect of the two plots. And what has happened, my lord, in respect of the two plots, they have given not for the entire land which I purchased in the year of 2000.
That is the evidence.
No. This is totally misleading. Total misleading. I have stated clearly in page 4 in our exception, paragraph F. I have stated everything. Each and every person, the erstwhile owner, which they have got. My learned friend is saying the erstwhile owner was the owner. Let them source that they were the owners.
Already, if my learned friend has finished,
Yes.
then my
yes,
lord, I
yes.
kindly allow
Let's
me.
clarify because here it's
Yes,
very
yes, Lordship,
confusing. huh?
Lordship, kindly come. Yeah, Lordship, kindly come to their writ petition first. Where's it on? If you Lordship kindly come to their writ petition, paragraph 6. 2-3 paragraphs are necessary, my lord, to place.
Paragraph 6. Yes.
6 of the writ petition. My lord, may I read? When they have purchased, that is not. Thereafter, suddenly the respondent number 2 served a notice upon the petitioners bearing process number so and so being award serial number 4 and 16, which I shown to your lordship. Yes. In respect of LA case number 4 of 2005-2006, respectively, wherefrom it could be learned that the plot of land of the petitioner being that number 1110 and 1111, that is, the remaining portion of the said plots has been acquisition for the construction of Barakpur-Damdam Expressway, and the compensation has been settled. And to take the payment of the compensation amounting to rupees 39,109 to each of the petitioners on 6th November 2006.
which is totally improper and inadequate, and the other plot holders whose land has been acquisition have been given a much higher rate as compensation. In the aforesaid notice, your petitioner were requested to attend the office of the respondent number 2, and your petitioner, upon attending the said office, made an objection to such acquisition of the land, and also in regard to payment of such very poor compensation, which was wrongfully and quite arbitrarily assessed by the respondent number 2 after a period of long 6 years of purchase of the said plot. 7. Upon the aforesaid objection of your petitioner, the respondent number 2 to 4 assured your petitioner that initial amount as paid by the respondent number 2 amounting to rupees 39,109 each as per the said notices has been given as an ad hoc payment, and the final compensation would be given after proper assessment of the compensation on the plot of land. Your petitioner and the legitimate claim of your petitioner should not be frustrated, and they should not be deprived of their proper compensation on the market value on their assurance. The petitioner accepted the said amount as an ad hoc compensation, and till now the proper compensation has not yet been assessed. The matter is sub judice.
Sir,
This is
agreed with the compensation.
compensation. Now, Lordship,
They have not been paid part of the compensation.
Lordship,
That's not your case.
Yes, to that effect, my lord, initially another writ petition was filed before this writ petition.
my lord, I'm
There, my
coming to
lord,
that. Having regard to, they have come up before this honorable court, and this honorable court directed the DM collector to consider their representation, and that was done. And challenging which this present petitioner has been filed.
So, but
Lordship,
enhancement of the compensation, that matter is pending. No, no, please. Not to mislead court, please.
Let me hear, Mr. Thakur.
Yes.
That is
বলতে
so
দাও, তুমি তো
satisfied.
বলেছো, I have not interrupted you. You will not allow the other party to place. Lordship, kindly come to the order passed in pursuance of the order passed by this honorable court. That is at page 62. That is not, I am not placing this. This is the initial order.
Go, you read it.
Yes, yes. If you want, I can read.
Sure.
This is not material, that is why.
No, no. Whatever
Let
you
him
read.
complete, please.
Please, don't make running commentary.
Yes, next.
Where is, I am reading. He wants that I should read.
The relevant portion.
He wants
Page,
wants me to read the whole order.
you're making a submission on the
My lord, the material, the 63, my lord, Lordship, kindly come to page
63.
63.
yes.
That is the material, the final order passed by the DM collector. That is 10th February 2010.
Yes.
My lord, got it? At
Yes.
page 63.
10th February to
2000?
17th July 2019.
No. That is
Page 63.
page 63 of the writ petition.
Yes.
That is orders passed by the district magistrate and collector pursuant to the order passed by
Page
this
numbers
honorable
are
court. It's not matching. 48 in my copy, I find তোমার copy তে দেখো তো।
It's annexed.
It is এই তোমার
Oh, 59.
it is
Order dated
P9
10th February
P9
2010.
P9
10th February 2010.
10th February 2010.
Yes. Yes.
May I place this? The case is taken up for hearing. Sri Dilip Roy and Srimati Shikha Roy, the petitioners are present and filed Hajira. The officials of the LA department are also present, heard the parties. The representation in the form of demand of justice dated received from the writ petitioner's learned lawyer, Mr. Pradeep Kumar Mojumdar, has been examined carefully and thoroughly. It is found from the said representation that the petitioners alleged for giving them LA compensation for their land in plot number 1110 and 1111 of Moja Matkal, jail number so measuring 3 katas under PS Damdam, which is beyond any calculation, and demanded to pay proper compensation on appropriate calculation of the market value of the land at the time of acquisition, considering the loss and damages. The original case records in respect of the related LA case number 134 of 2004-5 have also been thoroughly examined. It appears from the said LA case records that only 0.02380 acre, that is 1 kata 7 chetak, 2 square foot of land in the petitioner's plot number 1110 and 1111 of Moja Matkal under PS Damdam has been acquired. It also appears from the rate report of the LA case that many as 8 cell figures of Moja Matkal for the material period of acquisition were collected from the concerned ADSR office and taken into consideration, and a rate of rupees so and so has been assessed per acre, that is 40,832 or 632 per kata, as per provision of the Land Acquisition Act, which appears to be fair and reasonable. The sale price of the adjacent plots in the vicinity of the acquired land for the material period is main criteria for assessing the market value of land in question, irrespective of considering the stamp duty as per provisions of law. It is also found that the petitioners received LA compensation amounting to rupees 39,109 each on 6th November 2006 on protest by our serial number 4 and 16. Subsequently, they submitted reference under section 18 of the Act for enhancement of the collector's land value, which were already forwarded to the land acquisition judge Barasat for adjudication by memo number so and so, which have registered as LRA case number so and so for Dilip Rai Atom, case number 155, and for Shikha Rai 155 for Shikha Rai. And these cases are pending before the land acquisition court. It is thus evident from hearing the petitioner and examining related LA case records that the petitioners were paid proper land acquisition, land compensation assessed fairly, reasonably, strictly following the provisions of procedures embodied in the Land Acquisition Act. It is therefore ordered that the representation in the form of demand of justice is considered rejected and disposed of. What grievance they can have, they have already, because it was the primary grievance of the petitioner that compensation was not properly paid. They were paid less. They made a demand of justice which was not considered. In earlier occasion, Honorable Court was pleased to direct the collector to consider that. Collector considered that, examined that. And it also appears that against this assessment, they have already made a reference, which is registered. If they have any grievance about payment of compensation, it is the land acquisition court to decide.
Is it still pending?
It is pending. It appears from the order itself.
The 2010 order.
2010
Yeah,
order,
2010
and it is not stated in the writ anywhere in the writ petition that whether it is disposed of, whether it is enhanced or retained. The petitioner should have disclosed all these facts when challenging this order.
Yes, everything I have disclosed. Otherwise, I could not have been like this.
So what grievance he may have? And it is, my lord knows that it is the settled principles of law. The acquiring authority is not supposed to make a roving inquiry. Because in the first land acquisition case, as has been annexed in the report, they were not concerned, according to them. They came in picture subsequently. And it appears from the order itself that they were in the writ petition also stated, they were served with the notice. They appeared, filed objection, compensation assessed. So what?
No.
If they have any grievance about payment of compensation, they have already filed a reference case. Remedy lies elsewhere. Regarding the quantum of loss, it appears from the report that entire 2 plots are acquired. The portion he has acquired, he has purchased, if that comprises.
He has purchased 3 quotas, 3 katas.
3 katas. 3 katas, whether from which portion, that is to be identified.
That is when demarcation is necessary. I have prayed in our petition.
But here demarcation,
demarcate it.
No. Why demarcation? When the entire land has been acquired.
Why means without demarcation, how you say so?
You
Entire
cannot.
land doesn't belong to the petitioners. petitioners are claim to be owners of a particular portion.
I'm grateful.
Out of that particular portion, you say that 1 kata 7 chotaks, 2 square feet was acquired.
Acquired. From him,
Out of his portion,
out of his portion, 1 kata 3 chatak,
yes.
that
so
was assessed.
what
As
about the remaining
This
portion?
remaining, I'm grateful. to that.
If remaining portion is acquired and the compensation has not been paid in favor of the petitioner, then their relief is under section 30 of Act 1 before the land civil court. But they have to
Have you taken this point here?
that I have not taken, Malad. But
You have taken some other point.
Relief, Malad. Under section 30.
it is not the
Because
case
they are-
made out in
they
the
are-
writ petition. There are-
they are-
a second. It is not the case made out. They are challenging the reason order where it is specifically specified that one kata, 3 chatak, certain square feet has been acquired from his.
On page
land.
65 in our writ petition.
So if he had any grievance regarding the other part of the, when it is also disclosed,
On page 65 of
that
our
the
writ petition.
entire, these
This
two
is our
plots are,
representation. Let's
these
kindly
two
have a look to
plots
this
are-
representation.
these
The
two
demand
plots
of
are entirely acquired. So where is the scope of demarcation?
Where we have also stated for demarcation, prayed for demarcation. And Malad, this is a representation page 65.
Had
This is
there been,
special LAO collector not 24 Barasat. বলে জমি অধিগ্রহণ করার পর বাকি জমি বুঝাইয়া দেওয়ার জন্য আবেদন ইন বেঙ্গল ইট ইজ রিটেন আমি শ্রী দিলীপ কুমার রায় সাচ অ্যান্ড সাচে জানাইতেছি যে আমার এবং আমার শ্রীমতী শিখা রায়ের নামের উত্তর 24 পরগনা দমদম থানার অন্তর্গত মটকল মৌজার 3 কাঠা জমি আছে যাহার সিএস এবং আরএস দাগ নাম্বার 1110 এবং 1111 এবং যাহার জেএল নাম্বার 15 এবং খতিয়ান নাম্বার 547 এই জমি থেকে ল্যান্ড অ্যাকুইজিশন ডিপার্টমেন্ট বারাসাত 26/10/2006 তারিখে 1 কাঠা 7 ছটাক 2 স্কোয়ার ফিট জমি অধিগ্রহণ করে এবং আমাকে আমার স্ত্রীকে 39,109 টাকা করে দুটি চেক দেয়। সুতরাং ওই জায়গায় এখনো 1 কাঠা 4 ছটাক 43 স্কোয়ার ফিট জমি আমাদের অধীনে আছে যাহা সরকার এখনো অধিগ্রহণ করে নাই। ল্যান্ড অ্যাকুইজিশন ডিপার্টমেন্ট বারাসাতের লেটারের কপি এই আবেদনপত্রের সঙ্গে যুক্ত করা হইল। সুতরাং আমার প্রার্থনা এই যে আপনি আমার আমিন দ্বারা 3 কাঠা জমির মধ্যে আমাদের অধীনে থাকা 1 কাঠা 4 ছটাক 43 স্কোয়ার ফিট জমি যথাশীঘ্র আমাদের বুঝাইয়া দেবেন। What is the reply of that letter?
yes, it may be possible because from the subsequent acquisition in respect of 2 plots, his portion falls, my lord, 1 kata 3 chatak.
Admittedly, out of his 3 katas,
Yes,
1 kata 7 chotak 2 square feet has been acquired.
acquired.
Yes, and you say compensation was paid for that amount, for that portion. Petitioners being aggrieved,
Reference has been sought.
Section 18 is pending.
And 18 is
I
pending.
do not know whether it is still pending.
Yes, ma'am.
That-
So
that's
far
taken-
the
taken
enhancement
up.
is still pending.
So this is with regard to the acquired portion.
Acquired.
This court has nothing to do with that.
No, Malad.
The remaining portion out
I'm
of the 3
grateful.
katas.
I'm grateful.
Remaining,
That has to be,
yes.
you
The
say that the
remaining portion
entire,
has also been acquired. Because
where is that document?
It cannot have been acquired.
Where is that document?
I have shown, Malad.
Your order says that only 1 kata 7 chotaks and 2 square feet has been acquired.
Acquired from the petitioner's land, man.
Petitioner is,
Out of 3 kata.
yes,
The entire 3 kata has been acquired.
where
Because
is
the entire
that?
plot is, I have shown, Malad, my
Your order doesn't say so.
but record says so, Malad. In first delay case, Malad, I have shown, Malad, how the quantum of land has been acquired, page 80 of my report, Malad.
Not, forget about the first delay case. Come to the second delay.
Second delay case, Malad, kindly page 60.
We are concerned with the 3 katas belonging to the petitioner.
Yes, ma'am.
Yes. Out of 3 katas, your authority says 1 kata
Exceptional
7
detail
chotaks
is
2 square feet is acquired.
It-
What about the remaining part?
My lord, it may happen. Because these 2 plots were acquired in the first land acquisition, certain portion of these plots were acquired in the
Purchase is
first.
after that.
No, but it may be, my lord, the erstwhile landowner might have sold out a portion of the acquired
That
land,
is no one's case.
might have, because in the
Might have,
subsequent,
it can-
no, in the, your remedy lies against the vendor, your vendor.
We cannot bank on might have. The order impugned itself says that out of 3 katas, this portion has been acquired. It is very clearly stated in the order by the authority.
Yes, Malad.
So
Page
the authority
63.
has to
Page
clarify
63.
the position of the remaining land.
The order no has stated the remaining land has not been acquired. That has not been stated in the order, Malad.
when you say that you acquire one portion, it in
Entire plot has been acquired. This is the case.
where is it stated that entire plot is acquired?
That's what I have
Show me one
explained.
sentence.
Yes,
No,
sir, I have explained
my lord,
it.
that has been clarified in the.
Report is given
No,
by the
no, no,
authority.
no,
of-
I'm on the
Based on
collector's,
report one.
I'm on the collector's report,
Yes,
collector's order.
yes.
My lord, collector's order were considered only 2004-5 case.
Yes.
Second LA case. Second LA case in 1110, 0.20 acres, and in respect of 1111, 0.06 acres. That is altogether comes to 0.265 acres. Out of which, my lord, the petitioner's portion, my lord, falls 1 kata 3 chata, and the remaining portion, other co-sharers are there, in respect of which the award has been passed. So it is clearly goes to say, my lord, in respect of the second land acquisition case, his portion only 1 kata 3 chata 3 square foot or 6 square foot.
Show me the document.
That appears from the award itself.
Where?
Because the remaining portion, the other co-sharers are the owner.
Award cannot be said. It is the final document. Before
Please,
that, there.
language of the order impugned.
Yes.
Very clearly it is stated that out of the petitioner's plot, this much is acquired. So the authority admits that the petitioner is still owner of the remaining portion. There be a direction for demarcation.
Entire plot is acquired.
Demarcation,
Nothing
how?
to show that the entire plot is acquired. No document proves that entire plot is acquired.
But the Gazette notification says that an entire land has been acquired. These two plots are entirely acquired.
Where does the Gazette notification?
Yes, Lordship, kindly
Doesn't
come.
say
Kindly
entire.
come.
Page 15 and 16 of my report.
Not entire, except southeastern corner and northwestern portion. Page 16, that is their document from the report.
But that person has already been acquired in first LA case. That have shown to your lordship.
But this is in respect of portion. In respect of portion.
But total land
And he
is clear.
says that,
Total land is clear, 205, 0.205 and 0.06.
and in the first
So from-
LA, in the first LA case, Lordship will find at page 8, left-hand side, my lord, at the bottom,
Page.
page 8 of their report. The left-hand side column, last but 2 lines, my lord, Lordship will find at the bottom.
Yes.
1110 southeast corner.
Yes.
And the page, if you Lordship compares with the page 16, Lordship will find here except southeast corner, because southeast corner was already acquired. That is why except. And next one, southern.
Yes, but
One-
where
one-
does it indicate that the entire plot is this?
If I summed up, then it will become an entire plot.
Yes?
Both the area is summed up, then it will become an entire plot. I have
Southern Lekha.
And the next 1111, Lordship will find at page 8, that is southern.
কোথায় southern লেখা আছে?
এই তো southern.
এখানে কোথায় southern
It
লেখা
has
আছে?
also been
Southern?
perhaps
না, না, এটা north
has been
west
paid for
portion.
the outside owner.
Does it mean
Other
southern?
co-share.
Confuse করো না।
They are really
এটা
some
confuse
side,
করছি,
but
এইটা southern, এইটা ওইটা কেন southern হতে যাবে?
Whatever it may, total plot of land acquired 2006, 0.205 and 0.06. This is not disputed. And out of that, whatever compensation I have got, that I have stated here.
And in the earlier acquisition, it is 0.005 and 0.12.
Yes, ma'am.
So if we add up all these, does it comprise the entire plot?
Yes, my lord. That I have stated in our exception, my lord. I have stated how much compensation they have given to the erstwhile owner. How it is calculated. That it's from their records. It will be evident from the records. page 4 of our exception. If you look at kindly page 4,
Question that has been raised by Mr. Talukdar, whether the erstwhile owners have sold out plots which were already acquired.
no, that is not the question. No question does. We have purchased the plot from the erstwhile owner. This is not at all acquired.
How do you know?
Malad, let them say,
Sure.
Malad, that plot of land was not
He
demarcated
wants the
properly.
exercise to be done by the read code, which should have been done by
That
the
is
civil.
why demarcation is necessary.
Your relief lies against the
No, no.
against your
But
vendor.
why are you avoiding to demarcate it? Something
What
fishy is
is
there.
demarcate it?
The entire plot.
And
has
their
been-
plot when
the entire plot is acquired. There is no question of demarcation.
no question of demarcation.
Demarcation comes in only when a portion has been acquired.
Malad, so far the compensation, so far the assessment of compensation is concerned, Malad. Obviously, when demarcation is necessary. The owner, Malad, everybody.
You have not received compensation for the remaining part.
Yes, Malad, remaining part.
The entire plots, both the plots have been
Yes,
acquired.
yes.
There is no dispute.
No dispute. No dispute. So far the compensation which has been given, Malad, not to us only, but other erstwhile owner also. They have been given also compensation 2006. Malad, that is, I have specifically stated how much they have got the compensation, the erstwhile owner.
The owners of the different, you are owner only of three katas.
3 katas, but that 3 katas is,
Remaining portion.
no, Malad, that portion has been given. That is why I have stated in page 4. Page 4, paragraph A, I have stated from their report it is reflecting. The compensation which has been given, that page is 21 to 30.
There are many disputed question of facts which he is raised.
আর যখন পারছো না নানান রকম কোশ্চেন কথা বলবে
Why you are making such a comment? You argue on merit of the case.
I am arguing on merit of the case. You are everything you are saying on your own without any records.
Why don't you come back on affidavits? Because these questions have to be settled.
Yes.
Whether there has been overlapping,
Yes.
if I take it there is no overlapping, remaining portion compensation has been paid to whom?
If it is paid to somebody else, man. Then what is the relief, Malad? What is the relief? May have some Malad, they
You
are
have to pay to the petitioner and then claim it from the that
after
somebody.
determination, Malad. Just to be determined.
This can be clarified by the state. Let the state files an affidavit clarifying all this. And the petitioner is also to produce Milord the deed plan. If you lordship kindly takes up the page 31 of the deed, there let them also show the which portion they have purchased. Here in the schedule, if your lordship kindly sees that it is delineated তৎসংলগ্ন প্ল্যান লাল রঙের রেখা দ্বারা সীমাবদ্ধ. So where is that? Let him also to show.
Part of the petition.
Yes, Malad. I have annexed.
কোথায় প্ল্যানটা কোথায়?
এই তো প্ল্যান পাশেই আছে দেখো
This is page 33
কোথায়?
is the plan.
In our copy you have not
এটা চেঞ্জ বিট তাহলে তোমাকে দেয়নি তো?
না কোথায় এই তো দেখছো
দেখো এই তো আছে ওনাদের নেই দিকটা নেই No,
my copy I don't find that.
এই তো আগে যে
If it is there, honorable court will
Please come back
consider.
with detailed affidavit. Yes, I think that is necessary in this case. Otherwise, this problem cannot be solved.
yes, but it is a clear case, Malad. Whatever I have got, I have not purchased the land. It is a acquired land. That is, Malad. Let them say so. That it is acquired before that.
That is also in question.
I have purchased 2,000.
Vendors may have sold a portion of the acquired land also. That is nowhere. It is not found in the writ petition at all.
No, Malad. Because why? Because 2006, the rest portion has been acquired, where the erstwhile owner also got compensation. That is, Malad, clearly stated from their portion. I am saying that they have received it from their portion, from the records of the reports. From the report, it is reflecting.
And one more thing, lordship will kindly specify after purchase whether they have mutated their names in respect of this. That document to be shown also.
Exception submitted on behalf of the petitioner. Petitioners.
It's affidavit
The report in
clearly
the form of affidavit
separate-
submitted on behalf of the state respondents is taken on record. Paragraph upon consideration of the submission made on behalf of the parties, comma, this court is of the view that the matter needs to be heard on affidavits. Paragraph affidavit in opposition be filed within 2 weeks. Within 2 weeks from date, Stop affidavit in reply, comma, if any comma be filed within a week thereafter. One.
My lord.
Paragraph, let the matter go out of place for the time being, liberty to mention.
So
And for
state will file affidavit. State will file.
I don't think you'll be.
We do not have all these records. All these records are lying with the state.
Not necessary. That-
As you lost. And my lord, matter will appear up.
That's state response. We file the state respondents within 2 weeks.
My lord, matter will appear, my lord, on a particular.
Liberty to mention, I said, after completion of affidavits.
As you lost. Or my lord, date after 4 weeks, my lord.
Send your affidavits and come back.
Well,
Next.
well, will you be lordship pleasure to take up the previous matter? My learned friend is appeared.
Please come.
Well, your lordship has fixed on 22nd.
Yes.
Well, that day,
22nd, 4th.
24th.
My lord, as for the petitioner, led by Mr. Patprotim Roy. My lord, in this matter, my lord, I am.
Was called for.
Yes, my lord.
Yes, my lord. Report in the form of affidavit, my lord, has been affirmed. কপি দেয়নি না আজকে একটা জেরক্স করে দেবো অফিস থেকে একটাই আছে না আর এক
Served by the state.
আর হ্যাঁ
Regard to compliance of the award, the terms of.
yes have already been complied
Sure. How has the calculation been made?
কপিটা আজকে জেরক্স
I also I may be favored with a copy. madam.
Copy has not yet.
Please serve a copy to the.
yes I have to xerox just only one copy I have to xerox my lord.
And also me, my, I have not.
He is a petitioner, he's also.
I am filing today and I will serve within the today after xerox of my
You've not served the petitioner also.
let it be tomorrow.
No. This practice should be really. You come with reports and without copies of the reports. What is this?
না দেয়নি আর একটাই অফিস কপি আছে
Learned counsel for the state respondents is not ready with the copies of the report in the form of affidavit. Paragraph, let the matter appear on the same heading on 29th January.
এইটা নেই এটা নেই একটাই অফিস কপি আছে জজ সাহেব বললেন রেডি হয়ে কপি দিয়ে 28
Yes. 29 is appearing. 29.
But I am happy.
Who is Mr. A? They.
I am for the state, my lord, in this one.
Mr. Roy for the petitioners.
Roy petitioner.
Yes, Mr. Supratim.
Hey,
part-
তোমাদের মামলা তো 29 হ্যাঁ then my lord accommodate another day, my lord.
Extension was granted for using exception.
এই exception দেওয়ার কথা আছে my lord.
No clue.
While there is no mentioning of this matter, my lord, can we accommodate it for today, my lord?
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th February.
Right.
Please be ready with your exception.
Yes.
The land of the petitioner was acquired by the National Highway Authorities, my lord. Therefore, my lord, I have made an application for enhancement of the compensation, my lord, under the Act of 2013, my lord. My lord, the arbitration proceedings was held, my lord, without, my lord, serving any notice, my lord. My lord, award was passed, my lord. My lord, in the affidavit in report filed by the state, in the affidavit and not in the affidavit filed by the highway authorities, it has been never been disclosed. No record has been annexed, my lord, that any notice has been served, my lord. Without serving any notice, my lord, behind my back, my lord, award was passed, my lord. My lord, at page 31 is my application to the arbitrator, my lord. Is my application for
This is a 3G5 application.
3G5.
Yes.
And I will be relying upon a decision of the Honorable Division Bench, my lord, where also, my lord, no record was, my lord, submitted by the authorities that any notice was served upon the petitioner, my lord. In
Settled.
but my lord, instead of my natural justice, instead of, my lord, sending it to the, my lord, for setting aside the under section 34, my lord, it was relegated with the my lord, authority, my lord, since it was violates, my lord, principles of natural justice.
34 is not applicable when you are not heard at all. Yes. National Highways, Mr.
My lord, in this matter, my lord, my instructions, he has already received the enhanced compensation also.
Maybe.
My lord, regarding the copy of the award, my lord, I am not standing on his way, my lord. If your lordship can direct
Not
the
copy of the award. He was not heard at all in the arbitration proceeding. Where is the notice issued upon him in the arbitration proceeding?
my lord, in this case, my lord, he has already.
Report doesn't say so, I think.
My lord, my report says, lordship, I already received the compensation, my lord. Enhancement the
But
compensation.
unless the notice is issued,
But
it's received
lordship
by
made
him.
them so that he received the compensation without any prejudice, my lord.
My lord,
After
kindly sees,
receiving compensation, my lord, how he challenged the same, my lord.
my lord, kindly sees the report filed by the state, my lord, page 3, internal page 3, my lord. They have stated, my lord, notice was served, my lord, no record is annexed, my lord. Let the record be placed before my lord that a notice was served.
After my lord receiving the arbitral award, how he my lord raised this question?
My lord, I am lordship raising this question to myself, my lord, whether he received the compensation without prejudice.
Protest,
Yes, without prejudice, without prejudice.
Compensation is always received without prejudice.
My lord.
And that
Compensation
doesn't
amount
preclude
received
the
by-
person
My lord,
from challenging it,
my lord.
isn't it?
My
Grateful.
lord, regarding the
Please show me
copy,
one document that he participated
My
in
lord.
the arbitration.
My
and
lord.
out of
My lord, my lord. Grateful, my
my lord, regarding the copy, my lord, I am lordship, I am
copy. His participation in the
lord.
arbitration.
My lord.
There are a cabinet of decisions which say that if notice is not served, he has not been given an opportunity, that is not applicable to him.
after
He can
receiving
make
the
a
compensation,
yes,
whether
even
my lord,
yes, of course. Settled law.
my lord, then lordship give me some time, lord, so that I can take the instructions,
My-
lordship, on this. So my report is there because he received the compensation, so lordship, his remedy lies in elsewhere, my lord. After receiving the compensation,
This is the state's report.
My lord. State's report, my lord.
Petitioner has never challenged the award. Why will he challenge the award? He was not heard at all. He
My
didn't
lord, doing something
participate.
before also,
Yes.
my lord, the compensation has been assessed by the Kala, competent authority. He has received. He has made application before the arbitrator. And he has received after that one arbitral award has been part. I have no instruction whether my lord he has participated or not. No notice has been served
is-
upon him or not.
That is
I have
important.
no such instruction. But he has received the arbitral amount, my lord. The amount has been enhanced. An enhanced amount he has received without my lord any objection or protest. After receiving the award,
How has he received the amount? Through bank?
My lord, the
How have you received the amount? In cash?
আছে আমাদের কাছে? ঠিক আছে, অবশ্যই যে receipt
No, maybe there is always in the
Bank.
draft.
It
Draft.
is generally a bank transaction.
page
So it
34 is the.
sent to the petitioner's bank without.
Well, in this case, lordship, subject to lordship, notice has been served, lordship. Regarding the payment notice is there. After that, lordship, they receive the compensation. Lordship, the payment notice is there. No, lordship, as for
Where is the payment?
My lord, page 34, my lord.
Oh.
Page 34 of the writ application, my lord. Wherefrom it appears, my lord, awardee number such and such. But it does not reflect that any hearing, date of hearing, or any notice, my lord, nothing.
payment notice, yes.
This is payment notice.
yes, my lord.
Payment notice has been given to him.
My lord, actually, my lord, the entire compensation has been paid in terms of the entire MOSA. Thereafter, lordship, the land users came before the competent authority as the
And
disbursing
my lord,
authority. He disbursed the compensation in some
Compensation
way.
amount has been paid
After
in the year
receiving-
2017.
2015.
Because it's already 2021.
It's a continuing cause of
My lord, and I immediately, my lord, I have made an application before the arbitrator in 2015, my lord.
amount was paid in.
Amount was paid, my lord.
23rd May 2017.
2017.
And your application is
15.
at page?
My lord, page 31, my lord, 14 September 2015.
Application is prior to that. And there is nothing to show that this application has been considered and disposed of.
Well, that is correct, my lord. But whether, my lord, he has stated before this honorable court, he has received the amount or not, arbitral amount, arbitration has been held, it is correct. And my lord, here, amount has been enhanced, and he has received the enhanced amount. There is no such.
How has he received? It was sent to his bank account.
My lord, through a notice, my lord, through a payment.
Notice has been given to him. Page 34.
That doesn't preclude him from challenging because he's not participated at all. You just fix an amount and send it.
My lord, after 4 years, my lord, he has come before this honorable court after receiving the amount money.
Let me pass it on. Let this application be sent to the arbitrator and decided.
Grateful.
Can you find any document so that notice was issued? He'll be out of court.
Well, then I have to take, my lord, the instruction whether the notice has been served upon him.
If notice of arbitration is served,
Arbitration or he has participated.
there is no
No
case.
case.
My lord, my one submission is, my lord, he has got argument say, my lord, say, Lordship, we have not sent a notice. But he already received the compensation. After, Lordship, my lord, we
Withdraw
sent a notice.
litigation will not help.
No, my submission, Lord, we served a notice, Lordship. And after this notice, what will do, my lord? He cannot ask the arbitrator to enhance the amount. Now he is a functus officio, my lord. His remedy before section 34.
No,
What
the
will
arbitrator
do?
will take a final, fresh decision on his application because this application has not been considered at all. There is no question of being functus officio in this matter.
But
Functus officio only in respect of applications in which the the bodies were served notice and heard.
My lord, I have
Only in those cases.
I have come with the
Not
instruction, my lord, whether notice has been served upon him or not.
You have already filed instructions wherein there is no notice.
My lord, there is no whisper at all. Record নেই। ও দেখে নিতে হবে, না দেখে কি করবো? তার খবর নিয়ে এলাম। যদি থাকে তো দিয়ে দেবো।
Primary issue which has come up for consideration by this court is whether notice of arbitration was served upon the petition. Paragraph learned counsels. You also want to come back with
my lord, some instruction.
learned counsels for the state and the National Highways Authority of India seek to take instructions in this regard. Paragraph, let the matter appear under the same heading on 8th February. Next.
Yes, my lord, I am filing the report. I have served the copy of the report, my lord.
Item 31. Item 31.
My lord, National Highways Authority also filed their report, my lord.
Opposition করা হয়েছে ওদের
Necessary, my lord.
সব বলে report.
My lord, I may be favored with a report, my lord.
Please, why don't you serve copy to the other
কি পারবো না কেন? I've had very bad practice.
কপি দিয়ে দিয়েছি পিটিশন আছে।
আমি তো
ওকে
I
দেবে
am not
থাকতে হবে।
requiring for আমাকে
কপি গুলো দাও না।
report is being submitted to
আমাদের ন্যাশনাল হাইওয়ে একটা কপি
ওটা দিয়ে দিন, কপিটা দিয়ে দিন।
এই কপি কপি
please serve a copy to the National Highway immediately.
My lord,
আমাদের
আজ দিয়ে দাও।
This is not proper practice.
আজ জেরক্স করে দিও।
A report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph learned counsel for the petitioners seeks to use an exception to the report. Paragraph, the matter appear under the same heading on 9th February.
My lord, I shall file exception to the report filed by Mrs. Roy Clark, in H.
Let her come, please.
মানে নেক্সট ডে
কবে থাকবে?
8th February.
9th February.
9th.
My lord, I am appearing on behalf of Asansol Durgapur Development Authority in this matter.
Petition.
My lord, we have filed our respond number 4 West Bengal Housing Board. A question cropped up, my lord, whether it was acquired for public purpose.
I am for the petitioner, my lord. They have given me the supplementary affidavit, my lord. Kindly give me 2 weeks time to find my exception.
My lord, today,
How much time do you require, sir?
my lord, today I am filing the supplementary affidavit on behalf.
Respondent number
Then
4.
extensions were already granted to you.
Yes,
Not
my lord.
exception.
Respondent number 4 given me on.
My lord, I have filed today my supplementary affidavit. Copy already been served.
Grant.
Yes, Miller,
So
kindly
please come back with the
give me 2 weeks time.
supplementary affidavit filed on behalf of the fourth respondent. Is taken on record. Paragraph. Learned counsel for the petitioner seeks to use an exception to the affidavit.
Copy.
Paragraph with the matter and the same heading on 8th February.
8th February. Not 8th February. Millard, 8th February. 2-3 days more, Millard. Next week.
Yes, 13th February.
13th February.
ভালো দিন আছে
Eh? Yes, no problem. Yes. Third. Okay, good.
তুমি ইনস্ট্রাকশন নিয়ে এসছো? আমি কি ইনস্ট্রাকশন নেবো? ওটা রংলি রেকর্ড হয়েছে
Yes.
আগের অর্ডার অনুযায়ী। But in this matter, I am for the petition. Yes, with Mr. Ali. Mother, Your Lordship, kindly say. Last order, Your Lordship, kindly say. Last order, Tara. Probably, learned counsel for the petitioner seek to take instruction in this regard. Actually, it would be not petitioner, it will be state.
Oh.
Your Lordship, kindly see the tenor of the order. But I have got no hands for taking instruction in this matter.
Absolutely.
Mr. Mondal, এসব ভুল order
Lordship, the total fact is the earlier occasion, your lordship's order
জানো আমি সব
steps for payment of the petitioner number 1. So, and in pursuance of the order, the district judge already make an arrangement and prayed for skeleton statement and sanction prayed for the principal secretary judicial department. So at this stage,
না সব
with
order
approval of the judicial secretary, the district judge is ready to pay the amount 1,40,000.
Has the district judge sanctioned the complete statement, furnished the sanction?
Yes.
Skeleton statement.
But Your Lordship, kindly,
It's over.
Your Lordship, kindly just bear me 5 minutes time. Your Lordship, kindly keep. I think, my lord, the problem will not be solved.
That's regarding.
Actually, problem will not be solved unless
আমাকে একটু বলতে দাও না।
four authorities, the head of the four authorities directed to be present before this honorable court. Otherwise, this matter will not be solved. Why I am telling, my lord? Let him finish, my lord. I will take 5 minutes time.
Regarding the others petitioner, my lord, they are entitled as the legal heirs of the original awardee.
Yes.
Original awardee already dead, my lord, and one title suit is pending before the district court. So there was order in past that all legal heirs make an application before that court for payment of their compensation as legal heirs. So at this stage we are ready. That amount already deposited some more or less treasury.
এটা দিয়ে
Pursuance of your lordship's order and or the judicial secretary order, district judge is ready to pay that others petitioner.
It's a lapse deposit, isn't it?
Yes, let's. My lord, Your Lordship, kindly allow me to clarify the point.
On the basis of the skeleton day. But you kindly this document.
18 তারিখের অর্ডারটা বার করো 18/4 এই যে
the district judge has sent this to the principal secretary. How will the district judge pay?
That amount already deposited the treasury.
It has lapsed.
Lapsed.
Then how the district judge can pay?
With approval of the principal secretary, my lord,
Principal Secretary of
judicial department.
how the judiciary. Your Lordship, kindly allow me to submit my, I think the picture will be clear, probably. My lord, just Your Lordship, kindly bear me, my lord. The background of the case very precise. My lord, long back, my lord, for the purpose of the, my lord, the construction of the office of the settlement department in the district of Paschim Medinapur, our land has been acquired. My lord, the acquisition was 1995. 95? Two acquisition was there. One for 64 decimils of land and another for 74 decimils of land. Two awards were parts. One in respect of 19 lakhs something and another is for 16 lakhs something. This is the thing. Now, my lord, my learned friend is saying, yes, my lord, civil suit was there. There is a dispute amongst the co-sharer that has been settled long back. Now that chapter has been closed. Now, in the meantime, the amount was deposited to the district judge. In the meantime, it was lapsed. That is why several correspondence were made by the Accountant General as well as the Principal Secretary of the Judicial Department so that the lapsed deposit can be regularized.
Yes.
Department of Finance was approached, no step, nothing of the sort. Now, my lord, the trial court, the learned single judge, the writ petition was dismissed. Against that, we preferred appeal. The appeal court remanded the matter before this one. Now, your lordship, kindly see the report which was submitted before the division bench, appeal court. My lord, that is on record. Your lordship, kindly see the report. I think, my lord, the matter should be cleared. Otherwise, it will be confused. Mat number, my lord. 835 of 2021. Your lordship has got this report. That was also part of the record as per order dated. No, state authority has. And it was also part of the record. Yes. It was also. That is there. That is in the file. That is in the file. Yes. আরেকটা নিয়ে কি হবে আনসার দাগে দাও now your lordship kindly see paragraph 345 it will be clear paragraph 3 my lord your lordship
Order sheets. Give me a minute, please.
এটা দিয়ে দিন না দেখি আমাকে একটু
একটু দাও তো ওকে দাও তো ও না পড়ে কাদের সে খালি উল্টাপাল্টা করে
এটা কাদের আপনাদের রিপোর্ট
The remand was as there was no private respondent.
No private respondent. Actually, amongst the co-sharer that has been settled. Actually, now your lordship kindly see the have your lordship got the report, my lord, which was submitted before the appeal court.
No.
On the earlier occasion, my lord, I have submitted that was taken on record also. Submitted that was taken on record. জমা করেছি report in the 2nd February 2023 there in the order it has been recorded that on that day we have filed a report.
Oh, this is the yes.
Yes, your lordship kindly see.
Special land acquisition officer.
Yes, special acquisition.
Yes.
Now your lordship kindly see the paragraph 3. I think, my lord, it will be clear once for all. On perusal of such and such,
Yes.
LA case number such and such, notification was issued such and such, and 184 acres. These are the lands were acquired, and thereafter 4, paragraph 4, another declaration, and paragraph 5, your lordship kindly see the paragraph 5.
With regard to all the facts.
No, that is
Not in dispute.
not dispute.
Fact is
No.
not.
Facts
No, just your lordship kindly just to appreciate the thing. My lord, the 2 proceeding and the amount of 19 lakhs and another is for 16 lakhs. These are the amounts which are to be paid.
Paragraph 6, my lord, in the.
Now your
paragraph
lordship
6.
kindly see. Thereafter, your lordship
Question is
kindly
this.
come. Now the reports, 4 reports, my lord, they have submitted. I am submitting your lordship one by one. These are the reports. From the report, it will be clear that the acquisition and the amount which is payable. That is clear. Everything is stated in the report. To cut short this matter, my lord, your lordship kindly just bear. Now, your lordship kindly see the report dated 3rd, my lord, is January 2023. That is in the file. It was, my lord, the issued by the senior account officer, the accountant general office.
It's part of this bunch? No.
No, not bunch. Time to time, the learned advocate, my lord, submitted the report. Report dated 3rd January 2023. That is probably it will be in the file. এগুলা কপি আছে দাও তো পরপর পরপর দিয়ে দিই জজ সাহেবকে তাহলে চটপট হয়ে যাবে
11th August.
Yes, 3rd January 2023.
Not find it.
Well, probably it will be there because the learned advocate, when Mr. Bhattacharya was appearing, Sandeep Kumar Bhattacharya was appearing on behalf of the accountant general. He submitted report. Have you lordship got it?
No.
3rd January 2023. আছে তোমার কাছে? Well, your lordship kindly see. এটা জজ সাহেবকে দেবেন। Actually, it is in the file. He has supplied me. Your lordship kindly see. It was addressed to the district judge. He has stated everything. That the proposal has been made to the finance department. No, 3rd January. 3rd January. দেখো আছে। And taking cognizance of it, my lord, your lordship passed an order.
Taking cognizance of this order.
Your lordship passed an order 18th April 2023. 18th April 2023 order, your lordship kindly see it. 18th April 2023 order. Have you got it?
The judicial secretary was requested to accord special sanction.
Special sanction. Now, your lordship kindly see the special land acquisition officer submitted a report.
Has this special sanction granted by the state?
No, your lordship kindly see still
At this stage not.
no till
Not paid
my
for
lord,
approval.
actually there communication is being made between the 4 departments: finance, land acquisition, principal secretary, the judicial department.
State.
Yes, ma'am.
They have to all are state.
All are the state. That is why your lordship passed an order state authorities. Yes. Now your lordship kindly see the report dated 28 February 2023. This is the report. এটা জজ সাহেবকে দিয়ে দেবেন তো খুঁজতে দেরি হবে। Everything in the file. Your lordship kindly see everything in the file.
Not find any. Why don't you give me a compilation of all these reports?
I shall file it today.
Your lordship kindly see
The hearing to wait.
the special land acquisition officer issued letter Mr. Ansar Mandal and Srilekha Bhattacharya.
কি লিখলো কি লিখলো বলো স্পেশাল ল্যান্ড অ্যাকুইজিশনের আর কিছু আছে
Now your lordship kindly see,
যে অ্যাওয়ার্ড পাস করে দিয়েছে
my lord, they have stated about the entitlement 16 lakhs and 19 lakhs in the first page.
This is irrelevant now.
Yes, my lord.
This is irrelevant. The amount has been deposited. You need to clear the lapse deposit. That is the issue.
Yes, thereafter I will come. Your lordship kindly see. This is the communication, and in that my lord, enclosure there, where from it will be revealed that the a check has been issued and all this thing with regard to the two amounts. Now, your lordship kindly, now, again, your lordship kindly come, 11th August 2023, letter issued by the Principal Secretary to the Judicial Department.
Yes.
That is also in the file.
That is there.
Yes. It was addressed to the district judge. Yes, district judge, Paschim Medinapur. My lord, he has stated everything. Your lordship kindly see. Letter from the initiated physical file for on finance department regard to lapse deposit, but till date no response. Your lordship kindly see.
বার করো না তুমি, আমরা তো দিতে চাইছি, একবার গিয়ে প্রিন্সিপাল
আমার পকেট থেকে দেবো না জজ সাহেবের পকেট থেকে? Your lordship kindly see. Finance department was approached. No step, nothing of the sort.
This letter says that no sanction has been received from the district judge.
No, your lordship kindly see.
The last paragraph. Is addressed to the district judge.
District judge. Now, your lordship kindly see. But here it has been stated that the finance department has not, my lord, taken any step with regard to the lapse deposit. Now,
The district judge has to accord this sanction.
yes,
Then
thereafter,
the next step to be taken by the, has the district judge done this?
yes, thereafter, your lordship kindly see the last report which has been submitted on 18th January.
18th October.
18th October 2023.
18 October.
Yes. Now the district judge, my lord, with reference to letter dated 11th August 2023, and to comply the direction of the Honorable Court, a fresh application refund of lapse deposit in prescribed from with skeleton statement for issuance of special sanction amount of rupees such and such arising out of such and such be submitted an account which is for itself. It was submitted, district judge submitted to the Principal Secretary to the Judicial Department.
1,40,000
What?
only petitioner number 1.
1 lakh, it will not be 1,40,000. Actually, I am entitled to
Because
get
the
1960.
Order was passed in favor of the Sushil Kumar.
And thereafter, your second page, your lordship kindly come. Second page. Second page, the following refund of lapse deposit, such and such. Balance credited to government, 19 lakh something. And date of lapse is 1/4/2001. Such and such, he has enclosed everything. And he has referred to the matter to the Principal Secretary. Malad, this is the
So this is in reply to the letter of the Principal Secretary.
Principal Secretary. If that be the position, well, who will solve the problem? I am putting this question to myself.
So now it is for the
Yes.
Principal Secretary to settle.
Lordship?
The Principal Secretary requested the district judge for sanction. That was sent
Yes.
Lordship.
by the district judge.
Yes.
So now the Principal Secretary says, so that allotment will special sanction order can be issued from this.
Skeleton.
Yes.
Skeleton state.
Unskeleton.
Last
Ache. Actually, my lord, your lordship, just bear me, my lord. This is in respect of Sushil Mollik, in respect of one, not all. It is also an incomplete requisition.
The other petitioners, they
Other
will add up
petitioner,
to 19
other
lakhs,
accounts.
16 lakhs.
With regard to 1960 lakhs, my lord, no whisper, nothing of the sort.
Lordship, at this stage, the long time dispute was there, but according to the district judge already prayed for the Principal Secretary Judicial Department, as well as the Accountant Department, my lord, also said that if the Principal Secretary sanction the skeleton statement, they are after ready to pay the
Entire amount.
All
Two
the
amounts.
petitioners.
Lordship.
Petitioner number 1.
To petitioner number 1.
What about the other petitioners?
Other petitioner, my lord, at the stage, my lord, other petitioners, the legal heirs of the original awardee,
Settled, sir.
Lordship, and that portion of the amount, according to their respective share, that amount already deposit before the treasury as well as the account department. So in pursuance of the order, either other petitioner may pray for payment before the district court. District court, in pursuance of the order, they are ready
according the pay according to their respective share. Or your lordship, if pass any order to pay, the other legal he has to check and according to their share. In pursuance of the earlier order, my lord, earlier your lordship's order only for Sushil Kumar Mulli.
Where is that order? We should talk to the
এটা হয়নি।
Fifth October 2023. 5th October 2023.
With regard to
Lordship, kindly, it appears from the report submitted by the Principal Secretary to the Government of West Bengal that the District Judge Paschim Medinipur, being the third respondent herein, has not furnished the sanction with complete statement of the lapsed deposit concern for release of the compensation amount in LA case number such and such in favor of the first petitioner. In favor of the first petitioner Sushil Kumar Mulli to the Principal Secretary for issuance of statement with special sanction order.
That was in terms of the report.
report,
But the order is in respect of all the petitioners.
all the petitioner. And from their document, it will be revealed that two
Regarding
amount.
all the petitioner, one suit is pending before the district court, my lord.
No suit is pending. Everything is complete. What my learned friend is saying without any instruction. Actually,
Lordship, you
your
can
lordship
ask
kindly,
in favor of the all petitioner, the district judge already ready to pay according to their respective share. Share
Can the district judge pay without the?
with sanction of the Principal Secretary.
Sanction has to go to the office of the they will verify and
সবাইকে দেবে তো?
to the authority to pay.
সবাই তো ডিস্ট্রিক্ট জাজ কোত্থেকে দেবে? ডিস্ট্রিক্ট জাজের কাছে টাকা আছে?
I don't know how can.
How district judge will pay? I don't know. My lord.
Lying in the
Check was
lying in the lapse deposit man.
no, your lordship kindly see. Check was issued.
The district judge will send the complete lapse deposit statement to the office of the principal accountant general.
That has been sent already.
Yes, but that's why if they clarify the situation, then authority will be issued from our end.
You are for the principal accountant?
Yes. The clarification is sent, it will be issued.
Now, because of your internal the complete statement.
Since we are not getting the response from the statement, that's the district.
On the basis of the skeleton statement.
Statement, the statement is incomplete one.
Incomplete.
Earlier occasion, your lordship order passed in as regards the skeleton statement.
Skeleton statement, we cannot.
Obeyed the other, yes.
We cannot.
Earlier
We
already
have to check
granted.
whether any payment has been made earlier or not. We are the authority to check it.
You come back with a 2-page comprehensive report as to how the payment can be made.
Yes.
In respect of two amounts,
In
19
respect
lakhs and
of
16 lakhs.
All the petitioners.
Yes,
Right?
All the petitioner, my lord, but practically difficult, my lord.
two cases.
The one legal here, one competent, the awardee already died. After died, my lord, 3 or 4 person as the legal here. So petitioners say who will get the amount according to the legal here basis. It is the possible, my lord, because the one awardee.
There are 4 persons. How is the amount distributed? How is it disbursed? Will it not be equally disbursed?
Yes,
What is the problem? What is the difficulty?
equally.
পিটিশন নাম্বার 1 কি দিয়ে দেয় তার আপত্তি আছে?
অর্ডার শেয়ারের কথা বলা
ওরা ভাগ করে নেবে। ওটা ইনস্ট্রাকশন নাও।
সেটা তো বলা হচ্ছে awardee.
You are for respondent number 5 and 6.
Yes.
Because final disbursement will be made from your end.
Yes.
তোমরা কাছে তার যদি
Come back with a
ইকুয়াল শেয়ার ভাগ করে দেবে
as to the procedure for disbursement.
এটা করে দেবে।
Because it is only big shifting of the
সেটা
funds.
আপনারা করবেন লিগ্যাল ইয়ার সার্টিফিকেট চান
Other.
চিঠি করুন।
Otherwise, I really have to call all the
চিঠি
authorities.
করুন।
Actually, it will problem will be solved if your lordship direct the head of the 4 authorities to appear before the. Actually, he is playing with the court.
Let me give the learned counsel. a
Actually,
last
they are
chance
playing with the court.
to apprise the court as to what is the exact procedure.
Yes.
Yes.
With regard to the minority, two amounts. One, 19 lakhs 25.
all the petitioners.
Yes.
Yeah, all, yes.
As per their entitlement.
Yes.
They'll be equally shared or as per their entitlement.
Entitlement.
What is the procedure? The district judge has to.
No, district has to send the complete lapse deposit statement to the office of the principal account general. They have, so far they have sent on the skeleton statement. That won't help us to do the work. So unless they send
The
it.
district judge has to send it to the accountant general.
Yes.
Statement of
Then
that judicial sanction.
I'll record your statement. It is submitted on behalf
Eh?
of.
কিন্তু এর আগে তো বলেছিল
Respondent
court says
numbers
যে আমাদের
5
কোনো
and
দায়িত্ব
6.
নেই।
জুডিশিয়ালের কাছে স্পেশাল স্যাংশন
But
আছে।
because
In
Lordship,
order to disburse
Lordship,
the entire compensation in favor of all the petitioners, comma,
আরে টাকা দিতে
the
গেলে মুশকিল,
learned district
অনেক
judge
টাকা।
Paschim Medinipur
Yes.
is required to
ওই যেটা
send
আমরা দিয়েছিলাম
a complete
Lapse deposit statement.
lapse deposit statement.
Lordship,
For the relevant year, for the relevant year.
on the basis of the skeleton, my lord.
No, no, skeleton. No, in, no, your
নেই বলে
no, no, your
There
kindly,
is no Lordship that-
kindly, না যে জেনে শুনে। Your kindly record it in respect of the amount awarded. Two amounts, one 19 lakhs and one 16 lakhs. Your otherwise, my lord, there will be a confusion.
That goes without saying.
Yes.
Awarded amount.
Awarded amounts. Well, your lordship kindly record the figure, it will be better. Otherwise, my lord.
আর কোর্ট যদি দিয়ে দেয় আপনাদের কিছু আপত্তি কি আছে?
Complete lapse deposit statement in respect of.
The relevant years, when the deposit are made.
For, in respect now, for the relevant years, in respect of the amounts.
In, just I am telling, my lord. Your lordship kindly report paragraph 6, it will be clear.
Today's report.
No, that report submitted before the appeal court, division bench. It is their report. Paragraph 6, your lordship kindly quote it. It will be better for future. Otherwise, my lord, again, it will be confusion. Award amount, they have deposited, two miscases are there.
This is the entire amount.
Yes,
So, but this
miscase
amount has
number
been
2,
modified.
1997 for 19 lakhs. Miscase number 6 for 16 lakhs. Your lordship kindly record it.
কোনো অর্ডার দেয়।
572.
Miscase number 2, 1997-98 for the amount of 19 lakhs, 25,000 or, and miscase number 6 of such and such for amount of 16 lakhs, 15,000 or. Subsequently, it has
16 lakh
16
was
lakh.
rectified.
Rectified by,
39.
yes.
In
These are the
respect
two
of
amounts.
The awarded amount
Your lordship kindly.
is 19, 25, 555.94 and
Miscase.
rupees 15, 39, 572.50.
Subsequently rectified. It is recorded.
That's the final
Yes.
amount.
And miscase number, your lordship kindly say.
Before the
Deposited amount.
Lordship.
Miscase number 2 of 97-98 and miscase number 6 of 97-98. Not necessary, yes, sir.
before the
Officer of-
accountant general,
Yes, sir.
before the fifth
Five
respondent,
and six.
before respondent number 5,
Time লাগছে বলুন।
যেটা বলছি প্রথমে পেমেন্ট হওয়ার জন্য।
পয়সা দিতে চাও না আমরা রেডি আছি তা দিয়ে দিচ্ছ না হয় এটা তোমার তো এটা তো
District judge will send to respondent number
Yes.
5.
Yes.
That will solve the problem. That will solve the issue.
Complete statement is there. They will
Complete
check on it.
statement নেই
and
আমাদের
this is
কাছে,
also-
তাই special sanction।
The judicial secretary has nothing to do in between.
If complete statement is not available.
Lordship, complete
then
statement
the-
not as yet available, Lord, due to the partition of the district, Lord. So at this regard, the skeleton is
They cannot act on the skeleton statement. sir.
That's why we have asked for special sanction.
Statement, my lord, then judicial secretary has. to-
on this regard, pray for the
certificate
special
sent-
sanction from the judicial department.
Send a certificate.
Lord,
Certificate to what?
Then
এই যে
prove
check,
the
দুটো
judicial
চেক
secretary
জমা আছে
of the-
যে 19 লাখ
The complete statement is not
15
available.
লাখ জমা আছে
Learned
On the
counsel
basis of
further
the-
submits- Let me record the facts. The procedure.
yes yes
Learned counsel further submits that if the learned district judge is, if the complete statement is not available, if the complete statement, now this is কেটে দিন. If the submits that, if the complete statement is not available with the district judge, the skeleton statement will be forwarded to the,
Lordship, judicial state,
Secretary will forward to.
and
our-
already prayed for you.
the skeleton statement
Skeleton of
is,
the case.
the skeleton statement shall be forwarded by the learned
Regarding
district
pay-
judge to the principal secretary,
Also on the basis that already
Government of West Bengal, who shall verify the same and issue a certificate to
yes, ma'am.
the judicial secretary,
Yes, ma'am.
who shall verify the same and forward it to the fifth respondent.
respondent.
To the fifth respondent.
Hmm.
Paragraph learned counsel for the state respondents submits that
তা নিয়ে নিতে হবে, হ্যাঁ, এক তিন একটা। তিন এক একটা।
a fresh application along with a skeleton statement. This is only for the first petitioner.
You have already addressed to judicial secretary earlier also. They did not.
ওই 3rd January তো? Yes, I have handed over.
Yes.
We have, it's not that we are
এটা আর কপি
This
আছে
would be
extra?
in favor of all the petitioners. This is only for the first
If you
petitioner.
sanction in respect of all the petitioners, do that.
Paragraph, it appears from the report submitted on behalf of the
Regarding claim amount.
it appears from the documents. The documents submitted on behalf of the state respondents that the learned district judge has sent a fresh application along with a skeleton statement for issuance of special sanction order amounting to rupees 1,40,977 in favor of the first petitioner. Stop. The learned district judge is directed to send a similar statement in favor of the other petitioners as well.
According to
Before
the
the-
respective share. With regard to the claim amount, your lordship kindly specify this. With regard to the claim amount,
With regard to the claim amount to the principal secretary,
Yes.
judicial department, government of West Bengal,
claim or sanctioned amount,
Within-
which has been sanctioned.
sanctioned amount.
Within 3 months.
Sanctioned amount.
Actually, it will be sanctioned amount.
Within 3 months.
Sanctioned
It's already sanctioned.
Yes, sanctioned.
Sanctioned amount.
Sanctioned amount.
Within 1 month.
Just in-
District judge can send within 1 month to the principal secretary.
Hello.
Yes.
Okay.
Within 1 month,
1 month. Oh.
district judge will send. Can it be 2 weeks?
It should be. আরে মিস্টার মন্ডল,
হবে না।
কেন হবে না?
রেকর্ড দেখতে হবে।
কি বললাম?
তুমি তো রেকর্ড না দেখেই তো এসেছো।
Within 1 month.
ও রেকর্ড পড়ে না, এসে দুনিয়া যা বলে কি কথা বলে।
যদি করেছি।
1 month অনেক দেরি হয়ে যায়।
অলরেডি তো রেকর্ড বেরিয়ে গেছে
বেরিয়ে গেছে।
Within 1 month from the date of communication of this order. District judge will send within 1 month.
1 month. And the authority will comply this. Again, they will pray for time before the.
District judge will send to principal secretary. Principal secretary has to verify and send it to the,
That will check time.
upon, that will take time. Yes. Paragraph, it is expected that
কাগজ জমা
upon receipt of such application along with statement, comma, the principal secretary, comma, judicial department, comma, government of West Bengal shall take necessary steps for verification of the same and send the same to the fifth respondent as expeditiously as possible. Stop. The fifth respondent. No, stop. It is further hoped that the fifth respondent shall
ফাইন্যান্সিয়াল এছাড়া কি হবে?
endeavor to disburse the amount in favor of all the petitioners within the shortest possible time.
Issue authority of payment. Issue authority of payment.
Issue authority of payment. Shall endeavor to issue authority of payment. Issue authority of payment in favor of the petitioner, in favor of all the petitioners within the shortest possible time.
And matter will appear, my lord.
Yes.
will pray
How
for,
long can it take?
and we will pray for,
Let it appear in the monthly list of March.
not monthly list, Your Lordship, not monthly list, my lord. Yeah, actually, we are fighting for long back. For a long,
I understand, but I really want to solve the issue.
Your Lordship, kindly see, instead of monthly list, Your Lordship, kindly any other day.
Have brought it down to a narrow compass. So let's see now what happens.
But instead of monthly list, Your Lordship, kindly see the next day of the monthly list.
Will you come back in March? End of March?
End of month.
End of March.
আবার বলবে না তো যে ইলেকশন এসে গেছে বল আনসার মন্ডল
28th March.
হ্যাঁ উইল উইল প্রে ফর
How far it will progress?
ইলেকশনে খরচ করবেন টাকা
You can take back your documents.
মানে the letter which has been
It will be useful if you give a comparison of
after having Xerox I will do because I only want ওই 3 রিপোর্টটা দিয়ে দেবেন তো এটা জেরক্স না এটা না 3
বাবা আমাদের
This is my application. I am for DSDA led by Mr. Vianney. He is
But
on
I appear for the Diga Shankar Board on online today, my lord, kindly allows me.
What happened, Balut?
state.
He is online, I think.
Well, state is the answering respondent actually.
Balut. What happened, Balut? The Digha Shankarpur Development Authority. Yes, every service is there. But Balut, there is one difficulty, Balut. I must say this. I have given notice, or also the form says for tomorrow's date.
That's
So,
right.
I should not do it.
Not today in that case.
My lord, it won't be fair.
January. Only one document is there. It should be returned. We return it after having them.
3rd January covers.
3rd January पे दी देबो।
উনি দুটো ওনার কাছ থেকে পেয়েছি রেকর্ডে নেই ওই দুটো ওনার ডকুমেন্ট দুটো ওনাকে ফেরত দিতে documents that you had given. Yes, yes. Let this just be made known.
My lord, if the respondents are appearing,
Find the state. Anyone for the state in this matter? Mr. Vianney, the form says tomorrow's date.
But I followed that. But since it has appeared today, I thought, my lord, I must be present.
Let it appear tomorrow, not today.
my lord, it doesn't look fair, my lord.
Absolutely.
Indeed. Indeed.
Well, let it retain its position, my lord.
Next.
But accurate service be kept on record.
Not today, no order. Accurate service ফেরত দিয়ে দিন, কালকে দেবেন।
তাহলে ফেরত দিয়ে দেবেন?
My lord, before taking to the brief, if your lordship permit me for a 1 minute to recapitulate the provisions of State Execution Act.
Please wait, sir. I have not taken the file. I do not know what is there.
No, I did not notice. Sorry, my lord. My lord, before
Yes.
taking my lord to the brief, I like to submit 2 sections of the State Execution Act.
Have you served the school?
No, yes, I have served. Everybody is present. Received.
The school?
I have given notice. My learned friend for the state is appearing. He is appearing. My learned friend, Mr.
He cannot appear for the school, sir.
There is. I have served.
My lord, the petition is not maintained.
The ground.
Not mentioned on the ground? Yes, I am coming. I know the provision of the State Execution. I know the jurisdiction of the LRTT. Prior to that, I like to recapitulate 2 sections of the EA Act. As per the State Execution Act, it provides that within the mischief period, if some transfer be made by a riot, that will be inquired into under Section 5A of the Act for holding as to whether that transfer is bona fide or not. Let us assume for the time being
the transfer held to be not bona fide.
You are challenging.
No, I am coming. Milord,
I do not want to go into the merits.
no, I am not on that point, Milord. Your Lordship, I am coming under. I am coming. Your Lordship, kindly bear me for 1 minute. After holding the not bona fide transaction, what a notice under section 6 is to be given to the lawyer for exercising a choice of option. Then and only then, after exercising a choice, the land will be vested. This is the proceedings of the Act. Here, what happened? Sometimes in the year October 12, 1953, my forefather executed a deed of Aparnama.
Sir, I repeat, please do not go into the merits of the case. Please show me the order that you have challenged.
Order I have, Your Lordship, kindly come to the order. Your Lordship, I have prepared a list of dates.
I do not need that now. Please show
Lord,
me.
Your Lordship, at page, Milord, order impugned at page, Milord, 92. Page 92 of the brief. Page 92. Well, this is under not the EA Act. This is a Government Grant Act. Settlement of the righty land. The land has yet to be decided as to whether the vested or not. It has not yet been vested. It went up to the Supreme Court. The order of the highway proceeding has been set aside by the special judge. And Milord, kindly take 93, Roman 4. Their order. If it is subsequently found that the subject matter of land is involved in any court case, in any honorable court of law, including WBLRTT, then all concerns shall abide by the order as may be passed by such court. The matter is still pending. No, this is a copy. List of dates.
এটা খুলে নাও ওই চিঠিটা খুলে নাও দিচ্ছ ডিস্টার্ব করছে না তুমি দেখো এই যে 93 দেখো 93 তে
The lease has been granted in favor of the school.
No, for that reason, kindly bear me for 1 minute. The 5-day proceeding was started in 1956. Milord, it was found not bona fide. Then appeal was preferred. Appeal court affirmed the order of 5-day proceedings. Then civil division before this honorable court. Civil division dismissed. Then the 5-day proceedings was affirmed. Again, the Supreme Court was preferred. Supreme Court set aside all the order, directed the High Court to rehear the revisional application on the point formulated by the Supreme Court. After remand, this honorable court, I raised my voice, sorry, Milord. After remand, this honorable court disposed of the civil division case, directing the special judge, that is the appellate forum in the Act, as per the Act, to rehear the appeal in terms of the finding of the Honorable Supreme Court as well as of the Honorable High Court at Calcutta. Then the matter was remanded to the special judge. Special judge, Milord, allowed the appeal, setting aside the order of 5-day proceedings, directed him to rehear, taking the points as has been indicated in the order of the Honorable Supreme Court and also in the order of the Honorable High Court. Then, Milord, hearing was done. Again, the same order, verbatim, the earlier order was passed against that. an appeal was taken before the special judge. Appellate court set aside the order of the revenue officer, passed in the 5A proceedings. Against that, set aside the order and remanded the matter back to the revenue officer. Against that order, 2 revisional applications was moved before this honorable court. One by my predecessor in interest, another by the state. But 2 revisional application was numbered here. Upon commencement of the Land Reforms Tribunal Act, both the matter transferred to the Land Tribunal. Those are numbered. One was 2169 of 2004. Another was 21670 of 2004. Subsequently, in 2006, state withdrawn their transfer appeal. Now that transfer application is pending before the honorable tribunal. Since then, nothing has yet been done. It is still pending. And in view of the order passed by the special judge, the 5A proceedings not have yet been opened, not have yet been decided. During this juncture, this order at page 92 has been passed. But I am asking myself, if the land be not of the government, can the government settle it to anybody else for any purpose whatsoever? That too, my lord, Roman 5 at page 53 speaks. If any court case is pending, that will abide by. That is to be taken into account. Now, admittedly, the electricity is pending. Admittedly, revenue officer's order has been set aside by the appellate forum under the Act. So, admittedly, the status of the land has not yet been decided as to whether the land, the transfer of the land is bona fide or not. It is yet to be decided. In such circumstances, I am to be taken as the bona fide right of the land. So this land cannot be settled.
Unless it is acquired.
Unless it is vested or acquired or something like that. Without recourse of law, this cannot be settled. Because it is not the land of the government. It is the land of mine. So let the land be taken under the due course of law, then settle. This is my case. Well, your lordship knows better.
But it is still pending before the tribunal.
Yes, my lord. Yes, my lord. I got the entire certified copy of the entire electricity with me. If your lordship so desire, I can hand it over to my lord. But I have stated on oath.
My lord, if the matter is, my lord, is pending before the tribunal, how they have filed this application here?
That is a different issue.
That is
Well,
a
that is
different
a
issue.
different issue. That is the issue of the land is whether Rayati land or other land. That is the in the tribunal. He can, that is pending. He must go there.
For my lord, finish.
My lord, that is the procedure. That is the procedural, my lord, misconduct. I must say misconduct. As because, my lord, there is a pending, as my lord, now if we want to say something, my lord, he must go there and say the state is going to this pass this order. That is the forum is not here.
He is not a party to the matter.
He is a party of the proceeding.
Which proceeding, my lord?
The other proceeding, you are a
Yeah,
party.
in a electricity, I am a party. It is my matter there. My lord, what is there? The question arose as to how many times the appellate forum can send the matter back for remand. That was the question there. That is after
Question is 5A proceedings, whether it is in accordance with
not yet been concluded, not yet been opened now, after setting aside. That initial order.
After it was set aside,
No, that's-
after it was set aside, it is pending before the tribunal for consideration, isn't it?
Lord Participant, I could not clear. First order was set aside by the,
Yes, yes.
then reopening, then order passed, verbatim the same order as passed earlier. Against that,
Yes.
tribunal was preferred. That is the appellate tribunal. That is under section order before the special judge. Special judge set aside the order and remanded back to the revenue officer to rehear the matter,
Yes, yes.
take evidence, and decide the matter in the light of the judgment passed by the Supreme Court. Also the High Court. That has not yet been started. It has not yet been given notice also. Challenging that order of remand, 2 revisional application was moved. We challenge that how many times they can remand. Revisional application, they had transferred there. Whether that can be stand or not. Another order was, they also challenged. That also went to the tribunal.
Which order was challenged by the state?
State also challenged.
Which order? That,
That special judge's order
the remand
for
order
remanding the matter.
was challenged by both the parties.
Yes. So both matters were transferred. Subsequently, they have withdrawn their case. Then what is the matter to be decided there? Whether the second remand is bad or not. Let us assume writ application has been dismissed. That electricity matter has been dismissed. Then what will be happen? Then the highway proceeding will be reopened. They will take evidence. They will decide in the matter, in the guideline formulated by the Supreme Court as to whether the transfer is bona fide or not. In the meantime, how they can settle? Under which provision they are settled?
My lord, if your lordship will see page 89.
My lord, that too, your lordship can have a look to page number 52 for a moment. 92 for a moment. Under which act it has been settled, my lord? It is not under section 49(1). It is under the, obviously under the Grand Act. Grand Act, even,
I've seen this.
yes,
I've seen this.
even if the land is vested, then also this cannot be done without the permission or the taking note of the commissioner or land revenue commissioner, as per the management manual. My learned friend is very easy to say this is not maintainable, cases they are pending, they are not known.
Let us hear the state. Yes, Mr.
Lord,
If your lordship page 88.
88.
Yes, ma'am.
Yes.
8. It appears from the record that against the order of the appellate authority in connection with the proceeding under section 5A of the West Bengal Estate Acquisition Act, the writ petition was filed before this court and the same was pending. The said writ application of CO number Ato during the pendency in the writ application, my lord. At that time, my lord, when appeal was filed, my lord, after 5A, that writ petition was, that is the 226, that is the civil division, it's to be filed. They filed the civil division, CO number Ato, during the pendency of the said writ application. The West Bengal Land Reforms and Tenancy Tribunal having been constituted, the matter was transferred to the tribunal and gave the PA number. When the tribunal took up the matter, the writ petitioner took up a preliminary objection containing that the West Bengal Land Reforms and Tenancy Tribunal had no authority to decide the question involved in the matter. It appears from record that the tribunal overruled this such objection and the same breath dismissed the transfer application being TV number Ato. Being dissatisfied, the writ petitioner has come up for Ato. Mr. Bunia, the learned senior advocate, appearing on behalf of the writ petitioner, has fairly considered before us that it was a mistake on the part of his client in questioning the jurisdiction of the tribunal in the fact of the present case. But his grievance is that even if such objection is overruled, the tribunal ought to have entered into merit of the dispute for the purpose of deciding the question whether the transfer was really bona fide or not. The learned advocate appearing on behalf of the state respondent has, however, not disputed the aforesaid submission made on behalf of the writ petitioner and agrees that the next portion is very. After hearing the learned counsel for the parties, after going through the materials, we thus modify the order passed by the tribunal by approving the finding of the tribunal on the question of jurisdiction and directing the tribunal to decide the real dispute between the parties on merit. Since the matter is pending for the last 17 years, we direct the tribunal to dispose of the matter on merit positively within 3 months. We make it clear that is there is a pending, my lord. Now, my lord, if your lordship page 91, if your lordship will see, that is 3rd June, my lord, 2008. Our previous order, my lord, 13/3/2007. What is the conduct of the petitioner, my lord? Now your lordship will see second paragraph, my lord. After that, that is learned advocate for the appellate GR present today speaks for hearing of the Ato. We have perused both the application. We have also perused the order of the Honorable High Court 13/3/7, my lord, that previous 88. While sitting in appeal over the order of the Ato, this tribunal rejected this application. The Honorable Court by the said order has directed to us to hear the matter on merit within a time frame and allow the substitution of the Ato. In view of the order, Honorable High Court and also issue involved in the adjudication, we have reason to hold that the application should be substituted by the author. We accordingly allow the substitution applicant direct the substitution of the petition 1 and 2. Being the legal heirs of the deceased applicant, we direct the office to amend the cause title. We direct the application to file an amended copy of the application author. The application to take step. Let the appear of hearing amended copy. Let the TA number author to appear of hearing 15 to 12.
Still
Yeah.
pending.
No, original application. Original substitution allowed. Now, my lord, original application is pending there. Yes.
Application is
Is
whether-
pending there, my lord. That is the TA number. That is pending there.
What is the original application?
It is, that is the admit.
It is our repeated submission. It is pending till date.
It is our submission.
Application is challenging the order of remand.
Yes.
Whether the court could have.
My lord,
remanded
if
the
there
matter.
is one in tribunal, my lord, if there is pending that application, my lord, whether he can.
What application? That is important. Any application will not affect the writ
As per
jurisdiction. Before the
As per-
tribunal
as
and
per the
application
order of-
filed by the
সেটাই তো
petitioner
বলেছি
is pending.
দুটো এমএ তো তাই হয়েছে
My lord,
রসা বলছি ওনাকে শুনতে দাও
Please show the order again, which is challenged before the tribunal.
my lord, if
Tribunal.
he
Well, I got the entire
he
bill.
has come, my lord, against the substitution application. He has, my lord, 88 and 89. That is the, that order is there, my lord, 13/3/2007. That order is there. What is, since the matter is pending for the last 7, we direct the tribunal to dispose of the matter on this.
Have it disposed within a month. I don't have any objection. That is my prayer also.
That is the, my lord, that original application is pending there. My lord, they must come with that.
What is the original?
Have I not said?
That is, that
Have I, is there any
My lord,
suppression of the fact?
his submission is that, my lord.
there is the application before the tribunal.
What is the application?
Challenged before the tribunal.
I
which is
have,
pending.
I have submitted.
You
I
said
cha-
the order of remand. Please show
but
that application.
they challenge the special court.
The petitioner.
No, I am
challenged the second order of
Special
remand.
court
I have
passed the order for remand. Second time,
that.
we
Where is
challenge that. We challenge that.
Where is that application?
That's why আমাদের সার্টিফিকেট কপি দাও
Which is.
Well, I am giving the entire
which is
copy of
pending
the
before the
entire copy. I am handing over to my lord.
Will you file a supplementary affidavit annexing all these documents? Please file a supplementary affidavit with the applications filed before the, what is pending before the tribunal? The documents, I have understood what is pending.
Because there was two tribunal.
Understood, sir, the documents are required.
Yes, madam.
Please file the documents.
আমাদের সেই কপিটা কোথায় আছে? Annex that order. I am stating, my learned friend also prepared an TA. 2 TA was there.
You say that the state has withdrawn.
That has been withdrawn. Against the same order, 2 TA was there. Because special judge remanded back for the second time.
Yes, yes.
We challenged in one matter, they challenged in another matter. We challenged in 90, they challenged in 91. Both the CO transferred to that in 2004.
One CO was withdrawn.
In 2006, they withdraw their case. That is the,
Where are these documents?
what are these are the entire
Applications and the orders.
tribunal. Remember, I have annexed one order of the tribunal which went before this Honorable High Court is rejecting the first one. That is going to discuss here. I thought it is not necessary, but I got a copy. Your Lordship, kindly keep it tomorrow.
Not tomorrow, I'll fix a date.
Tomorrow, because I will hand over the entire certified copy of the tribunal's order. Monday.
I'll give you a date. Please file a supplementary affidavit.
Annexing that
all
application.
the relevant documents and the petitions. And please hand over a copy to Mr. Dey. He also needs to see.
Yes, madam. In the meantime, some protection is necessary because
Already settled.
and has been settled. They come to take possession. If we prevent,
Jurisdiction.
আর একটু বলে নেই আমি।
হ্যাঁ, বলো তো।
In the meantime, they have come. What is their order? If there be any order case pending, they will abide by. Well, it is their order at page 93. They are to obey that. Their own order, page 93. Well, admittedly, the TA is pending. Admittedly, 5 proceeding has not yet been concluded. Well, how my land can be taken by the government? Well, I am asking this myself, for myself. Well, page 93, Your Lordship, kindly read Roman 4. It is their case. If it is found that there's some case is pending,
Shall I make it only not today?
ये मिला
Shall I make it only not today? Can you?
not
come-
today,
Because yesterday, if the submission is taken into consideration, there has to be a stay on this.
Monday,
Monday. Yes, my lord.
Monday, my lord. Monday,
Monday.
Monday. Because I got.
My lord, at a time, there was pending one WPLT and he has not any authority to come here.
That is on a different ground altogether.
Whatever may be that, my lord, they must go there and take the injunction. That is, your lordship can pass the order, my lord.
That's why I want to see the documents.
Yes,
I want to see the
ma'am.
application which is pending.
এই তুমি এই আমাকে পাতাগুলো দিয়ে
I
দিও।
would like to see the application which is pending before the tribunal.
সব দিয়ে দেবো
একটা কপি দিয়ে দাও না ওনাকে চেঞ্জ করে দাও না
Service.
my lord is keeping my lord on Monday.
Yes, you said once.
I am appeared on behalf of respondent number 7, my lord. Well, the private respondent.
The school.
School. Let it be hard on merit, no problem, my lord. Well, on the, my lord, instead of giving the supplementary affidavit, well, it is to be affirmed. My client is busy for, my lord, 22nd January. So let me permit to bring the copy of the LRTT. Entire certified copy I will hand over, not, my lord, the authenticated copy. I will hand it over to my lord and copy to my lord. Entire I got.
Counsel for the counsels for the parties.
29.
Paragraph. Counsel for the petitioners. No, it appears.
My lord,
Prayer of.
I heard, my lord, on 22nd may be holiday. Can it be on 29th?
29. Next.
29.
29. Top.
29.
But top to থাকছেই থাকবে।
29.
Same position.
Well, with my lord's leave, my lord, I.
On prayer of the petitioner, liberty is granted to produce the certified copies of orders and the applications pending before the learned land reforms and tenancy tribunal.
স্যার আমাদের কিছু হয়েছে নাকি
না
ওইগুলো কি আপনার
Paragraph let the matter appear under the same heading on 29th January.
Same heading,
Same
same
heading.
position.
Matter এ রাখতে হবে।
একটু দিলে
Same position, man.
এটা change করবে, group 1 করবে।
Man, keep it same position.
It will appear as mentioned matter so that it appears earlier.
Check it. Diploma.
Next.
I beg to appear on behalf of the petitioner.
I am appearing for the respondent number 11, my lord. Lordship, kindly see the, my lord, earlier order.
Lastly, your
Lordship, kindly see the earlier order dated, my lord, June 26. Well, there is a, my lord, preemption case on the self-same cause of action was filed by the first petitioner against, my lord, my client, private respondent, my lord. And, my lord, I produced that document. An order was passed, my lord, by that.
First, my lord, first I tell your lordship
So
that
there
is,
is appearing in
my lord, in this case, my lord, the preemption application does not lie here. My lord, learned trial judge rejected the application on the ground of co-heirship. That is, my lord, the separate issue which has been, my lord, raised by my lord, friend's kind. And my lord, the section,
same property.
no, but the property is different. My lord, kindly see the page 20, the annexed chart, which has been, my lord, the sketch map. That is the annex, my lord, the page 20. That is the
For
petitioner.
encroachment on PWD land.
PWD land. That is, my lord.
Where is the document?
That is, my lord, the complaint has been raised my client, my lord, the 25th April 2023. That is page 20. And sketch map which has been dealt with, my lord, they have been given. That is page 23. That is annexure A, my lord, that is, my lord, the petitioner's land. And B, my lord, PWD land. This has been, my lord, encroached by the private parties. Page, my lord, the page come to page 20, the annexure P4. This has been complaint raised before the, my lord, assistant engineer PWD Hooghly subdivision 1, PWD Sen Road, Sodor Hooghly at Chinsura. Demand justice for taking necessary action as envisaged under section 10 of the West Bengal Highways Act
The demand of justice.
Demand of justice.
What is your representation?
Representation, my lord, the representation separately has been complaint of this has been, my lord, annexed. And lastly, my lord, that is page 16. Page 16 is also the complaint. Annexed P3, that is 22nd.
Case was filed by you. The
Filed by me, my lord, that application was rejected on the ground. My client has deposited the impugned deed consideration that has been refunded and it has been proved before the judge. This is not the co-Sierra land. This is not the adjacent land. So the application has been refused by the trial judge.
So Lordship, kindly see the order, my lord, of preemption and my lord plain.
That is different issue.
Land
This is
of
the brother's land is a different chapter. Co-Sierra land is a separate cause of action.
Same cause of action, my lord.
It
Lordship,
is a
kindly see.
different cause of action. How the preemption is lies in here.
Order to write it.
I have also copy, my lord.
No, that is plain, and my lord, also order is there, my lord.
This is order 18 rule 4. Where is the petition? Here's the schedule.
I have a copy, my lord, the petition.
It's there. It's there.
Watch it.
Yes, this is RS plot number 759.
759, that is my joint Sadhukan, that is page 23. That 26.25 shatok of land. It is my lord the petitioner's land, and private party has my lord the constructed in the front of the public road. That is my lord the
The schedule is different.
schedule is different.
This is the land. The construction alleged is in front of the land, not this land. So this doesn't help you, sir.
No, my lord, Lordship, kindly check. May I check it?
Yes,
May I take instruction, my lord? My lord.
necessary. This is very clear. Do you have a representation pending?
Yes, man.
Where
That
is
is
it?
that is
Not
my
the
lord,
demand, the representation.
representation. That is my lord page 16. Page 16, annexed P3. That is 22nd March 2023.
This will be heard by the authority?
Yes, my lord.
And the private respondent will be given an opportunity.
Yes, ma'am.
Of hearing. Yes? You're
Yes.
given an opportunity of hearing, you can place your case before the authority.
Yes, ma'am.
Third learned counsels for the parties. It appears that the preemption case referred to in the earlier order passed on June 26, 2023 is in respect of a private property, whereas the petitioners allege encroachment of a portion of PWD road in front of his property by the private respondents. Paragraph. The petitioners claim to be the owners of the plot in question and complain that the private respondents have encroached upon a portion of the PWD road adjoining their property by raising unauthorized construction therein, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation in this regard before the concerned authority on 22nd March 2023, which is yet to be considered. Stop. The petitioners. No, the presentation. The petitioner submitted an application under Section 10 of the West Bengal Highways Act for representation category. The petitioner submitted an application under Section 10 of the West Bengal Highways Act 1964 before the authority. The petitioners pray for a direction upon which is yet to be considered. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Application at the earliest. Paragraph. Learned counsel for the state respondents submits that the second respondent be directed to consider the application in accordance with law. Paragraph. In view of the above, the writ petition is disposed of directing the second respondent to consider and dispose of the application submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons including the petitioners and the private respondent, comma, in accordance with law. Disposed of. Wait a minute. You can take back the documents. Next.
দিয়ে দাও, এটা দিয়ে দাও তো।
I am for
দিয়ে
the
দাও না,
petition.
এটা।
Land is
File activity opposition in this matter. The lordship of directly file reports and because there is some. We want to file activity in opposition.
Report will not do.
Some.
No. On twice, your lordship
Yes,
requested
my
Mr.
lord.
Dev.
Five files. After that, my lord, it was stated that activity in opposition is necessary for this case. I took time, my lord, on the previous.
Private purchase matter, why?
Yes, my lord, as because, my lord, there is something.
There is something manipulation.
Only the top.
Learned counsel for the state respondents seeks to use an affidavit in opposition in this matter. Paragraph affidavit in opposition to be filed within 2 weeks. 2 weeks. Within 2 weeks.
Activity in opposition, my lord, next week is totally bad week. My lord, minimum 4 weeks, my lord. And because, my lord, there is something.
Within 4 weeks from date. Stop affidavit in reply, comma, if any comma be filed within a week.
Within a week.
Within a week thereafter. Paragraph, let the matter go out of list for the time being, liberty to mention.
Opposition, affidavit in opposition by the state.
Yes. If, do you also require?
No. We,
They are user.
state is the state's notification, they consented to sell,
Construction of a, yes.
they
It's a-
consented.
After that, I don't know why. Anyway, let me see the.
leadership prize, my lord.
কি বলতেছিল?
Original site, division bench, new application, item number 1.
This matter, my lord, may I have the permission to speak first, my lord? Because, my lord, a direction was passed by your lordships to put in an affidavit.
My application, my lord,
I have not been able to file that, my lord. But I'll seek an extension, my lord, kindly.
No, I'm sorry, my lord. I generally wouldn't oppose Mr. Ray, my lord, but this is a matter where, my
I
lord,
have my ways of arguing why it should be allowed, my lord. Yes, my lord, kindly, my lord, because
No,
I have
I'm
the
opposing, my lord. I'm opposing because, my lord, here it was a question of an interim order on last occasion, my lord. I wanted because the whole purpose, my lord, will be now, my lord, defeated. He can't, my lord, go on. It's very difficult to get my lords to, my lord, by natural reason, specially constituted bench. He can't take it so casually.
Also.
Yes.
My lord,
My application as a
You are one of the proposed intervenors.
Yes, my lord. I am my lord Kanti. I'm one of the contributors.
There's another proposed intervenor who filed an application, who proposed to file an application. I believe, not filed.
I have
my
already
lord,
filed.
this intervener, my lord, is an alter ego, my lord, of the company in liquidation. My lord, there are, my lord, orders with pass, my lord. This is only to, my lord, try and stall. My lord, the question of, my lord, a property, my
I
lord,
have a
which has
question
been,
of maintenance of the application.
no, then
Because
you are
whatever he's
I'm
arguing,
willing to
but
argue.
may I?
My lord, I'm
Whatever
willing
he's
to argue, my
arguing,
lord,
my
my
lord,
application,
my
my lord,
lord,
I'm asking for
my
vacating
lord,
of an
he
order.
cannot because
My
he
lord,
doesn't
can
have
you
the
hear me?
Lokas. Because he's bound by the order of the division bench.
That's
When
what I've asked for,
no,
vacating.
no, not that, my lord. My lord, that's what I'm saying, my lord. He was bound by the division bench order which went up to the Supreme Court. And there it got finalized.
Judge,
So he did not say anything about
I'm
the
relying
Supreme
on
Court.
that. I'm
He did
relying
not
on the
say
order of the
anything.
Honorable Supreme Court
Becomes
to
a
say,
res
my lord,
judicata.
my lord, I'll tell my lord what is.
Clear case of res judicata. But that is
It
fixed,
was,
my lord.
my lord, my appeal, where my lord, this order was passed, and my lord, in my appeal, my learned senior friend has taken out an application for vacating of the order. That is the situation.
Come up with an affidavit.
Yes, my lord, I wanted to, my lord, I am out of time, my lord. I'm also praying for
Last order
I'm out of time.
23rd November order,
I,
sir.
I do realize, my lord, it's my default, my lord.
My lord, may I, my lord,
I
just try and
cannot-
explain what the matter is? My lord, I'm for the restriction of 2 multiple fine, my lord. I'm ICICI Bank. My lord, there was, my lord, a property, my lord, in Waldy, my lord, which was, my lord, mortgaged to me. My lord, this is, my lord, they say, my lord, it's a company, my lord, which is, my lord, one of the associates of, my lord, Dunlop, which has gone into liquidation. But, my lord, the property was transferred and then, my lord, mortgaged to me. I've given, my lord, security, my lord, and, my lord, money, my lord, was given. My lord, the matter traveled up to the Honorable Supreme Court. There, my lord, there was an order, my lord, which I'll show, saying that, my lord, I am permitted to go ahead with sale of the property. And, my lord, I was asked, my lord, to give a bank guarantee, my lord, for a bank guarantee, or, my lord, 520 crores. Then, my lord, I'll show another order whereby, my lord, it was released. I was permitted, my lord, have, my lord, sale of the property. My lord, I have, my lord, now, my lord, sold it, my lord, whatever way I've dealt with the property now, my lord, as, my lord, it's a security asset, my lord, so far as I'm concerned. Then, my lord, in a subsequent proceeding, my lord, the division bench of this honorable court, my lord, again said there will be a stay, my lord, with regard to dealing with the property.
Yes.
Now, my lord, that is the order which I'm agreed by, and, my lord, I've come up, my lord, for vacating of the order.
But
Then, my lord, I also, my lord, said, my lord, that because, my lord, this property, my lord, my lord, advertised it several times, there was no one to take it. So I, my lord, myself taken it. Now, my lord, I can't hold on to the property. There's, my lord, Reserve Bank direction, my lord, that I can't hold on to the property beyond a certain period, my lord. That period has, my lord, already expired. I got, my lord, 1 year extension, which, my lord, will also expire, my lord, this year. So I, my lord, made this application. The whole purpose, in November, my lord, will recall, my lord, I had pressed, my lord, for vacating of the order. Quite naturally, my lord said, you can't have it on the first day. And that is why, my lord, directed, my lord, gave them
3 weeks time, my lord.
My lord, given to them. Kindly see, my lord, the last order, 23rd November 2023. Yes.
It was given.
No extension has been sought for. Now, my lord, when the matters come up before a specially constituted bench, my lord, they come up and say, again, we want extension.
The difficulty, because since
Yes, my lord, it's not a regular bench. And my learned friends are aware of it. Well, it's a specially constituted bench, my lord, for taking up this matter. And it's only, my lord, to delay the whole purpose. Kindly, my lord, I want the order to be vacated, my lord. My lord,
The next week, I'm in some personal difficulty. Kindly give me 2 weeks, my lord, I'll file.
My lord, I am, my lord, opposing, my lord, this, my lord, any grant, my lord, because I understand, my lord, generally, my lord, gives, but in this matter, my lord, I'm praying, my lord, that the interim order.
this direction was given, so let them have another.
Well, I'm very grateful.
My lord, they can't, my lord.
It will be ready by.
Yes, yes, well, definitely.
Serve advance
My lord, I, for my side, my lord, I'll do it definitely. My lord. Definitely, my
Lord,
lord.
as far as my intervening application is concerned, my lord, I appear for the contributory Kanti commercial, my lord. Now I am interested in this matter because, my lord, I have filed a review application
I have filed a review application which is pending before coordinate bench of this honorable court from the order dismissing my appeal, admitting the winding up. So, my lord, here whatever is being done, my lord, whatever property is being sought to be alienated or brought back, this directly affects my rights as a contributory. And all that I have sought, my lord, is they give me a copy of the application, and then your lordship adds me if your lordship.
Done only when your application is allowed.
Yes, yes. So that if your lordship kindly see
Lord,
the reliefs, my lord, all that I've.
I don't have a copy of the application, my lord, whatever has been, my lord, and he is, my lord, only.
I also don't have, my lord.
No, no, it's
I
not
have
been
served-
served.
I have
My lord, this is the
served
whole
people-
tactics, my lord.
I
Kindly
was
see.
not being served.
My lord,
I have served
specially constituted page.
I
My lord, they come up, they don't serve.
have affidavit of service which shows service on a bank. If a bank says he's not received it, the affidavit of service shows service on a bank. No,
One
this
bank
is-
is served, Kuruj.
Yes.
Have you also
Show me.
received it?
My lord, I have not received also.
Well, I'll hand over here and now. I have no
No,
problem.
that's not,
Hand
that's not the point, my lord. He says, my lord,
I have received.
Hand over.
I have received, my lord. I have received,
Please
my lord.
serve copies.
I am giving I'm handing over here and now. I have extra copies. I'm handing over here and now.
Shall we take this up on because this has to be heard first?
Yes.
My lord, on the
I'll give an affidavit.
next day, my lord, then, my lord, because I was, my lord,
concerned.
my humble submission is, my lord, that kindly, my lord, if my lord is adjourning the matter, kindly give the shortest possible time and let them, my lord, file affidavit. If they don't file, kindly, my lord, take up my application. Whichever way, my lord, it is good, bad, indifferent, my lord, kindly, my lord, decide on this application.
Has to be taken up first.
Yes.
Well, on the same day, my lord. And my lord, this my lord, intervention application made by Kanti Commercial, who is, my lord, an associate company of, my lord, the company in liquidation.
I
It's
said
all, my lord, set up by the
I
promoters.
said contributory, my lord. That is
All
what
set
I
up by the
noticed.
promoters.
I'm admitting.
And
it's
a contributory, my lord, has no right, my lord, to the property, my lord, of, my lord, and this is not even the property of the company.
We'll deal with it.
My lord, if they,
Let all these matters appear on the same day. Since we don't sit regularly.
Yes, my lord, that's one of the. And my lord, directions for affidavit, my lord, my only request is can you, my lord, make it peremptory? Otherwise, my lord, next year again, my lord, will find, my lord, the same situation where they'll come up and say.
Yes, yes.
Be ready on the next
But
day.
I'll,
And please serve advance copies. I
definitely, my lord, definitely. But I have to, or else he won't be in a position to give his reply.
So if that is filed on the next day.
No, I'll, on the direction date, my lord, I'll file. No, I will definitely.
Learned counsels for the applicant and the first respondent. Seek extension of time. to use the application opposition as sought. Paragraph
কি আছে আমার এই করে দিন অন্তর তাতে লিখে নেই
2 weeks.
2 weeks মানে 2 weeks
Be filed within 2 weeks from date. Stop affidavit in reply, comma, if any, comma, be filed within a week there.
Yes, my lord, yes.
A week thereafter, comma. Let the matter, along with the intervention application, appear under the same heading on.
Lord, Lord, intervention also, my lord, will file affidavits, my lord, so that, my lord, on the next day, my lord, there is also no question, my lord, of.
reply
You are the applicant in this matter.
I am the applicant, my lord, and yes, my lord, and this is ACO 3 of 2023, my lord, I am the applicant.
I am the applicant ACO 4. The intervention is ACO 4.
The applicant in ACO 3 of 2023 seeks to use an affidavit in opposition to the intervention application. Therefore, let the matter. Under the same heading. Eighth February.
Will be.
8th February.
8th Feb.
very grateful to you lord.
Exchange your reference.
Definitely.
Yes. Grateful.
My lord. Grateful.
Mark it.
I'm grateful.
Grateful, my lord.
Under complete circumstance, I am mentioning the FCI matters. What happens, Your Lordship, remember? Yes, Your Lordship remembers that Your Lordship has been pleased to release all the matters on 13th December. Now, thereafter, they filed application for recalling of the order. But the application, Your Lordship, they mentioned several times. Your Lordship didn't allow them for listing. Well, I went there for mentioning the enlistment of the matter before the regular bench. Well, they said that the application is pending, but regular bench says, kindly dispose of the application, then I shall take up. You'll also kindly make the applications be listed on Thursday. Now you'll also dispose of. But I'm giving the slips. I'm giving notice to all. The notice is.
Withdraw the application. It will be dismissed in a line, sir, because I have released.
That is also. Well, all the numbers are there. Well, the mentioning list notice also.
Next Thursday.
On Thursday, well,
Application next Thursday.
I'm grateful to your Lordship. I'm grateful. Number notice does last. I'm grateful to you.
Any other mentioning? Original side, single bench to be mentioned, item number 1.
Item number 1.
No, affiliate side,
Your Lordship, in item number 1, I am for the petitioner. This matter has come at my instance. Your Lordship, initially by an order of 7th April 2022 was pleased to appoint a special referee to ascertain the mean profit as well as rent compensation and other charges, Your Lordship. Subsequently, by order of 31st August, the time to file report of the special referee was extended till 31st of December 2023. Your Lordship, a hearing has been concluded. What I am humbly beseeching Your Lordship to extend the time to file the report by the special referee by 28th of February 2024.
Did you communicate to Mr. Sengupta, the special referee?
Yes.
Because it is over. Only the report.
Only the report has to be filed. So hearing has been concluded. I have filed my notes of argument. My learned senior friend will submit his notes of argument. So after filing of the notes of argument, the report will be. So for precaution measure, I am praying for 28th of February, 29th of February, till the end of February.
I don't have a doubt.
Learned counsel for the petitioner submits that the special referee, Mr. Sengupta, former learned advocate, as advocate Smalley, has dealt with the matter and has heard arguments.
Lordship.
And has heard arguments canvassed on behalf of both the parties. Stop. The report is yet to be prepared. Learned counsel seeks further extension of time for submission of the report. Paragraph in view of the above. The time for submission of the report is extended till 29th February 2024. Copy of this order is made over to Mr. Sengupta, former special referee, at the earliest.
24 match.
Yes.
Court applications under Article 226, item number 2.
Lordship, item number 2, I'm for the petitioner. Lordship, I apologize. I have had to pay for accommodation on a number of occasions. Lordship, Mr. Jain Manna is the advocate on record in this matter. Lordship, he's an octogenarian and he had to undergo a bypass surgery and he's not in the position to come to court, Your Lordship. Yes, Your Lordship. And we have not been able to contact the client either, Lordship. Yes, Lordship.
As a last chance, I'll dismiss the matter on the next occasion.
Kindly put it in the monthly list, Lordship. He's not in a position to come to court either.
Counsel for the petitioners seeks further accommodation. Paragraph, as a last chance, the prayer is allowed. Paragraph let the matter appear at the same meeting in the monthly list of February.
Grateful, Lordship.
Item number 3.
State respondent.
My lord, 3 appear for the petitioner, my lord. My lord had the occasion to hear this at length, my lord. Remembers this, my lord? This is
Mr. Ghosh is appearing for the Kolkata Municipal Court. Petition is there, and my lord, he is on leg before my lord just.
My lord would kindly recollect. My lord would kindly recollect, my lord.
Who is the proposed intervener?
The KMC is a beneficiary.
Beneficiary.
report file হয়ে গেছে
My lord, may I indicate, my lord?
supplementary
Supplemented affidavit was the.
Affidavit is, well, on last occasion I have filed it, and I have served also upon.
exception দিলে দিয়ে দিন
My lord, may I, my lord? My lord, this application for intervention addition of party was filed. This was heard at length before the vacation, my lord. It was your lordship's desire that.
আপনার নাম
Yes, and this was heard out at length. I relied upon 2 judgments, my lord, one of the Supreme Court, one by our Honorable Court, my lord, which says the beneficiary has no manner of any, my lord, interest in so far as the arbitration is concerned. My lord was of the opinion that the beneficiary would not be heard. But at the instant of the state respondents, my lord, the matter was adjourned.
Arbitration
11th.
হবে না,
The
arbitration
11th,
হবে
there was a resolution.
arbitration
We did not appear. We didn't appear, my lord. But we see from a supplementary affidavit, my lord, which was served upon us, we see that a liberty was granted by this honorable court, my lord, to the KMC to affirm a supplementary affidavit. But I am only on a point of law. They cannot be heard. Yes. My issue before your lordship is, my lord, the KMC being a beneficiary cannot be heard, my lord. I am, my lord, fortified by 2 judgments, my lord, which I had placed on the last occasion, my lord.
My lord, here.
In a position to counter your. Argument.
But this matter was heard out at length, my lord.
Yes.
But he has to come.
Yes, to come.
KMC advocate.
This time and again for the last 3 months we are trying, my lord, kindly seize the records. It's either this way or that way, my lord.
Will you come back next week?
Next week.
I can come back, my lord, but this is continuing for quite some time. My lord, kindly seize, my lord's records.
আমি থাকতে
I understand, but 25th next week. Please be ready on the next week, sir.
My lord, kindly makes this, my lord, indicates this in the order, my lord. This is peremptory, my lord.
Next Thursday, some problems is here. Next another week.
My lord, I usually do not object to this, but this is going on. Just like playing dice with the court. One day the KMC comes with the adjournment, my lord. The other day the state comes with one.
Very well. 1st February, but.
First February.
First February.
Kindly makes a peremptory, my lord.
Care of the.
রেমিটারি কি আছে কিন্তু চাকরি ম্যাটার থাকে আর কি আছে
Proposed intervener, the matter is adjourned. Paragraph let the matter appear under the same heading on 1st February.
I'm grateful, my lord.
Item number 4.
The reply.
I'm grateful.
I would request you to assist me with written notes of argument. It was heard long back.
Yes, we'll, my lord, also, my lord,
in fact I have already concluded my
my lord, I'll quickly, my lord, just briefly, my lord, or rather briefly, my lord, remind my lord what was the issue and what my learned friend had argued also.
ম্যাডাম KMC has finalized.
Lord, there's a lease deed given, my lord, by WBIDC in favor of, my lord, this company, my lord, which went into insolvency, not called SS Ramsarup, sorry, SS Tomrai. Or a Ramsarup Industries, my lord. It has a unit called Ramsarup Lohodyog. The lease was in its name, but my lord, it has to be, my lord, in the name of the company. My lord, this company went through a resolution process, and my lord, a resolution plan, my lord, was approved, my lord, by the National Company Law Tribunal. WBIDC was part of, my lord, the Committee of Creditors. And that is very important. As financial creditor, my lord, they were part of the Committee of Creditors. I had shown, my lord, the judgments of the NCLT, NCLAT, and the Supreme Court, where, my lord, the plan was approved, to show that we had wanted to back out from this plan, or rather we said, not back out, that's not the right expression. We said that, look, the plan, this is the amount of money which we are going to invest to have this company resolved. Under the we cannot pay any additional, or there can't be any question of any additional extra transfer fee from WBRDC. That was one of the argument which we made, that was negative, saying that no, there is no question of any payment by to WBRDC. The plan, my lord, was approved, my lord, first, my lord, by the NCLT, my lord, in, my lord, 2019, my lord, that's 4th September 2019. Then, my lord, it went up to the NCLT 4th March 2021. These dates, my lord, are very important. Then, my lord, finally by the Supreme Court on 4th May 2021. Thereafter, my lord, the demand was made, my lord, by now, my lord, WBRDC in, my lord, 2022. Right? On, my lord, 26th April 2022, demanding a transfer fee. Now, my lord, 3 points, my lord, we had taken. My lord, first is that all these were issues. I did not, my lord, say, my submission was not, and my learned friend perhaps, my lord, has misunderstood my submission. I did not say that they have specifically held that no, you're not supposed to pay transfer fees. I says this was an issue. And you knew at that point, no question was raised with regard to that you have to pay transfer fee. On the contrary, they had submitted that no transfer fee. Why are you getting out of the plan? Because there's no transfer fee. On that basis, my lord, the plan gets approved. My liability, my lord, is limited to what, my lord, I'm paying, which is upfront. I cannot be then, my lord, under the law, my lord, as it stands, I can't be, my lord, then, as a result of the insolvency, be burdened with additional liability, which was not there. So my first submission was, my lord, by reason of the approval of the resolution plan, my lord, there can be no further liability on me with regard to transfer fees. That's, my lord, my first submission with regard to the effect of the IBC and the resolution plan. My lord, second, I also showed that this was, my lord, the lease with, my lord, the corporate debtor. And in terms of the subsequent policy, if there is a transfer, there is a question of, my lord, paying a transfer fee. Here, my lord, there is no transfer. The corporate debtor still exists. So also, my lord, on the basis on which they claim, that also, my lord, they could not, my lord, claim. That was one of my second submission. Which is, my lord, they rely, my lord, a policy of 2012 to say, my lord, that they could charge, my lord, transfer fee. And third, my lord, my submission was that this was one of the demand which was made subsequently, my lord, knowing all this situation, my lord, with regard to could not have been made. That is why, my lord, the challenge, my lord, to the demand itself. Now, my lord, quickly, my lord, just to answer, my lord, my learned friend's point, my lord, in the NCLT order, my lord, kindly come to, my lord, at page 212 is the order.
Volume 3.
Volume 3. And my learned friend, my lord, relied on, my lord, these paragraphs to say, as if, my lord, I have, and he used, my lord, very strong words that have trying to mislead the honorable court. Perhaps, my lord, that kindly come to, my lord, 212, my lord, starts at, my lord, the actual order, my lord, is at 222. And kindly see, my lord, 222. Kindly see, my lord, first 222. The appellant in this appeal is the successful resolution applicant whose plan is approved by the adjudicating authority. So I had appealed. Adjudicating authority by the impugned order. Appellant has challenged the impugned order only to the extent of not allowing the terms contemplated in clause 15.15.5 of the resolution plan, thus making the interplan unviable and unfeasible. Then, my lord, kindly see paragraph 4. The appellant has in clause 15 a plan as part of the additional terms of the plan, inter transfer of the lease of 315 acres land lying in Kharagpur granted by West Bengal Industrial Development Corporation, my learned friend clients, to Ramsarup, the unit of corporate to the respondent 1, Ramsarup Industries Limited, being the corporate debtor. It's only, my lord, a unit. So the transfer was really, my lord, and we were making this point, without the payment of any fee, consideration or premium or areas of lease of rent or penalty or interest. However, the adjudicating authority has in its impugned order failed to sanction the same. Consequent to the refusal of the adjudicating authority to sanction this term, this is my contention. Appellant will have to incur an additional sum of 40 crores towards transfer charges as well as area lease rent, penalty and interest, which shall result in increase of outflow of the appellant's successful resolution from 400 crores, being the maximum sum the appellant had agreed to pay under the approved plan, to beyond forfeit, thus rendering the plan unviable and unfeasible. This was not my contention, and this was rejected. Now, my lord, kindly come to paragraph 21. Page 231. Extremely important, my lord. Kindly see their stand now and their stand then and their stand now. The learned counsel for response number 5, WBIDC submitted that the appeal is misconceived and premature. The appellant has neither any actual cause of action nor is aggrieved by the impugned order in any manner. The appeal is entirely premised on the appellant's apprehension that it may have to incur additional expenses, provided it has to comply with the statutory obligation under the resolution plan. Then, can you see learned counsel for COC 22? He is also part of this. Contended that the waiver from payment of transfer penalties and areas are payable under the sublease deed as sublease right of the Kharagpur land was granted by the WBIDC to one unit of the corporate debtor, namely Ramswarup Lohodyog, which was merged with the respondent by number 1 way back on September 18, 2008. Next line, very important. Therefore, there cannot be any requirement of payment of any transfer fees as contended in the absence of any transfer. Accordingly, the objections raised by the appellants are untenable. Lease deed entered into between WBIDC and the corporate debtors unit does not contemplate any transfer fees. WBIDC, being a member of the committee of creditors, was aware of all the terms and conditions of the plan and had therefore voted in favor of the plan. Accordingly, it is now stopped from claiming what it already waived in the plan, which has even received the adjudicating authority's approval. Then, my lord, I'll just read, my lord, this paragraphs which I want to, and then, my lord, I'll come back, my lord, to. Then, my lord, kindly see 23. My lord, this 40 crores, my lord, is nothing there. 24. It is pertinent to mention that the above mentioned claims from WBIDC are an afterthought, and the same was raised after the appellant apprehended transfer fees payable to the tune of 40. It is also important to mention WBIDC, being a financial creditor, has not raised any of the claims mentioned above before the resolution professional or the adjudicating authority. In fact, WBIDC voted in favor of the resolution plan without any comment about such claims as stated here and above. Same is an afterthought, quantified and submitted only its written submission dated 29 July 2020, and they were never placed before the resolution provision. Further, WBIDC only placed its claim before the COC regarding security charges, which has been approved. Considering the above, clear that WBIDC claim is an afterthought, barred by estoppel waiver. No consequent claims are to be considered. I approve that. This is, my lord, paragraph 24. Then, my lord, kindly come to paragraph 26. Thus, in view of the above, appellant or WBIDC cannot be permitted to disturb the resolution plan on the basis of mere apprehension of the additional cost of erroneous and subsequent claims, which an afterthought the same could be against the object of INB court. Therefore, the principle laid down in the above mentioned cases, which has been relied upon by appellant and WBIDC, does not find a place in the premises discussed. That not applicable to the facts of the case. Now, my lord, let's see, my lord, what the conclusion, my lord, this in paragraph 29 it starts. 30. Paragraph 30. Paragraph 30, my lord, page 236. Just 3 paragraphs, my lord, I'm going to show as per clause 15.3, 15.12 and clause 15.44G of the resolution plan. If the waiver sought are not granted on the or the assumptions made are not true, it will not have a bearing on the successful implementation resolution. COC has approved the resolution plan fully aware of this clause in resolution plan. Further, the adjourn has not in any manner mandated or directed SN, which is me, SS National, to make payment of transfer fee, consideration, premium, areas of lease rent, penalties, interest, any other payment to WBIDC. Then kindly take paragraph 36. 238.
Yes.
Regarding the objection of the appellant, in context with the transfer fee of Kharagpur land, it is important to mention the Ramswarup Lohiya is merged with the corporate debtor on the appointed date, that is 1st April 2007. The lease of the Kharagpur land has been granted in favor of the corporate debtor with a indenture of sublease, which was executed on 13th September 2009 after the merger. Therefore, when providing the lease, corporate debtor was the legal entity and Ramswarup Lohiya was merely its unit. The successful resolution applicant SSN's allegation that it has to pay an amount higher than 400 crores is neither established nor borne out from the record. No calculations of facts have been provided to establish the amount higher than 400 crores are required to implement it. Now, the whole purpose of the NCLAT order and why I showed it is, we went on an apprehension that I have to pay transfer fees. To that, WADC said, no, this is premature, no question. COC said, there's no transfer because the lease still subsists in the name of the corporate debtor itself. So, because the corporate debtor now is a resolved company, as they say, under the IBC, and it has been resolved by me, it doesn't mean that there's a transfer. So the purpose of showing the entire IBC proceedings to show that this was an issue raised, it was negated against me. And I've shown WBIDC submission. They come and say premature. What do you? COC says no, it's not a transfer. So when you want the company to be resolved, you make one kind of submission to take advantage of the process. As soon as the company is resolved and you get the money, because WBIDC is a financial creditor. So as a committee of creditor, they get their money, the portion of money which they're supposed to get. As soon as you get your money, and after the plan is sanctioned right up to the Honorable Supreme Court, then in April 2022, you raise this question of transfer. This is what we have said on the question first point, that you cannot. And that is why the NCLAT order is their submissions, and what the law is binding on them. Now the next, and the lease deed will find is at page 29. Lease deed is at page 29 of this is in the first volume. Well, I mean, argue question.
Yes.
Well, page 28 it starts. And I'm reading with the greatest respect. I'm not understood what is this point with regard to transfer fees. Because we'll see, just kindly look at page 29, we'll see it immediately. Page 28 and 29. Indenture of sublease 28 made this 2nd day of September 2009. Mine, it's a 9 between West Bengal Industrial Development Corporation, sublessor, and C's of one part, and page 29, Ramswarup Lohiya Udyog, unit of Ramswarup Industries, a company incorporated provisions and such. So, a unit is not a legal entity. So the lease really is in the name of the corporate debtor. And then we'll find at page 35, we'll see it's a long lease for a period of 99 years.
At page?
At page 35. I'm sorry, page 32 to ache na? May I just 32 also, I'm so sorry. 32 clause 8 will find unexpired period of 99 years at the top part of clause 8.
Yes.
And my lord, lease premium, my lord, given of 5 crore 29 lakhs. And my lord, only renewable for a further period of 99 years. And this, my lord, we also find at page 35, that same clause is, my lord, there. With regard to, my lord, the period. It's 99 years for, my lord, and a further period of, my lord, 99 years. So, my lord, the dates, my lord, has already got that, my lord, 4th September 2019. Then, my lord, the NCLAT order, which I've shown, my lord, 4th March 2021. And, my lord, Supreme Court order is 4th May 2021, which is, my lord, at page 318. Now, my lord, kindly come to, my lord, their demand, which is, my lord, at page 324. (26th April 2022. At 2012 policy to work. Actually, 2012. Well, sees date, Malad, is very important. After everything is done, Malad, 26th April. And they also write, Malad, to SS Naturals, re Ramsharoop Industries. We write to you in respect of the sublease dated 3rd September 2009. Entered into by and between West Bengal Industrial Development and Ramsharoop Loh Udyog, a unit of Ramsharoop Industries, with respect to the land measuring about Sansas. As per the policy of WBIDC, consent for transfer of such leasehold, sub-leasehold rights can take place only upon payment of the transfer fee, computed rate of 10% of the prevailing market value of the devised land by the transferee to WBIDC. Hence, you are requested to make payment of a sum of 6 crore 45, only being the transfer fee assessed as 26/10/2020, that is 10% prevailing market value of the demised land to WBIDC in order to obtain consent permission of transfer of sublease in favor of SS Natural, Resources Private Limited. Then, Malad, bank account detail given. Then, Malad, kindly sees, Malad, page 326, Malad, my reply. So, the 20th May, subject compliance, Malad, we write to WBIDC. The letter dated, Malad, in the reference, Malad, will find letter dated 26th April. Then, order of the Honorable Supreme Court, refer to 4th May. Compliance with order of the Supreme Court dated 4th May. We are in receipt of your letter dated 26th April 2022, wherein you have wrongfully sought payment of transfer fee amounting to 6 crore 45 for transfer of the sublease in our favor in respect of land at measuring about 315.42 acres situated at Kharagpur district. This land was subleased by WIDC on 3rd September 2009 to Ramsharoop Loh Udyog, a unit of Ramsharoop Industries merged entity. Ramsharoop Industries Limited underwent insolvency proceedings under the Insolvency and Bankruptcy Code, wherein SS Natural emerged as the successful resolution. Resolution plan of SS Natural was approved by Committee of Creditors on 16 March with 74.41% voting share, including WBIDC as one of the assenting financial creditors as per the terms of the resolution plan. Transfer fees are waived in terms of mandatory. Let me set out the clause. Then we'll kindly come to the next page. 327. It is paragraph 3. It is also pertinent to note that yourself as an ex-member of the Committee of Creditors of the corporate is voted in favor of the resolution plan, which seeks exemption payment of transfer fee, if any, and hence was fully aware of the waiver clause in the resolution plan mentioned in clause 15.15.5. In its order dated 4th September 2019, NCLT Kolkata approved the resolution plan, which was also upheld by NCLT Delhi as per order dated 4th March. I've shown that order, 4th March 21, wherein you were also added as one of the respondents. The mere transfer of shareholding of lessee company cannot be termed as a transfer of the lease unless the lease deed expressly makes such specific inclusions that change in control will be considered as a deemed transfer. Further, the Honorable Supreme Court in Civil Appeal, SS National versus Ramsarup, the same matter, my lord, pronounced its final verdict on 4th May 2021, wherein the Supreme Court upheld the original unmodified resolution plan as approved by the COC on 16 March, while including the cost of security expense of WBIDC and directed as follows. Then, my lord, we have set out, my lord, the order of, my lord, the Honorable Supreme Court. Then, my lord, next page 328. A perusal of the above order, paragraph 7. Above order makes it evident that the Honorable Supreme Court has upheld the original resolution plan as submitted and approved by the COC as a whole, except for a minor aspect pertaining to the security expense of WBIDC only, and hence mandatory clauses 15.15.5, which permits waiver of transfer unconditionally, arises should be accepted and honored. That this is clear that Supreme Court approved the resolution plan approved by COC in totality, while only directing the inclusion of payment of security expense of WBIDC as accepted by RP. Then, my lord, paragraph 11. The approved resolution plan of SS National under IBC upheld by the Honorable Supreme Court is binding on the corporator, Ramsarup Industries, its employees, members, creditors, guarantors. That's one of the clause in the IBC, section in the IBC. Central government, any state government or any local authority and other stakeholders involved in the resolution plan, and hence your office too is bound by the order of the Honorable Supreme Court and thereby cannot charge the transfer fee which has been waived in terms of the resolution plan, also approved by the Honorable Supreme Court. Then kindly see 13, you are put to notice demand of transfer is contrary to the order of the Supreme Court dated 4th May. Any step taken person said would plainly amount to willful and deliberate contempt of the order of the Honorable Supreme Court. Then, my lord, 14, we talk about, my lord, the insolvency and bankruptcy code. Then, my lord, after this, my lord, again another letter comes, my lord, from them, 333 at page, at page 333, 6 July 2022. This is, my lord, reply to 20th May, my lord, our reply. And here, my lord, we'll find, my lord, there's a narration, my lord, with regard to, my lord, the entire facts, my lord. I'd shown it, my lord, before also. I just don't want to, my lord, again, trouble, my lord. At 334, okay.
The last 4 lines of the first paragraph.
Yes, yes. Correct. Absolutely, my lord. Then, my lord, they narrate this, my lord, the orders and kindly see, my lord, 335. It is also second paragraph, my lord. It is also an admitted position that pursuant to the resolution plan, the entire shareholding of the corporate debtor shall now be taken over by the resolution applicant. Moreover, in view of the resolution plan being approved pursuant to the orders mentioned herein before, the existing board of directors has been replaced by a new board of directors comprising of your members and your representatives. It is denied that the transfer of shareholding of the lessee company cannot be termed as transfer of lease unless the lease deed expressly makes such specific inclusion that change in control will be considered deemed transfer as alleged or. Then, the next paragraph, 335, the last 4 lines, I think, that is what was 335, last 4 lines of the second paragraph or third paragraph. In pursuance of the order, has that. In pursuance of the order dated 26 December 2012, 26 December 2012, WBIDC has framed the terms and conditions of allotment, land module, and the same is applicable to all existing lease deeds, including the sublease dated 3rd September 2009. Following condition also required to be complied with, forthwith, which are mentioned here below. My lord, why I showed this, my lord, will recall, my lord, when I was arguing, my lord had also asked me a question, and my lord, it had fallen from, my lord, the court, because the lease is of 2009. That's, my lord, a concluded agreement, my lord, between the parties. Whether by a subsequent order, my lord, what they call, or a notification, my lord, they could then change the terms of the existing lease. Because, my lord, this is as on 26 December 2012. This, my lord, is annex, my lord. I'll show that, my lord, that is also, my lord, there. So this is what they say. Then, my lord, kindly see 336. after the quotation, my lord, from their, it is evident from the aforementioned clauses that in case of transfer that affects the ownership and control of the corporate data, prior permission is required to be taken from WHC, and the transfer affecting ownership and control of the corporate data shall only be allowed after making payment of transfer fees applicable, denied that the terms of the Insolvency Bankruptcy Code 2016 and relevant regulations, Ramswarup Industries Limited being the corporate herein, shall remain as it is and therefore shall continue to exist with all its rights it had prior to commencement of a corporate insolvency resolution process. All its assets includes right over demised land as alleged that the resolution itself contemplates change in shareholding of the sublessee corporate debtor. Therefore, since the majority shareholding of the corporate debtor will change pursuant to the resolution plan, it is imperative and incumbent on the part of the resolution applicant to make payment of a transfer fee of 6,445 in such term we are here. So let's see. Now the case becomes, they accept all of the lease is with Ramswarup Industries. The corporate debtor, my lord, is the lessee. But they say because of the insolvency process, resolution process, you have now gained control of Ramswarup Industries, and therefore you have to pay transfer fees pursuant to this order, my lord, which is there, which came in 2012. And that order, my lord, will find at 337. The date, my lord, will find, my lord, at 340. It is 26 December 2012. 337 date is also there. Yes, my lord, at the top right hand side, sorry. 337, my lord, date is also there. 26/12/2012. So also, my lord, apart from the insolvency point, my second submission is that this order cannot apply to a lease which is already existing. It is a bilateral contract between two parties. You can't use an order. It can only have prospective effect. It can't have a retrospective effect to affect, my lord, all leases which are already there. My lord, sees, whereas the state government, corporations, development authorities, and urban land having been allotting and pricing land and other assets in line with various departments where need to enter new uniform. Now, my lord, 3. Now the governor, after careful consideration matters, pleased to hear to make the following land allotment policy, which will be applicable to land owned or held by any department, state government, or agency funded by the state government in any manner. Then, my lord, kindly sees B, 2B. The lessee is not entitled to assign his leasehold interest, whether in full or in part, without prior, my lord, has that, my lord, without prior written approval. My lord, page 337, my lord, 3B. Without prior written approval of the lessor, an assignee shall hold the same on the same terms and conditions as in the original lease, and to such other terms and conditions as may be considered to be imposed by the lessor while granting such approval. In case of such assignment of leasehold interest, the assignee concerned shall have to obtain fresh lease after expiry of the unexpired period of lease. Kindly see, shall have to obtain fresh lease after expiry of the unexpired period of lease on payment of such consideration money and annual rent based on the prevailing market value as may then be fixed by the lessor in granting such lease. Two submissions I immediately have. Saying, this clause is not applicable to a subsisting lease of 2009. Secondly, this is not a voluntary transfer as it is contemplated. It says lessee is not entitled to assign his leasehold interest whether in full without prior written approval. Here, the lessee has not assigned his interest. It has gone into a process of insolvency, and under the resolution, in terms of the IBC code and in terms of order of the court, if I may say, the National Company Law Tribunal, if we can consider it as a court, then in terms of their order, this has happened. What has happened, the corporate debtor shareholding quite naturally, because a new management has to come in. Otherwise, this company won't survive. So a new management has come in pursuant to the orders of court. It's by operation of law. So no question of any transfer. No question of a voluntary act of assignment by Ramswarup Industries. Now, it is clear they're saying because by reason of insolvency, you SS Natural has come in and you are holding the shares and you have become come into management. Therefore, there's a question of transfer fee. This is the second submission. And give me the case. My lord, the cases, my lord, will recall, my lord, which had the transfer cases. My lord, will recall, my lord, the cases I keep writing those cases and I keep losing those cases. My lord, yeah. My lord, three cases, my lord.
You've referred, yes, I
Okay,
have.
my lord, one, my lord, is Gopi Ballav. My lord, State of West Bengal, others versus Gopi Ballav solution. My lord, this is a division bench, my lord, of our court.
Yes.
My lord, this is MAT 869 of 2018. There, my lord, will recall, my lord, paragraphs 9, correct. 9, 10, my lord, very clear that, my lord, it is not a change, my lord, with regard to, it's not a transfer. Then, my lord, Green Hut, my lord, we have relied on. That is, my lord, 2010 SCC Online 610. क्या paragraph है? Where is my copy? Well, I'll just take out. Sorry, Manoj, just give me one. My copy. Well, just give me the page.
The last page.
Well, last, my lord has the, yes, I've got my judgments. So, my lord, here also, my lord, see, my lord, this is in, my lord, in aid of, my lord, my second point, which I'm saying, my lord, there's no transfer also. My lord, the last page, my lord, will find. It is true that a company, my lord, has that, my lord.
Yes.
Second last paragraph. Well, it's true that a company is a different entity from shareholder unless there is express transfer or assignment of a lease by the company in favor of some other party. It cannot be ordinarily said that there's assignment to transfer of the lease merely because there's a transfer of shareholding. And Mullah, that's exactly what they say. This Mullah I had cited and relied upon. The letter of the government of West Bengal alleges transfer of shareholding only. It says that by such transfer, there is assignment or transfer of the lease in breach of the above covenant. Basis of the allegation, the body of the letter and opinion, no case for transfer or assignment is made out. Hereby declare such a rest in the government center. Any steps on basis of letter. Mullah, here also Mullah is exactly Mullah a similar situation Mullah which Mullah WDRC is doing. And the other judgment Mullah Din Chemicals Mullah will recall of Mullah the
Yes.
Chief Justice Mullah, the then Chief Justice Mullah of our courts. Mullah, that is also Mullah a second last page. Mullah, in the middle, Mullah will find. Yes, yes. Mullah, about Mullah 10, 11, 12 lines Mullah from the bottom. Read question number 2 at the bottom, Mullah, just above that. As such, Mullah, perhaps it may be marked Mullah in my Lord's copy. As such, by following the aforesaid decision, Mullah has that. It's the second last page and internal page, Mullah 4 at the top. Mullah will find small print, Mullah, on the left hand side, page 4.
As such, this court.
Yes. No, Mullah, as such, by following the aforesaid decisions
Yes.
of the Honorable Supreme Court as well as of this Honorable Court, this court has no hesitation to hold that with the transfer of the share by the promoter shareholder to the present shareholder, namely the transferees of such share, leasehold interest of the company was not transferred from the promoter shareholder to the present shareholder of the said company. Petitioner company which obtained the said lease from the government still remains the lessee of the said plot of land, and its leasehold in the said plot of remains unaffected by transfer of shares by the promoter to the present shareholder. As such, this court holds that the restrictive clauses regarding transfer of the leasehold interest of the lessee in favor of strangers does not attract in the present case. Because I'll tell my lord, in our lease also, my lord, there's such a clause that you cannot transfer. That's page 39. So it would have been violation, but no, they're saying no. Because my lord, it's by order of court. So my lord, all these judgments, my lord, I've shown on the second point, my lord, as to my lord, that there is no transfer as contemplated by them. And my lord, the other set of judgments which my lord will also recall, my lord, is on Ghansham Mishra my lord, the 2021 9 Supreme Court cases 657 that I've also cited. And that is, my lord, on the principle. My lord has already noted, my lord, saying I can't be exposed because of the resolution plan and, my lord, the approval. I can't be exposed to more than, my lord, what I've already paid. So this transfer fee, my lord, addition which they asked for is, my lord, really against the provisions of the IBC. And, my lord, also, my lord, does not satisfy, my lord, that clause, the 2012, my lord, order which they rely upon. My lord, now, my lord, their judgments which they relied upon, my lord, I don't know, my lord, I'm little surprised, my lord, with, my lord, what my learned friend has relied upon. Because, আমি তো বুঝতে পারছি না. My lord, I don't know, my lord, what he relies on, my lord, all these judgments. I have. There is one. Mine only. No? मेरा ही है. Good. Yes, my lord, तीनटे judgment. 2003 9 Supreme Court cases 401.
Yes.
2008 12 SCC 481 and 2015 8 SCC 583. Now, my lord, all these judgments, my lord, will find is, my lord, on a question of, my lord, concealing material fact, or, my lord, on the question of, my lord, coming to court, my lord, with unclean hands.
That is the primary submission of the.
Yes, my lord, I don't understand, my lord, with the greatest respect. I don't understand what is the coming with unclean hands. I, my lord, given the judgments of the NCLT, NCLAT, and the Honorable Supreme Court. And I have not said, my lord, my submission is not that, my lord, NCLAT has held this. I am showing this was your submission. And I, on the other hand, my lord, as a resolution applicant, wanted to go and say that, no, sorry, there will be huge transfer fee. I'm not taking this company. So that you as financial creditor, you as WBIDC kept quiet and said, no, it's premature. You don't have to pay. Or there's no question arises of payment. And then after the plan is sanctioned and approved, then you come and raise a demand in 2022 saying that now I think it's a transfer because you have transferred the shareholding. So, my lord, these judgments, my lord, are not applicable. The principle, my lord, is there quite naturally, my lord, if I come with, my lord, unclean hands. But where is, I don't understand, my lord, where is the unclean hands? I have come to court challenging a demand which you have made for a transfer fee, which we are saying is illegal. You could not have done it. That is, my lord, my writ petition, my lord, with regard to. My lord, I am very grateful, my lord. We'll file a written notes, my lord, whenever, my lord, permits us.
I'll keep it on next Thursday for the written notes of argument.
Within a week, my lord.
Yes.
Within a week. Because next week, my lord, we are getting holidays.
The holiday week.
Holiday week.
Holiday week, my lord, yes, my lord, we have 2 days of holidays, my lord. 23rd and 26th.
Extended weekend and yes.
Yes.
Right.
Yes, extended weekend, correct.
Well, only 3 working days.
And that also, my lord, we don't know, my lord,
About 22nd.
my lord, what will happen.
Are being made not to keep on.
I don't know, my lord. I'm told, my lord, the Bar Council of India now, my lord, has made a representation, my lord.
Yes.
The chief justice.
To the chiefs.
It's not commented.
Yes, my lord. I also don't want to, my lord, comment on that.
The next Thursday is 1st February.
First time in. Lord, I'm my lord, first. Yeah. 8.
Grateful.
Sufficient time.
Just for the submission of returns. That's
Grateful.
And what are the interim orders to
Still this.
Great.
yes, next.
For hearing, item number 5.
I am opposing this. Parties have filed their respective
This is my application, Talat. Application, my lord, under section 74 of the trust. My lord, for appointment of trustees. My lord, if I may briefly state the facts, my lord. This is with regard to the trust of my lord. This is my lord, the affidavit of service. Kindly hand.
We have been served
Affidavit
with the
of
copy.
reply. Affidavit. my lord. My lord, this relates to the trust of my lord Mutisil, my lord. My lord, Mutisil, my lord, had three sons, my lord. One is, if I may, my lord, indicate from the application, my lord. My lord, at page 3 of paragraph 4, my lord,
page 15 আমি mark
Mutisil, my lord, had three sons, my lord, Punnolal Sil, Kanailal Sil, and Govindolal Sil. My lord, if your lordship finds, my lord, the second line, there are, my lord, as many as three branches of the descendants of Mutilal Sil, namely Punnolal Sil, Kanailal Sil, and Govindolal Sil. My lord, these three family branches of the trustees are to be selected as per the provisions of the trust. Out of the trustees, my lord, three sons shall be appointed from Pannalal Sil, three sons from the Kanairal Sil, and four sons from the Govindolal Sil. My lord, herein, that's the trustees. My lord, 10 trustees and three from the Kanailal and Pannalal, Punnolal, and four from the Govindolal. My lord, we are concerned with the Govindolal Sils in the instant application, man. But happened, my lord, the Govindolal had, my lord, 8 sons, and it was the wish of the settler that the Govindolal's 8 sons will be appointed by rotation in 5 years for the 5 years period. My lord, that's the wish of the trustee, my lord, if I may indicate from the trust deed, my lord, at page 19 of the petition, my lord. Is the second paragraph, my lord. Page 19, 19. Yes. My lord, trustees appointed shall duly carry the directions contained in the trust on the expiry of every 5 years. New trust. The first paragraph? Second paragraph, my lord. Second paragraph. Yes. My lord, and newly appointed trustees shall, as trustees, remain in the possession of the said properties vested with regard to the trust deed. 7, except the period of Sri Jukta Babu Krishnolal Sil shall remain a trust, and total number of trusts shall be not more than 10%. At my lord, if your lordship kindly take note. And my lord, the method of appointment also has been mentioned. If your lordship kindly sees, the trustees shall be appointed by voting in the manner of election out of the family branches of Pannalal Sil and Kanailal Sil. But for the Govindolal Sil, my lord, it was mentioned in some other way. My lord, the third line from the last, my lord, if your lordship kindly takes, the trustees shall be appointed, my lord. Every 5 years. Yes. Trustees shall be appointed every 5 years by rotation from the family branch of Govindolal Sil. And this rotation, my lord, shall commence with the eldest son. My lord, I am led by Mr. Ghoshal, my lord, if I may.
Lord, here is a case, my lord, under section 74 of the Indian Trust Act, wherein, my lord, I have, as a beneficiary, I have come before this court, my lord, for an appointment of a trustee in place of a deceased trustee, my lord. Now, my lord, section 74 comes into play when section 73, the appointment procedure, my lord, mentioned in section 73 has failed, or by efflux of law or otherwise, it is actually impracticable. Now, before, my lord, I place all, my lord, the documents, kindly have a look at, my lord, section 73 and 74 for once. Indian Trust Act আছে? There it is. Lordship kindly takes me not section 73 first. Appointment of new trustees on death, etc. Whenever any person appointed a trustee disclaims or trustee either original or substituted dies or is for a continuous period of 6 months absence from India or leaves India for the purpose of residing abroad or is declared as insolvent. Milord, these are the situations under which, Milord, there is a vacancy of the new trustee. Kindly, Milord, ignores the other portion and comes straight away or refuses or becomes then, in the opinion of a principal civil court of original jurisdiction, unfit or personally incapable to act in the trust or accepts an inconsistent trust, a new trustee may be appointed in his place by. The situation are the person nominated for that purpose by the instrument of the trust, if any. So it has to be by the trust nominated in the instrument of trust, Milord. Or if there be no such person or no such person able and willing to act, the author of the trust, if he be alive and competent to contract or the surviving or continuing trustee or the trustee for the time being, all legal representative or the last surviving and continuing trustee, the retiring trustee, if they all retire simultaneously, the last retiring trustee. So basically, Milord, the second aspect is by the author himself, if he is alive at that point of time. Now, in our case, your Lordship will find that this trust was created in the year 1947 by as many as 28 settlers. Now, all those settlers have expired. Now, these settlers, while executing the trust, Milord, has given in the trust deed itself the appointment of the trustees from the legal heirs of the settlers.
It was just read out.
Yes. Milord, I'll show the interpretation because ultimately when I will place section 74, your Lordship has to consider the intention of the settler. That is exactly section 74. Kindly comes to section 74 for once. So, Milord, under section 73, there is no appointment. There is impracticable. So, Milord, therefore, as a beneficiary, I have come up before your Lordship, Milord, for appointment as a trustee. Appointment by court. Section 74. Has my Lord got it? Whenever any such vacancy or disqualification occurs, and it is found impracticable to appoint a new trustee under section 73. So one of the basic ingredients, Milord, for following section 74 is the impracticable situation under section 73, which I am, Milord, satisfied. The beneficiary may, without instituting a suit, apply by petition to a principal civil court of original jurisdiction for the appointment of a trustee or a new trustee, and the court may appoint a trustee or a new trustee accordingly. Now, while appointing, the court has to see the rule for selecting new trustee. In appointing the new trustee, the court shall have regard to, the first aspect is to the wishes of the author of the trust as expressed in or to be inferred from the instrument of trust. The second aspect is to the wishes of the person, if any, empowered to appoint new trustee. Next is to the question whether the appointment will promote or impede the execution of the trust. And fourthly is when there are more beneficiaries than one, to the interest of all such beneficiaries. So, section 73, if it is impracticable, any beneficiary under the trust deed can come up before this court praying for appointment of a new trustee. Now, while appointing a new trustee, it is a business of the court with the, Milord, the applicant before the court. While constituting, Milord, or appointing a new trustee, the court has to consider four aspects. One of the fundamental aspect is the intention and the wishes of the settlor. Then comes, Milord, the remaining three. But first and foremost is the intention of the settlor. Now, my lord, if your lordship kindly comes straight away to the genealogical table for once, which starts from page 107. Kindly come straight away to 108. Now, this genealogical table has been accepted by my learned friend. Your lordship will find the applicant before your lordship is Joyantolal Shil, who happens to be the legal heir of Maniklal. Maniklal is the third son of Govindolal. Has my lord got it? Joyantolal Shil is the petitioner. Now, lordship kindly comes straight away to the right hand portion, the last son of Govindolal, Jawaharlal. Your lordship will find Jawaharlal legal representatives, my lord, consisted of Joroda Kumari, Dalimmoni, Rajendranath Horonath, Dariknath, and Omionath. Omionath has expired. So, my lord, after Darik and Omio, there are no legal representatives. Now, your lordship has, I believe, my lord, my junior, my lord, had placed, my lord, the rotation wise, my lord, of Govindolal Shil. Your lordship will find the petitioner along with, my lord, the person who has expired is the legal representatives of Govindolal Shil. So, if there is, my lord, a vacancy in, my lord, the line of succession of Govindolal Shil, it has to be by rotation.
From the eldest, I think.
Yes, from the eldest. Now, my lord, I'll place, my lord, a judgment of the Bombay High Court which says that under section 74, the only point of contention which a person, my lord, opposing a section 74 application can raise is, my lord, on a disputed question of fact, where evidence is required. If such contention is not raised, my lord, there cannot be any legal and valid objection before a court of law, my lord, to contradict or oppose an application under section 74. I'll place that judgment. The second aspect is, lordship kindly takes, my lord, the trust deed, my lord, the English translation. That is also, my lord, accepted. 19 and 20. Page 19 and 20, my lord, of my application. I believe, my lord, the last portion of the second paragraph has been placed before your lordship, where it says, my lord, that if in the family branch of late Govindolal Shil, any post of the 4 post of trustees become vacant on the aforesaid ground, in that case, that post shall be nominated according to the seniority only by a person who is a member of that person's family. Now, kindly takes, my lord, page 108 for once. Your lordship will find there is no legal heirs or representatives, my lord, in the line of succession of Omio. So, if there is no, my lord, line of successions or, my lord, descendants of Omio who can take, my lord, or, my lord, decide upon the trustees, then comes, my lord, the general proposition, that is, my lord, appointment by rotation. So, appointment by rotation, if it commences according to the trust, then, my lord, automatically the petitioner before your lordship is entitled. On account of seniority. On account of seniority and in accordance with, my lord, the interpretation of the trustee. In any event, my lord, let us, my lord, consider from the different aspect altogether.
Who is the petitioner?
Joyantulal Shil is, my lord, the legal representative of Manik Lal. From the legal, from, my lord, your lordship will find Joyantulal Shil is the son of Dulal Lal. Dulal Lal is, my lord, the representative of Manik Lal. The reason why, my lord, I say that Joyantulal is entitled is because, my lord, the representatives of, legal representatives of Pyarelal and Brojolal is there. Is already, my lord, acting as a trustee. Lordship now, my lord, thinks from another aspect. Lordship has
Necessarily have to be a new person.
no.
The existing trustees cannot continue.
The existing trustee can continue, but, my lord, the members has to be 10. 10 members has to be there. Now, my lord, your lordship might put a question to me that there is no mention in the trust deed that always it has to be 10 members. But if your lordship interpret the trust deed and, my lord, your lordship, my lord, read out, my lord, the different paragraphs of the trust deed, your lordship will find the intention was always there to appoint, my lord, a trustee whenever a trustee, my lord, expired or, my lord, is incapacitated, my lord, by his, my lord, disqualified. Intention was always there of the settlor that 10 trustees must be there. That is always the intention, and that had been, my lord, the intention of the, my lord, board of trustees, my lord, prior, my lord, coming into, my lord, before this application. Always there. Now, my lord, your lordship has already seen that. Now kindly takes, my lord, page 21, the next page. The second paragraph, be it known that 7 except the male heirs of the sons and grandsons of the settler, never shall a daughter or daughter's son be nominated, within bracket elected. So that is in respect of election of the other branches. Because in the previous page, your lordship will find, apart from Gobindulal, there are 2 other, my lord, legal heirs of Motilal, where election has to be there. So this, my lord, is in respect of, my lord, the other heirs or appointed as a trustee to the trust estate. If within 1 month of the vacancy, kindly marks this word, my lord, if within 1 month of the vacancy to the post of the trustee, no representative be nominated or elected in this case, the trustees shall, after due service of 30 days registered notice, elect and appoint 1 person out of the members of the family in which the post of appointed trustee falls vacant, and also shall remain bound by this. Now, this takes care, my lord, of 2 aspects. The first aspect is there should be always, my lord, 10 members. And the other aspect is, my lord, how and when a new trustee can be appointed in case of election. Thereafter, my lord, the trustees shall follow the very method. This is very important, my lord. The trustees shall follow the very method which has been stated before in case of nomination election by rotation, within bracket by rotation, from the branch family of the late Gobindulal Shil only. So the period of 30 days is not only relevant for, my lord, the other branches, but also from the branches of Gobindulal. And Omionath belongs to, my lord, the branch of Gobindulal. Now, my lord, interestingly, my lord, there has been a point raised in the affidavit in opposition that time has not come or the application is premature in nature. I'll take, my lord,
The respondents.
the respondents are the trustees.
The trust, board of trustees,
Existing trustees.
The
board of trustees.
From the other branches.
No. The existing trustees of the trust. Out of which, my lord, one of the trustees has expired. That is the reason why, my lord, we have filed this application for appointment.
Existing trustees meaning thereby from all the three brothers.
All the three branches, my lord. All the three branches. So, my lord, this is in respect of, my lord, the 30 days period, my lord, by within which, my lord, the trustees should have appointed. Now, kindly takes, my lord, page 109. This is a letter, my lord, written by me. You are well aware that this has been addressed to the trustees. You are well aware that in terms of the trust deed dated such and such, 4 trustees are to be appointed from the branch of Govindolal Shil by rotation. In terms of the said trust deed from the term 2022 to 2027, the following 4 trustees were appointed from the branch of Govindolal. These, my lord, 4 names has been set out. Unfortunately, Omionath Sen died on March 2023. This letter has been issued on 2nd June 2023. So if it is March, then by April 2023, the, my lord, new elected trustee ought to be there. They haven't, my lord, done so. On the contrary, they say that no, according to the trust deed, my lord, I'll also take the point, my lord, without prejudice to my such point, that this affidavit in opposition has been affirmed by one of the manager of the trustees. I'll also take this point, my lord. I'll come to that. So within, my lord, 30 days, they ought to have appointed, which they have failed to do. This has been, my lord, accepted. The next page, your lordship will find, my lord, the certificate of acknowledgement issued by the, my lord, Indian Post, item delivered to address it. There is another letter, my lord, at page 111. This is 24/7/2023. Still not done. In fact, in the 3rd, my lord, paragraph, I have specifically stated that in spite of lapse of 3 months from the date of Omionath Shil, till you have not made any endeavor for appointment of trustees. So, if your lordship sees, my lord, the intention of the settlor has specifically, my lord, settled in trust the properties, my lord, which are there. The settlor, my lord, has also settled that there should be, my lord, 10 members as trustees, my lord, functioning, my lord, as a board. The settlor has also specifically stated that apart from, my lord, the 2 branches of, my lord, the my lord, Motilal Shil's, my lord, the legal representatives, 2, my lord, leaving aside Govindolal, there should be election, and Govindolal Shil's, my lord, representatives has to be appointed by rotation. There should be 4 members, my lord, appointed by rotation. In case of death, the new trustee has to be appointed within 30 days. Now, my lord, I'll show another aspect, my lord. ম্যানেজার কিভাবে দেবে না দেবে পেজ নাম্বারটা আমাকে বলো page. Now kindly takes, my lord, page 34 for once.
Yes. This is the deed.
Yes, this is part of the deed, my lord. The trustees shall appoint a competent manager to carry on the work of the trust. Now, my lord, what is, my lord, I am showing this for the purpose that a manager of the trust is not empowered by the trust deed to, my lord, file this affidavit in opposition before your lordship. Because, my lord, unless authorized, specifically authorized by the trust deed, the trustee shall appoint a competent manager to carry on the work of the trust. The said manager, pursuant to the direction of the trustee, shall call for monthly and, if necessary, emergency meeting of the trustees. The said meeting shall be held at the office house. The manager shall duly send invitation letters by post or by peon to the trustees to be appointed in the meeting in due time, at least 48 hours before or at the time fixed for the meeting. It will be sufficient if the invitation letters are sent to the address of the parties recorded in the trust office. So, my lord, the manager is specifically empowered, my lord, for calling a meeting and nothing else. Now, my lord, kindly takes, my lord, page 36. What else, my lord, the manager is empowered with? The manager shall have the charge of the meeting, shall expenses and of keeping the key of the iron safe in the office room. He will preserve the checkbooks, bank's passbook, and other valuable documents, etc. of the trust kept in the said iron safe. The manager shall be entitled to append without the permission of the trustee for the purpose of the trust an additional sum of ₹200 over and above the amount sanctioned by them, and shall keep proper accounts in respect of the same, and shall got the same sanctioned by the trustees in the very next meeting. The manager shall pay the creditors cash in cash or by check in amounts which the trustees have sanctioned in the meeting. He shall be competent to issue and sign the said checks in the manner aforesaid. The trustee shall be competent to keep in the deposit in the Imperial Bank of such and such with the present then government of such and such for meeting expenses for 2 months in the name of the manager, the late Motilal Shil estate, for the purpose of meeting monthly on emergency expense. So, my lord, apart from these powers, my lord, as more fully enumerated in the trustees, the manager does not have any other power. Because the trust deed, when it is created, the trustees, my lord, under law, are the managers of the trust.
Yes.
And until and unless, my lord, there is a specific provision in the trust deed that what can be done by the manager of the trust, the manager doesn't have any other power, my lord, over and, my lord, beyond, my lord, what has been specifically stated. Now, my lord, kindly takes, my lord, the affidavit in opposition.
Take some more time to. So, shall we continue on the next day? Because I have another determination to deal with. I can find learned counsel's waiting. Yes, shall we continue on the next day?
My lord, my lord, the interim order is still on the yes.
My lord, I'll
The 31st.
Your lordship is otherwise busy, but I'll only take 2 minutes. Your lordship will kindly place it for some other day. No problem. Lord, I shall only draw your lordship's attention to the letter just now my land friend has shown. Only that letter.
On the next date?
I haven't finished.
My lord, question is, my lord, the interim order is there passed by your lordship.
Has to be extended.
And my lord, there is a threat for both civil and criminal cases against the trustees. That you are incompetent and many things has been said on the power of manager and all this.
If under the law, I
shall try to satisfy. I shall try.
If under the law, the
Kindly keep it
trustees
for-
have not done or not acted in accordance with the trustees, whatever is there
As
in
on
the-
date,
under
yeah.
the law, it is there.
Of the matter.
Yes.
It will be dealt with by the other trustees at before this is disposed.
Most certainly not. Kindly keep it in that case for Thursday week, my lord. Because the next week, next week, my lordship knows, but the next week.
Rampuria fix.
For further consideration on.
Thursday week.
Can you come back on 1st February?
1st February.
First February.
on 1st February.
1st February.
24th paragraph, the interim order granted earlier is extended till 29th February 2024 for the orders, which is concerned.
Gratefully.
Take that to book.
আধার ট্রাস্ট ছিল যেগুলো রাখতে হবে হ্যাঁ দি এই না নাম আমার এটা কোথায় গেল
Yes, our book number 95 is ready.
Yes, ma'am.
Milord, I am for the petitioner. It is my affidavit of service, Milord. I pay for extension as because the corporation, in spite of service of.
Let me just. I've switched to the appellate side matters, so please give.
Yes, in spite of this stay over the said proceeding an order of the municipal commissioner, Milord, the corporation has issued demolition notice, Milord.
There is already an interim order.
Which has expired, Milord. We have filed a CRAN application within time, Milord.
It was till November 30th.
Yes, Milord.
You have served the.
Yes, Milord. Corporation and the private respondent.
Not delivered.
Milord.
Private respondent has not been served.
Door locked, Milord.
Only on one occasion. It has to be on repeated occasions. Then only it is taken as service. This is only on one occasion.
Yes, Milord.
Can you let it be extended for a repeated of service? None appears for the Kolkata Municipal Corporation despite service. Paragraph, heard learned counsel for the petitioner. Paragraph, the interim order of status quo with regard to the construction has expired on November 30, 2023. Stop. Learned counsel for the petitioner submits.
But it is not construction, Milord. It is over the house.
Order is status quo with regard to construction.
Yes, Milord.
That is exactly the interim order. I'm
Yes,
referring to that. Learned counsel for the petitioner submits that in view of expiry of the interim order, comma, a notice has been issued upon him by the executive engineer on 13th January 2024 Requiring his assistance in demolition of the unauthorized structure. Stop. Paragraph, the said demolition order is assailed in the writ petition. This is CAN, isn't it?
Yes, my lord.
The CAN 1 of 2023 ke order code. Paragraph. In view of the above, this court is inclined to hold that refusal of an interim order at this stage shall render the application infractions. Paragraph, the order of status quo granted vide order passed on July 27, 2023 be extended till February 29, 2024 or until further notice, whichever is earlier. Paragraph, the matter be placed before the regular bench.
Deeply obliged.
Next.
My lord, I am for the petitioner.
Yes.
My lord, interim order is till 31st of January.
Served.
My lord, this is the affidavit service pursuant to the earlier direction I have served, but no further notice, my lord, regarding extension. My lord, first notice was received by them on 27th October, but this is my affidavit of service. It has been delivered on 27th of October. My lord, I have mentioned this matter before your lordship, despite, my lord, the interim order still 31st, because, my lord, the next week there are most probably there is no days. Therefore, my lord, I have mentioned this. And my lord, this relates to, my lord, construction. This relates to construction. And my lord, I have been restrained by the impugner
For another month.
My lord.
But the learned court will be back before that.
My lord?
Learned court will be back before that, the regular bench.
My lord, difficulty is, my lord, situation is completely different. My lord, before your lordships, I have mentioned the matter. I have not taken any step. The matter has been listed. But situation is different, ma'am. My lord, don't take me amiss, ma'am.
Very well, another month.
My lord.
Affidavit of service. Learned counsel for the petitioners. Paragraph, the interim order granted earlier is extended till 29th February 2024 or until further orders, comma, whichever is earlier. Paragraph, the matter be placed before the regular bench.
I'm getting.
Lord, I am appearing for the petition. I am grateful your lordship has been very kind to fix this matter as fixed matter. Your lordship, I am the wife. Now, a divorce suit was filed at the instance of the husband. That is, if your lordship kindly comes to page 9. That is matrimonial suit 146 of 30. And the relief portion is, your lordship, at page 11. May I place the relief portion? Under the above facts and circumstances, your petition humbly prays that your honor would graciously be pleased to pass a decree for divorce or marriage. Now, thereafter, your lordship kindly comes to the next page, that is the order. My lord, suit was withdrawn without taking the leave of the honorable court to file a fresh suit. That is order dated 3rd of December 13. Learned advocate for the petitioner is present. OP appeared and files a petition 24. A copy not served, prays for withdrawal of this case. Considered, prayer is allowed. So here liberty is not taken. Thereafter again, my lord, next page, a fresh suit again was filed. That is page 30. Between the same party.
The same cause of action.
Same cause of action. Now your lordship kindly comes to, my lord, the prayer portion. Page 17.
Yes.
Your Lordship kindly sees.
The same thing.
Yes. Now the learned trial court, the impugn order starts from, my lord, the last page, my lord. That is after inner page 13 in impugn order dated 13/10/23, where the learned judge with great respect, my lord, missed, my lord, the essence of order 23 rule 1(3) subclause B. Your Lordship kindly sees. And I am guarded by different judgment, as your Lordship knows better than me. I have also a judgment of Honorable Supreme Court also. My lord, liberty is essential. My lord, cause of action is same divorce. But what he says, that cause of action, the word cause of action is absent in the first suit, it is present in the second suit. But order 20. No, it is not stated in details. But prayer portion I have indicated before your Lordship. My lord,
Court says cause of action is different. Where is the difference?
no difference. I can show. Same cause of action. Divorce suit, where allegation is that the wife has filed 498A, cruelty. If your Lordship wants, just now I can place that. The thing is that,
That was subsequently fetched.
yes, your Lordship kindly see the learned trial court missed out with great respect and utmost humility that liberty is not taken. So, my lord, the essence of order 23,
Serve notice, let further proceedings be stated.
my lord, grateful. Grateful.
Since no comma. Learned counsel for the petition. Submitted on behalf of the petitioner that an earlier suit
My lord, number is 146 of
matrimonial
13.
number 146 2013 filed by the opposite party husband against the petitioner wife was withdrawn
Which territory number is it? 52.
by the opposite party without seeking liberty to file afresh on the same cause of action. A subsequent suit being Mat 6 of 2015.
My lord, which is renumbered as 352 of 22. The suit thereafter renumbered. I have mentioned.
Which Mat suit number 6 of 2015.
Renumbered as 352 of 22.
352 of 2020 was filed by the opposite party. Against the petitioner seeking a decree for divorce as sought in the earlier suit. Stop. Learned counsel for the petitioner submits that the opposite party was precluded from filing the second suit since no liberty for the same. Second suit on the same cause of action, since no liberty for the same was granted to him. Paragraph. That the application filed by the petitioner challenging the maintenance of the second suit was turned down by the learned trial by an order passed on 13th October 2023. Stop. Paragraph, the petitioner has made out an applicable case. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the adjourned date. Paragraph, in the meantime, all further proceedings of Mat suit number 352 of 2022 be stayed until further notice.
Deeply obliged. Deeply obliged.
Paragraph, the matter be placed before the
Deeply obliged.
Take back your book, please.
My lord,
Your book.
my lord. Grateful, my lord. Grateful.
Next.
My husband is the petitioner before your lordship. My lord, the husband has filed a suit for dissolution of marriage on the ground of possession and cruelty. My lord, the wife left the matrimonial home with the child. My lord, the husband has filed an application for the visitation right. The wife entered appearance and took time for filing written statement and the written objection to the visitation right. On the 15th of August 2023, my lord, it was fixed for hearing of the visitation right. She did not appear. But in the meantime, my lord, we filed an application for preponement because the husband wanted to see her girl child during the puja vacation. The learned judge directed the matter to appear on 15th of February 2024 for my lord, show cause, and directed if she doesn't appear, it will be taken up for hearing. My lord, my inaugust prayer would be, my lord, your lordship, can you direct the 15th of February 2024, the date for hearing show cause. Direct the trial judge to hear out my visitation right, my lord, on that particular date.
Where is your application?
My lord, application, my lord,
Order, sorry, the order.
order, my lord, the last order, my lord, your lordship will find
15th February was a date
15th
for filing show cause.
show cause. My lord, your lordship knows, my lord, 15th of show cause if she doesn't appear. Therefore, my lord, your lordship will kindly direct the learned trial judge to dispose of my application for visitation right, my lord, on that particular day.
Why was show cause ordered?
Because she is not appearing, my lord, she is not filing the written objection to the visitation right, my lord. The husband is deprived of seeing his girl child, my lord, from the for last 1 year. She entered appearance, my lord, she assured the court that she'll file the written objection and objection to the visitation right on that particular date, 15th of August. She did not appear, my lord. Subsequently, when the court said she'll be allowed to be a show cause on that day if she doesn't file the show cause, the application will be heard. My lord, the application is pending since more than 1 year. Therefore, I was humbly praying, my lord, your lordship can direct the run trial judge.
The wife was not served before the trial court.
Yes, it has been served.
The trial court observes that it cannot be made out, cannot be ascertained whether it is served.
Because, my lord, your lordship, my lord, the track report, my lord, we have served. The track report did not indicate there was any service in the track report.
That is necessary.
Yes. Therefore, my lord, this is application on the 15th of February, the matter is fixed for hearing show cause. On that date, my lord, learned trial judge says if she doesn't appear, we'll hear. Your lordship can ensure.
Yes, provided you have served the wife.
We have served. It has been served. If your lordship filing direct, my lord, on that day, my lord, if she, the learned trial judge, my lord, said that if she doesn't appear on that date, my lord, the show cause the application will be taken up for hearing.
The date is already fixed on 15th February.
Therefore,
Why do you want an expeditious date?
Because on that date, if she doesn't appear, my lord, again, my lord, it will.
No, this is premature.
My lord,
This is premature.
we have lordship kindly considers, my lord, that day, my lord, the husband is suffering, my lord, that is the reason, my lord, your lordship kindly on that day, my lord, kindly.
Stated specifically that if the show cause is not filed, the matter will be, the application will be taken up for hearing.
My lord, kindly.
No further, nothing.
My lord, your lordship will kindly say.
I will not find any merit in it. No. There's already a date of on 15th February.
The show cause, but only the show cause petition, your lordship will say.
Apprehension, that's all.
The reason, my lord,
Stated if show cause is not filed, the matter will be taken up for hearing. Yes, if the
My
show
lord,
cause is filed, then the person has to be given an opportunity.
when the opportunity was given, she did not appear. My lord.
Place before the regular bench. I know others. Next.
But I am for the petitioner in this matter. But I am an applicant in a surface proceeding. Lord, there are petitioner But I appear for the respondent in this matter.
Yes, you've received copy?
Yes, I'm on caveat. I received a copy. Now, my lord, I challenge, my lord, a surface proceeding and the borrow. Now, my lord, the tribunal, my lord, debts recovery, I'm sorry.
Yes, continue.
Lord, I am the borrower who challenged, my lord, a surface proceeding before, my lord, the debts recovery tribunal. The debts recovery tribunal, my lord, upon hearing me, passed an order which is at page, my lord, 20. This is an order of injunction, page 20. Now, my lord, page 21. In the above circumstances, even in the absence of auction purchaser, the auction purchaser is directed to maintain status quo regarding the subject property till the next date of hearing. Now, my lord, this was continuing. Now, my lord, why I am before your lordship? Lord, the impugned order is, your lordship will kindly come to, my lord, the impugned order at page, my lord, page 80. Page 93. But on 30th of November 2023, this order was passed. Learned advocate Mr. N. Mishra and Mr. G. Singh appear for the surface applicant. That's my client. Learned advocate Mr. Shamrat Mukherjee along with Mr. Rajiv Maiti and Kuheli Dev appear for the respondent a financial institution. Learned advocate Mr. S. Ganguly along with Ms. Ish Mishra appear for the auction purchaser. Mr. Anubhav Mittal and Rajkumari Mittal, Sujit Kumar Singh and Ms. Ritu Singh, while raising issue that by order dated 39/2022, order of status quo was obtained and filed supplementary affidavit today. But this is the order that I have placed before your lordship, 39/2022, and filed supplementary affidavit today. That supplementary affidavit is at page 93. Learned advocate Mr. Nimish Mishra for the surface applicant vehemently objected to refer to the supplementary affidavit filed today and shouted in court in bad manner for referring to the supplementary affidavit. Now, the supplementary affidavit was not filed on 30/11/2023 itself. The learned judge remarks about the manners of the learned advocate Mr. Nimish Mishra is contemptuous and cost of 1 lakh is imposed upon surface applicant, which shall be paid within 7 days from the before the registrar of this tribunal. Interim order passed on 39/2022 is vacated. This is where I am. But the interim order which I was enjoying, but that was continuing. But the interveners, they take out a supplementary affidavit on 30th on the basis of maybe Mr. Mishra might have his submission might have been appearing to be contemptuous to the judge.
That's your case.
Yes. Therefore, as of today, I say, that first of all, this 1 lakh that has been imposed, that is too harsh.
That is rightly.
We do not know,
This it will be enhanced.
1 lakh, that was enhanced on that day, by remarking, it is imposed on the surface applicant. I was not there. Kindly see, the learned judge says the manners of the learned advocate, Mr. Nimish Mishra, is contemptuous. And the cost, in what manner, it is a contempt on the court. A lawyer has been briefed, to object. All that Mr. Mishra has said on that day was that today a supplementary affidavit is being filed. Allow me to use an affidavit, counter affidavit to that.
Do you really think he said only this?
My lord?
Do you really think he said only this?
But in the recalling application,
Manner that you are submitting?
but I was not there, I was not there. But I am submitting on the basis of instruction. But let us assume, whatever it might have been, it did not go well before the judge. But the interim order could not have been vacated by the learned judge as a retaliatory measure, because that reflects on a particular applicant.
Let us hear. Yes.
My lord, my learned senior friend has referred to the order dated 30th November 2023 by which the interim order was vacated. My lord, I am the learned advocate Shauritra Ganguly, whose name is appearing in the order. The supplementary affidavit, my lord, on which stress has been heavily laid, was not pressed at the time of hearing. The moment it was placed on that date, my lord, it was not pressed and no reliance was placed on that affidavit. My lord, this is one part of my argument. Now, my lord, primarily, my learned senior friend has to cross the hurdle. How is this application maintainable?
Judgment.
My lord, I will produce the latest judgment. I'm aware of Whirlpool, L. Chandra Kumar, Otin Arora of this honorable, Whirlpool and L. Chandra Kumar of High Court, Supreme Court, and Otin Kumar Arora of this honorable High Court. My lord, the latest judgment, Supreme Court, my lord, passed in the case of Naveen Philip Matthew. My lord, I'm carrying, I'll place that judgment. Your lordship will give me 5 minutes, my lord, I'll place that judgment. My lord, clears the field on this premise, my lord. Now, my lord, what has happened in this matter, my lord? My learned friend's client, the SURFACE applicant, my lord, files a section 17 application being aggrieved by steps and measures issued under notice 13.2 and 13.4.
Not on merits at all.
No, my lord, no, my lord, I tell you, lordship, what has happened, my lord? What has happened, my lord? How my learned friend's client is doing forum shopping one after the other, and at all he is entitled to any equitable relief from your lordship. Now, my lord, pursuant thereto, my lord, what happened is the property was put in auction and the property was sold. I represent the auction purchasers. I file an application to be added as a party. Now it is no longer res integra. Division bench of this honorable court has decided this fact that once a property is sold, auction purchaser is required to be added as a party. The Learned Debt Recovery Tribunal passes an order directing the SURFACE applicant to implead me as a party. That order was carried in appeal before the Debt Recovery Appellate Tribunal. Debt Recovery Appellate Tribunal, my lord, for non-compliance of section 18.2, that is the requirement pre-deposit appeal fee requirement, dismissed the appeal. Now, my lord, they carry that order before this honorable court in a revisional jurisdiction. My lord, that writ jurisdiction, my lord. This is the order, my lord, the writ is dismissed. Have a copy of the order, my lord. The writ petition is dismissed. Now, my lord, this is the order passed by my lord Justice Bhattacharjee. My lord, this is a recent order, my lord, a couple of days back, 15th January.
On merits of the
On the merits on the whether deposit is required on an appeal or
Now,
not.
my lord, they have taken this plea in the revisional application. They have taken this plea. Averments are there. Now, my lord, how is this?
is not being dealt with now, sir.
Now, my lord.
I propose to extend the interim order for a limited period till the learned.
Now, my lord, then kindly comes to one page.
Bench joins.
My lord, kindly comes to one page. My learned friend has referred to 30th November order, my lord. Kindly comes to the next order. How is this application maintainable? They do not prefer an appeal.
This is not an appealable order.
My lord, kindly sees, my lord, what they do. My lord, after this order, the order which has been placed or impugned in this revisional application, they file a recalling application. Now, my lord, kindly, when your lordship takes up this order, the subsequent order, my lord will refer to page 71 of this revisional application. Page 71. This is the revisional, this is the recalling application. My lord. Kindly sees, my lord, what they do. They file a recalling application. Now, my lord, they avail their remedy before the Debt Recovery Tribunal to recall the order. Now, my lord, kindly comes to page 78. What are the prayers in the recalling application? What was the subject matter of adjudication before the Debt Recovery Tribunal, which is a principal civil court? Now, my lord, kindly comes to page 77. The prayer starts, my lord. I'm not going into the averments. Now, my lord, kindly sees the first prayer is to recall the order dated. This is exactly what is being sought for before your lordship. The second prayer is status quo recorded in the order dated 39. Exactly the prayer sought for before your lordship. The third prayer, allow the applicant to issue respectfully submission and they tender an unconditional apology for their erratic behavior on the date when the interim order was vacated. In this application, I can show the pleadings also. Now, my lord, kindly comes to the order dated 13 December.
That page?
My lord, that is the last page. My lord, the order impugned is 30th November. The last page of the revisional application, second last page, my lord. The order starts from the second last page. Now, my lord, what they do is, kindly sees, my lord. Learned Counsel N. Mishra, G. Singh, Learned Counsel Somrat Mukherjee, Learned Counsel Shodhitra Ganguly, Learned Counsel for the applicant files an interim application. This is the interim application for recalling the order dated 30/11/2023, which is impugned before your lordship. And subsequently submitted with the order dated 30/11 interim order was vacated, which was passed on 39. Learned advocate for the respondent F1 filing supplementary affidavit clarified amount received by demand draft. Learned advocate for the respondent bank wants to file objection, and eventually this matter has been reserved for orders. Now, my lord, what they have argued before the learned debt recovery tribunal, which is reserved for orders, a revisional application is preferred before your lordship. By bypassing, had it been an order bereft of jurisdiction, that is the only plea my learned senior friend can take, placing reliance on Whirlpool and L. Chandrakumar. That it is bereft of jurisdiction, accordingly a revision is maintainable. But when they have availed the alternate remedy, how is a revisional application at all maintainable, and how at all they are entitled to any relief, far less the equitable relief from your lordship?
You have to wait for this order. I am afraid after this order, I don't think I'll be
But
passed.
I'll answer, my lord, my learned friend. I'll answer my, let him finish.
No, my lord.
I'm not on merits, actually. I'm on the, now
Look,
that
I
he's
will.
wanted this house.
My lord, if your lordship hears me out for a moment, my lord, the law is settled now, my lord, by the Honorable Apex Court in the case. If your lordship directs me,
Just hear his response.
my lord. Only one judgment, my lordship.
Order.
Yes. Yes.
How the learned judge has gone wrong is, my lord, that, my lord, he has vacated the interim order, which was, my lord, I obtained, my lord.
But you have asked for recalling of that order and the judgment is reserved.
Now, my lord, I'll
Let
tell
the
your
learned
lordship.
judge take a decision first.
Now, my lord, till he takes a decision, my lord, I am remediless. I am without any protection. My lord, that is why I am before your lordship. Kindly, my lord, come to, my lord, the order which my learned friend.
I'll spend further time on more time on this.
Lord, will kindly, my lord, yes, spare, my lord, a minute to me, my lord.
Make any observation which goes against any of the parties, I'll just
Lordship.
send it to the regular bench.
But then
Otherwise,
kindly,
you
my lord,
record all these submissions,
kindly direct him.
Tenure to your benefit. in
But
the-
may not be, my lord. But kindly direct so that, my lord, they do not, my lord, create any embargo, my lord, in the property, my lord.
Nothing, because it is pending. I cannot intervene at this stage.
Then, my lord, your lordship will direct, my lord, the tribunal to dispose of, my lord, my application within a particular period, my lord.
It has been
Well, reserved for orders.
The orders
No,
are
no, 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 no.
Reserved for orders.
It is reserved for orders, but, my lord, that is on, my lord, that is, my lord, in December.
I cannot direct the tribunal to pass an order.
Lord,
Matter be placed before regular bench. I'm sorry, Mr. Mukerji. No.
Grateful, my lord. With your lordship's kind leave.
Next.
I'm grateful, my lord.
Grateful.
Maybe. The petitioner before lawsuit. The first landlord filed his suit for eviction in the year 2006. And that suit was withdrawn.
That's what was?
Was withdrawn. Leave to file a fresh suit. Now he has filed a fresh suit. But that on the ground there is 2G that will apply. Then in between that the suit was withdrawn. My client must send the rent by money order. Since he did not receive, that was returned back. He deposited the rent in the initially rent controller manner, and that proceeding is going on. Now the fresh suit has been filed, the present suit. The fresh suit moment on this is the summon. He entered and filed an application 7172, and that 7172 that has been dismissed, and against that I have come. But that is the impugned order, kindly see. But 7172, my lord, that is start from 54. But city started to deposit the rent to the rent controller. That is the file and application. But 55, it is therefore praised that your honor may decide to be pleased to permit the defendant petitioner to deposit the area rent since the month of December 2021 to January 2023, that 14 months, such and such, total such along with the interest. Then 72. Both the application has been rejected. But kindly see that impugned order, 18th October 2023. Yes, sir. But he has discussed everything, my lord. Now, my lord, kindly see third paragraph. The defendant has filed a petition on 24th February 2020 under section 7. That was within time, my lord. 71A of the state stating that suit has been falsely filed, such as defendant has paid for permission to deposit the area rent for the month of December 2021 to January 2020 together with statutory interest. Defendant has further filed an application 71C of the Act paying for permission to deposit the rent for the current month, and thereafter both the parties have heard at length. The defendant to Sivdat Mondol has further filed petition on 20 such and such under section 7.2 of the Act, stating therein the defendant received summons of this people as litigation. He has submitted he is the tenant in respect to the sub-room. Denying the allegation he is a defaulter. It has been stated that the plaintiffs earlier filed a suit for eviction against defendant being jailed by such and such. in which the petitioner filed petition under 7172 of the Act. It is stated that said petition was allowed by the learned preceding small court and the defendant too had paid rent to the plaintiff in dispute that his tenant subroom. It is stated that subsequently suit was transferred at the prayer of the plaintiff. The submitted defendant should be allowed and permitted to deposit the area rent in accordance with law since he is a tenant in his premises. 7.2, the petition under 7.2 has also been heard at length. The defendant to file written statement on 4th July 2023, wherein he has taken plea that he is a tenant and there has been no termination of tenancy. The plaintiff opposed the petition filed by the defendant and learned advocate for the plaintiff argued that he is a suit for eviction of an unlawful occupier under the provision of section 2G of the Act, for the which the petitioner under section 7. Yeah, that is on the ground.
What is your urgency? The regular bench can issue.
29, that date hasn't fixed. So, what I am saying, I am dealing with the judgment of this uncle. The 7.2G should be disposed of first. That should be disposed of. When I am reading the judgment, my lord. So, our High Court judgment.
The regular bench is coming back before the 29th of January.
29th, my lord. But 23rd, 26th is the holiday. It will be very difficult. For that reason, I mentioned. It's very urgent, my lord. Otherwise, my lord, but it is 7172 goes, my lord. Your losses, no, sorry.
Issues are framed, it can be dealt with after that. You are aware, sir.
But I know, my lord, but for some protection, otherwise it will be very difficult.
The matter will be placed before the regular bench. In this case, no protection. You are aware of this. Next.
In this matter, Lordships, I am appearing for the respondents.
For the petition.
Lordships, at my instance, probably the matter has come. The urgency is because as an unauthorized occupant, the plaintiff has filed a declaratory suit, 2017. Lordships, the property is mine, the defendant's property, and he is trying to establish his rights over my property. Defendant number 1 and 2, Lordships, the husband and wife, because the defendant number 1, Lordships, last year, 11 February, Lordships died, substituted in the trial court and High Court also. Lordships, and I have filed a counterclaim along with the written statement. My counterclaim is decree for evictions of the plaintiff from my positions, from my property. So, Lordships, I am the Lordships, after the death of my husband, Lordships, I'm the feeble and aged lady, Lordships, but my son and daughter, Lordships, residing outside. So, plaintiff is my brother-in-law, Lordships, and I raised some time, Lordships, when he was young. And now, Lordships is unauthorized because it's my property, then rooftop. Lordships, he is occupied forcefully. And
proceeding before the
Lordships, the suit, Lordships, why I'm calm? Because it is suit, yes, proceeding, but at the last stage, at the argument stage, is a contrary to the law, Lordships, order 16.
direction not to deliver judgment till
Lordships, not to deliver judgment, but Lordships kindly see, so since 2022, the argument has been fixed. Lordships,
February 2023.
Lordships, the interim order, Lordships, expire February. Then he reimposed.
Disposal, yes.
No, reimposed again the interim order. Lordships, Lordships, because Lordship, my prayer is because trying all sort of troubles to me. Lordships, not vacating, Lordships, kindly hear and pass the order. Disposal of the revisional application, Lordships. Lordships, urgency, Lordships, because you, Lordships, kindly fix the date. Because otherwise, Lordships, the 9th January.
It's a date before the regular bench.
Lordships, the regular bench, Lordships already fixed the date, 9 January.
But arguments are over?
Lordships, no, argument, Lordships, kindly see, because Justice Shampar Sarkar, Lordships, kindly, Lordships, relevancy, yes, fix the date, 9 January, and urgent motion. Lordships, kindly fix the date. Urgent motion, Lordships.
Regular bench.
Regular bench.
Let's fix a date in the regular.
Otherwise, Lordship, the matter will not come. And 2022, justice delayed, justice denied. Lordship, next date, any date, Lordship, urgent. Urgent, without urgent date, Lordship, because Lordships, because they are Lordships adopting the dialogue. আরে ডেট যদি না দেয় কি করবো? বুঝেছিস এখনো দেবে
Fix a date before another bench.
another, because these courts of the regular bench Lords already fixed the date 9 January.
Sir, I cannot fix a date before the regular bench.
Lordships considering the matter, because the justice, Lordships, when Lordships, maybe Lordship the coordinate bench, but Lordships, when Lordships I am praying the justice, Lordships, kindly you may extend your hands also.
Lordship, I'm paying for this adjournment. Today, learned senior couldn't able to come.
The matter be placed before the regular bench. Order of joint learned counsel for the petitioner seeks accommodation. Yes, next.
My lord, I just extended. I beg to appear for the petitioner, my lord. Now the matter when it was last taken on 31st July, my lord Justice Shorkar was pleased to direct to pay rupees 2 lakh rupees to the opposite party wife, my lord. My lord, and to serve a copy upon them, my lord. We have served the copy upon them, my lord. And in the meantime, also, my lord, we have prepared the demand draft. We went to the house of the opposite party as well as the advocate representing opposite party in the lower court, but they denied to accept it. I'm carrying the demand draft, my lord. My lord, in that regard,
Have you served?
I have served, my lord, but unfortunately, it's showing dispatch, but it has been received, my lord, but I don't have the copy of it.
Yeah, to be served. Why don't you come up with an affidavit stating what you're saying, what you're submitting?
My lord, then if my lord kindly direct me, then I will do. I shall do that.
This is oral submission doesn't hold.
My lord, my lord, kindly, my lord, direct the same. I shall do that.
File an affidavit before the bench.
My lord, I shall do it.
Saying that she has refused.
My lord, I shall do it, my lord.
Otherwise, it's your line.
My lord, definitely, my lord. That's why I was carrying the demand draft to show my bona fide that I have made it.
Service. Service. Not served. So take this back.
My lord, but actually, my lord, when it was served in the month of August, my lord, it has been served later on. But the rule of the track report is that after a month, we do not get the track report.
So it is the matter is.
Kindly direct that I shall give an affidavit in that regard regarding the refusal.
It is your call.
If my lord,
You submit.
my lord.
It is your call. Do that.
I'm for the petition.
Lord, I beg to appear, my lord, for the opposite party in this matter.
My lord, my urgency in this matter today only. There was a award challenged by the parties up to Supreme. Done. Now it has gone to execution. In the execution, we are government company. Other side is a private company, and there are certain issues. I don't want to go. For today, what I want to say is, in a execution, I filed an application. I say that it is a equitable set-off. I am a government company. I am supposed to get some money from you under certain degrees, and he is supposed to get money under a degree. So there is a concept of equitable set-off. Now, when the concept of equitable set-off I filed, the lower court rejected my application. And the entire principal amount of the amount has been handed over to the award holder. Now only the interest portion is there. Court has passed an order already that result of that payment is subject to result of this. Lower court has also passed, high court has also passed. I have approached to the lower court that see, court is in session. Court said the main money is subject to, so you cannot disburse the interest, delayed payment interest. That is also around 1 crore. On 8th, court said there is no stay, I will proceed. Now kindly see, court said that bank should deduct the money, come with the bank draft. Now if the bank draft is again handed over to them, Lordship, then Lordship, from a government exchequer, the entire money will be. I am not taking your Lordship to the merit of the case.
Now, Lordship, at best, court can say deposit this money with the registry of the court. I will deposit this same money with the registry of the court, subject to result of this revisional application. That will be in an interest-bearing account. That's usually is done. Court has taken note that the case is there. I mentioned, and that's the reason why I personally came before your Lordship and I mentioned. I am not saying that they are entitled or they are not entitled. It may happen that they are entitled. But Lordship, if this is done, then the execution is satisfied. They will go to their home. So I am saying this money should be
Recorded that this will be subject to decision of the.
no Lordship.
So even if this is disbursed.
No,
it'll
this
be-
is second disbursement. First disbursement is subject to.
It is subject to decision of this revision.
Lordship, then if this disbursement is again subject to, then Lordship, I am not holding anything. Means he has taken away the money. I win or I will lose. They are gone because they are private company. Lordship,
You are
see,
holding the main thing, the revisional application. Nothing is more important than that.
Lordship, kindly appreciate.
This court will.
No, kindly appreciate this, Lordship. What I'm saying is, instead of, see, I'm a government company. I cannot go away with the money. I'm a 100% owned government company.
It's the fact that there is no stay.
No, because in the earlier order,
The same arguments were made on the same self cause of action. The interim order was refused.
Lordship, kindly see. What I'm saying, interim order is not refused. Kindly look into that. Court said we need to consider this matter at length.
But the bottom line is there is no interim order. That's the bottom line.
I understand. Now, Lordship, my matter is still in motion state. 24, because next working,
Is under challenge.
they can challenge my maintainability. There is no issue. Revisional maintainability, they can always challenge to oppose me. But then, Lordship, kindly see. In this matter, if the fund goes out from the government covered, I won't be able to recover. Because that goes to the company to directors and shareholders and goes up. Then I won't be, because even if I hold contempt, anything is against the company because it's a suit. Company is in liquidation. That is already in the NCLT. I have annexed the order.
But this is the properly, my learned senior friend is not properly instructed. Lord.
That's true. That's true.
That is
Now, Lordship, kindly take some.
that is not the correct submission that is coming. I
know,
think
I
Lord,
know,
he
I
needs to take more instruction on this.
I know. Lordship, kindly turn to page 81 of
If
my
he
application.
knows, Lord, then there's no point making this submission.
81.
Kindly 81
81 kishe?
of my application, Lordship.
Yes.
80, 81, 82, any page, Lordship. Lordship, kindly see, I have given the company is in NCLT. I am not saying something from statement from the bar.
But in NCLT and in liquidation, there is a hell and heaven difference.
No, I am not much aware of the company laws as my learned friend. Lordship, let's not, what I'm saying is,
and this application has been dismissed.
that's all right.
Lord, that is not all right.
So
There's
this
a
is,
difference.
this is,
Lord, if my learned senior submission is that,
I don't know, that
he
is not
doesn't
on
know
record.
the company law, then he should
sir,
not make
he
the
should have
submission.
come up. That is, should have not come. What I am only trying to say.
There is a limit of
No,
making
Lordship,
submission.
this is, no, this is the last order I have.
He says that he doesn't know anything about company law. He should not bring this notice to
Because
your,
he
to your
should have,
lordship.
Lordship, this is the stage up till when I filed the
This
case, this was the
application
stage.
has been dismissed.
So that, fine, then you should produce that order.
So then this application suffers from suppression. No, I'm led by Mr. Chatterjee.
This application has been dismissed.
Yes.
All right. So, Lordship,
This application
kindly
is
see the
dismissed.
conduct of that company.
Because it is at 422. Yes.
So, Lordship, what I am saying is, if your Lordship kindly looks into the first impugned order, kindly see the impugned order.
I have a preliminary point.
Since there is no stay of the first order, the principal amount, this court will not stay the interest.
Grateful to you. I am also not saying,
Yet abide by the result of the.
then Lordship can record that order, but then.
But even abiding by, blood, there was no order on it because they prayed for. They prayed for it. It was refused. And moreover, there was no urgency, my lord, at all, because this matter was heard by Justice Day, and thereafter, my lord, no steps were taken.
On 10th May 2023. This
Huh.
is an order of 8th January 2023.
Yes, my lord. But that order is not on challenge before your lordship.
This is
8th January is not on the challenge. before your
This is subsequent to my revision.
So that
Lordship,
needs to
kindly
be
see.
challenged. Can't be so moto.
Lordship, this is, the court is proceeding. I said the pray. My prayer of the interim prayer has not been rejected even today. Lordship, kindly see. Kindly see, I am.
Application pertains to the earlier order.
Yes. Now it is now, since either the court has to say.
Order dated 11th November 2022.
Yes, my
Lordship.
lord. That's the revision application. This is not the subject matter of my lord's revision application.
Lordship, kind.
Supplementary affidavit annexing this.
No, that needs to be challenged, my lord. It's up to him.
24th, please, Lordship, kindly see, 24th is the date.
Yes.
Then Lordship,
You should have submitted this in court earlier in that case.
Lordship is a,
This is
Lordship,
subsequent event, I understand, but then you should have been brought before the court.
Lordship, kindly see, government, I know what Lordship is saying. Well, my learned friend has taken a technical point and
What I am saying, you are aware of the laws.
Lordship, if I am,
There's a regular bench.
Lordship, kindly,
Come back with a.
no, Lordship, then kindly protect me. May I suggest one thing?
On what basis?
Lordship, the order has been passed. The order is there before your Lordship.
It's not for this court at all. You are aware of what you're submitting, sir. Please. remember. Next one.
As your Lordship. Then Lordship, kindly pass a single line order to that effect so that I can make a request to that court.
On an application which is not on record at all?
Not for this order. Lordship, kindly see that I am on an urgent basis.
Still before that?
What I'm saying is, my main application is there.
Yes.
My prayer for stay of the execution proceedings is there.
An order has been passed to that effect.
That has not refused my application. Lordship, kindly kindly see.
Passed will be contrary to that order.
As your Lordship.
No. Next one.
Then Lordship, kindly pass an order that it should be taken up by the regular bench so that I can say that I tried it before. So till the legal.
Beneficial for all of us.
To that we agree.
Yes.
So Lordship, kindly pass that order to that. By passing an order so that at least I can say to the court below.
One-liner, sir.
I'm sorry. I'm sorry.
Grateful for that.
Obliged.
26 and 27, same.
Yes, yes.
Next.
My lord, I have to petition my lord. My lord, only consideration before this, my lord, in this matter, after transferring of the entire share of the property, my lord, that is the that is the Shyama Prasad Dasgupta. My lord, after death of his father, Vijay, Shyama is was inherited in respect of 1/4 share. My lord, kindly turn to for a moment, very short matter. Very short matter.
Hearing matter.
Page 50 onwards. Page 51. Shyama Prasad Dasgupta transferred all his interest in respect of undivided property led by Vijay Prasad.
Yes.
My lord, he transferred the entire property, entire interest, all his entire interest transferred in favor of the former defendant, Devi Prasad Dasgupta.
Yes.
Now, after transferring all his right to the interest in respect of undivided share after death of his father, Vijay, Shyama Prasad cannot have any right over the property. The registered deed, it was executed in the year 2017.
Yes.
Now, other co-sharer, that is the Gayatri Rai Chaudhuri, they filed a suit for declaration injunction. Trial court restrained the opposite party number 1 from disturbing the peaceful position of the plaintiff in respect of the common area, regularly creating disturbances by the opposite party number 1, that is the urgency. He cannot do that.
There is already an order of injunction.
That has been set aside by the first appellate court, the court of appeal below. But by short submission, ad interim order injunction application is pending before the learned court below.
appeal court set aside the order. Trial court may be directed to hear of the injunction application within a fixed period without being influenced by any of the observation made by the first appellate court. Because the opposite party number one, after transferring the property, cannot have any right over the property. He transferred his entire interest in favor of the other co-sharers.
Yes. Now, we'll kindly see this order passed by the learned trial.
By the
Learned trial judge. Kindly see. Now, we'll kindly see after the word ordered. The prayer of the defendant is hereby considered and allowed on contest with a cost of ₹100 to the plaintiff, and it is beyond is filed beyond the statutory period. Then later, now the record is taking up for hearing of the injunction application heard the learned advocate of the plaintiff, that is my learned senior friend's client. Fixed 16th May 2024 for payment of further hearing of the injunction application from the plaintiff side. Now, Millard, this is refusal to pass ad interim. My learned friend himself has started arguing the main injunction application. He is now still pressing Millard the revisional application from an ad interim order, refusal to pass ad interim order of injunction. He is the plaintiff.
Is a কোন suit?
A suit 551.
551 ad interim was passed on 5th December 2022.
Yes, thereafter, this is the recent order.
has been taken up for hearing and you are.
He is the plaintiff. Virtually, he has gone.
Kindly, my lord, direct the learned trial court to dispose of the injunction application with a further fixed date.
Sir, the hearing is proceeding and you are making your submissions there.
My lord.
Have you seen this order?
No, I'm not. I'm not. My lord, kindly direct the trial court, my lord. So dispose the injunction application with further fixed date.
Why the trial court has taken up the matter.
And fixed a specific date for hearing of the. On that date, we will conclude our hearing.
Well, the matter is pending before this honorable court 9 January, which was filed in 2023.
And Millard, this matter
is pending against the misappeal.
Misappeal disposed of.
Application is taken up for hearing.
Well, kindly direct that trial court.
Sir, no need for action. A specific date has been.
Well, without being influenced. Well, only I am
what is
very modest submission without being influenced by any of the observation of the first appellate court.
The matter placed before the regular bench.
Well, kindly dispose the matters. Dispose of the matter.
Well, this was filed in January 2023. My learned senior friend did not take any steps to move this application ever. Now in the urgent determination. Grateful.
Lordship.